Then mirror for tomorrow, mirror. Family matter, mirror.
Adjournments. Adjournments, page 5. Page 1, seal number 1. Page 2, seal number 2 to 4. Page 3, seal number 5 to 8. Page 4, seal number 9 to 10, 9 and 10. Page 5, seal number 11 to 14. Page 6, seal number 15 and 16. Page 7, seal number 17 to 21. Page 8, seal number 22 to 24. Page 9, seal number 25 to 29. Page 10, seal number 30 to 37. Page 11, seal number 38 to 44. Page 12, seal number 45 to 49. Page 13, seal number 50 to 53.
My lord, seal number 51, my lord.
Serial number
51.
50. Or other
Name the
side.
50 na.
Okay, 50 family court. My lord.
RB submission.
You are for
Petition.
appellant. As requested by the appellant's counsel. List on again YO 1 of 2020 in the pending. Inform the other side. Madivira.
Last one. 24. 24 to
25.
My lord, seal number 51.
Serial number 51.
51, my
Who do
lord.
you represent here?
I affairs for the appellant in the connected matter.
One more connected matter, my lord, for the appellant.
But somebody has moved this matter. Who has
Moved the matter, my lord.
I have
One
not
more
moved.
matter. Both are connected. Insurance company claim petition.
correct? Other than these two, there is one more matter. Other than these two, there is one more matter. So our time ಕೇಳ್ತಾರೆ second set ಕೊಡ್ಬೇಕು ಯಾರು?
Second set was not furnished by the insurance company.
I will file second set, my lord. 2 weeks time may be given.
That is recently connected.
How's
51.1 ನಲ್ಲಿ
2 weeks.
it is finally 2 weeks time is granted to
Much
file second set, failing which the appeal shall stand dismissed.
Very
This
hard.
one, 2 weeks of-
My lord, that rider may
27. 27 to.
my lord, that rider may kindly be there. I will do it. Even if I'm saying I will do it, but that
You ಮಾಡಿ, no, if you are confident that you are doing, then why are you coming in the way of the order? Yes.
kindly.
Page 14. Till number 54 to 56.
56, my lords. I represent the appellant, my lords, may request 10 days time in this matter, my lords.
56 appellant.
Please, I have informed the respondent.
Of the appellant's counsel. Yes.
Page 15, seal number 57.
ಎಲ್ಲರೂ ಸೇರಿ ಒಂದು ಚಾರ್ಟ್ ಪಾಟ್ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ವಲ್ಲ.
ಅದಕ್ಕೋಸ್ಕರ.
Seal number 57 to 59.
59 ಅಲ್ಲ ಅಷ್ಟೇ.
ಯಾವುದು?
Yes.
Page 16, seal number 60.
Which matter?
46, my lord, serial number.
60.
In 2 weeks time may be granted, my lords. I have informed the respondent, my lords.
You, whom do you represent?
My lords, I represent appellant, my lords.
Send at the request of the appellant's counsel. Date ಕೊಡೋದಿಲ್ಲ.
Obliged.
46. Orders, seal number 1, L. Shrikant Rao, H. Pawan Chandra Shetty, A. Prasanna Shetty.
After taking no objection from the,
Appearing for the respondent.
Sir, the voice clear ಇಲ್ಲ.
I have filed wakalat subsequently after retirement the other judge, other advocate. I seek 2 weeks time.
2 weeks.
To
Only
file
to
second
file second set.
How soon? Okay. ಅದು ಪೇಪರ್ಸ್ ಬಂದಿಲ್ಲ ನನಗೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲು.
There are 1.2 early. You have to submit in the connected matters.
A week's time.
2 ಮ್ಯಾಟರ್ಸ್ ಅಲ್ಲಿ ನಾನು ಹಾಕ್ಬೇಕು, ಅವ್ರು 2 ಮ್ಯಾಟರ್ಸ್ ಅವ್ರು ಹಾಕ್ಬೇಕು.
ಎಲ್ಲಾನು ಒಟ್ಟಿಗೆ ತಗೊಂಡ್ಬಿಡ್ತಾರೆ all. But request 10 days time is granted to do the needful. 1.4 ವರೆಗೂ.
I'll do it.
You are granting 10 days time ಅಷ್ಟ್ರಲ್ಲಿ ಮಾಡಿ. You do want 2 weeks time?
ಮಾಡ್ತೀನಿ.
1 week, my lordship.
ಇಬ್ಬರಿಗೂ 2 weeks ಅಂದ್ರೆ 2 weeks ಆಗುತ್ತೆ. Yes,
Obliged,
number-
my lordship.
Seal number 2, N Krishnaswamy, Bhanuprakash HV.
I am for appellant, ಇದು connected matter.
No, IAS are not furnished.
ಅದರಲ್ಲಿ
Krishnaswamy,
I gave
who
now.
has filed these IAS?
R5
Pending. ಅದೇ IA copies ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇದೆ.
ಇವಾಗ ಕೊಟ್ಟೆ ಮೇಲೆ. Just to furnish.
Who's R5?
Applications are filed by whom?
Process fee ಕೊಟ್ಟಿಲ್ಲ.
process fee is a owner, is not necessary, ಇದು ಡ್ರೈವರ್ is not necessary party. ಯಾಕೆ ಕೊಡ್ತಾ ಇದಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ತದೆ.
ಅಲ್ಲ ಇವ್ರು ಅಪೆಲೆಂಟ್ ಹಾಕಿದ್ದಾರೆ ಅಪ್ಲಿಕೇಶನ್.
ಈಸ್ ಎ ಡ್ರೈವರ್, ಪ್ರಕಾಶ್ ಈಸ್ ಎ ಡ್ರೈವರ್.
ಚೆಕ್ ಮಾಡ್ತೀನಿ ಮೇಲೆ. ಚೆಕ್ ಮಾಡಿ ಅದೇನಿದೆಯೋ ಸ್ಟೆಪ್ಸ್
These applications are filed by the plaintiff. At request
Relax.
finally, 1 week time is granted to do the needful, failing which IA 1 to 3 of 23 shall stand dismissed. If he is only a driver, why do you want to take notice against him? Illards ಅಂತ ಹೇಳ್ತಾರೆ. Illards of
ಅದಕ್ಕೆ
R5.
necessary ಸ್ಟೆಪ್ಸ್ ತಗೊಂತೀನಿ ಮೇಲೆ. ಆದ್ರೆ
ಇಲ್ಲಿ ನೋಡ್ಕೊಂಡ್ ಬರ್ಬೇಕು. ನೀವು
ನೋಡ್ಕೊಂಡು
ಇಲ್ಲೇ ಓಪನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
Who is R5? R5 is, he was respond number 2 before the tribunal.
ಅಲ್ಲಿ R5 ಅವರು
ಆಗ್ಲೇ ಅಪ್ಡೇಟ್ ಆಗಿ ಹೋಗಿದೆ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2 ಇಲ್ಲ ಓನರ್ ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ರವಿಕುಮಾರ್ ಓನರ್.
ರವಿಕುಮಾರ್ ಓನರ್, KV ಪ್ರಕಾಶ್.
No, they want to bring his LRs on record. ರವಿಕುಮಾರ್ ಅನ್ನೋರ್ದು. Failing which?
ಪ್ರಕಾಶ್, ರವಿಕುಮಾರ್ ಅಲ್ಲ, ಪ್ರಕಾಶ್.
ಅಲ್ಲಲ್ಲ ಅವ್ರು ಎಲ್ಲಾರ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿರೋದು ಟು ಬ್ರಿಂಗ್ ದ LRs ಆಫ್ R5 ಅಂತ ಬರ್ತಾರೆ. R5 is on record. ಇವ್ರು ಡ್ರೈವರ್ ಅಂತ ಹೇಳಿದ್ರು. No, he is not the driver.
ಅದರಲ್ಲಿ ಎರಡು ಅಪೀಲ್, ನನ್ನ ಅಪೀಲ್ ಅಲ್ಲಿ ಅವ್ರು R1 ಇದಾರೆ, ಅವ್ರ ಅಪೀಲ್ R5 ಆಗ್ತದೆ.
ನಂದ್ರಲ್ಲಿ
ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಫೈಡ್ ಅಪೀಲ್ R5 ಅವರು.
ಹಾ ಸರಿ ಆಯ್ತು. Yeah, right. Application maybe not.
R5 ಮೇಲೆ.
Who's R5?
ಡ್ರೈವರ್.
Just ಪ್ರಕಾಶ್ ಅಂತಾನೆ ಇದೆ ಎಲ್ಲಾರ ಅಪ್ಲಿಕೇಶನ್. ವೈಫ್ ಆಫ್ ಡಿಸ್ಮಿಸ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ, ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಪೀಲ್ ಅಬೇಟ್ ಆಗುತ್ತೆ. ಫೈನಲಿ ದಿಸ್ failing which the concern shall stand dismissed.
ನಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ R2 ಇವ್ರು ಇದಾರೆ, ರವಿಕುಮಾರ್ ಆಲ್ರೆಡಿ ಸರ್ವ್ಡ್, ಇವರು ಕಾಪಿ ಇದೆ, ಅನದರ್ ಅಪೀಲ್ ಸರ್ವ್ ಆಗಿದೆ.
ನಿಮ್ಮ ಅಪೀಲ್ ಅಲ್ಲಿ ಎಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದ್ದು ತೋರಿಸಿಲ್ವಲ್ಲ. R1 ಅಬೇಟೆಡ್ ಅಂತ ಆಗಿದೆ ನಿಮ್ದ್ರಲ್ಲಿ.
ಓನರ್ ಡ್ರೈವರ್
R2 is not yet served.
ಲವಕುಮಾರ್ ಅಂತ ಇದು ವಕಾಲತ್ ಹಾಕಿದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಡೈರೆಕ್ಟ್.
ಕರೆಕ್ಟ್, ನಾವು ಅವ್ರಿಗೆ ಹೇಗೆ ಹೇಳಕ್ ಆಗುತ್ತೆ ಅವ್ರು ಹಾಕಿಲ್ಲ ಅಂದ್ರೆ? ನೀವು ಕರ್ಕೊಂಡ್ ಬಂದ್ ಅವ್ರ he is not even present here. Request finally. ಎರಡರಲ್ಲೂ 10 days ಮಾಡ್ಕೊಂಡ್ವಿ. 10 days time is granted to people. Failing which appeal against R2 shall stand dismissed. Yes.
ನಾನು ಕೊಡ್ತೀನಿ ಫ್ರೀ ಆಗಿ.
Cell number 3, Ramesh KR, SV Hegde Mulkam, P Shankar Reddy.
Needful done by. Appeared.
ನಾನು consider that.
And also my lord, one more connected matter, my lord, the insurance company
Second
also.
ಕೊಟ್ಟಿದೀವಿ ಅಂತಾರಲ್ಲ.
Free of paid.
ಸೆಕೆಂಡ್ ಟೈಮ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
Second time.
ಯಾವತ್ತು?
ಇವಾಗ morning.
Needful is done today. Registration will verify if found correct. Issue notice to respond number 1. Yes.
So my lord connected with the MFM number 9726 of 18, insurance company appeal.
ಅದರಲ್ಲಿ ಸರ್ವಿಸ್ ಆಗಿದೆ ಅವ್ರಿಗೆ. Issue notice to respond. It is submitted that this matter is connected to MFA number so and so. List both the matters together on 6 weeks.
Okay, 28-3.
28.
Oblige.
Cell number 4, PB Raju, Rangegoda NR.
Here on behalf of Raju, a week's time have been granted to pay process.
Not found ಅಂತ ಬಂದೆ. Who has moved it at request? 10 days time is granted.
My lord, office may be directed to put up the application for withdrawal of amount. My lord, I have filed application for withdrawal.
10 days time is granted to do the needful and permanent. Now counsel for respond number 1 to 3 submits that he has filed an application
For withdrawal of amount.
seeking withdrawal of the amount and deposit. Registration verify and do the need. List after 10 days.
Cell number 5,
Appeal for
WS
the
Sympathy, Rangegoda NR.
pay for the appellant, weeks time may be granted to pay process to respond number 1 and 2.
Award amount deposit ಮಾಡಿದ್ದು
Amount deposit ಮಾಡಿ.
deposit ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ದಾರೆ ಟ್ರಯಲ್ ಕೋರ್ಟಲ್ಲಿ ಡೆಪಾಸಿಟ್.
Now counsel respond number 1 submits that the amount is deposited. Therefore, office objection in that regard should comply. Withdrawal again.
The liability is under dispute. The driver was not pulled.
Counsel for the appellant submits that liability of the insurer is under dispute. Therefore, I1 of 2025. Therefore, consideration of I1 of 2025 is deferred for the time being. If needful, 10 days and ಕೊಡ್ತೀರಾ ನೀವು?
I'll have it paid.
Counsel for the appellant submits that he will do the needful in respect of R2 and 3. If needful is done within 10 days, issue notice to response to 2 and 3.
ಡ್ರೈವರ್ ಅಲ್ವಾ?
ಈಗ ಅದರಲ್ಲಿ
There is R1 before the.
owner, the R2 is the owner of the vehicle. R3 is the father of the deceased.
ಹೌದಾ? All right. Correct.
Issue notice to R2 and 3. No, list on
28-3.
28.
So number 6, B Pradeep.
I am for the respondent in this case, my lord.
For the appellant.
ಇದು ಮಾಡಬಾರ್ದು ಅಂತಂದ್ರೆ ನಮ್ಮ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡಿದಾರ. ಅಲ್ಲ ಇದು ಡಿಲೇ ಕಂಡೋನೇಷನ್ ಇದನ್ನ ಸೆಟ್ಟಿಂಗ್ ಸೈಡ್ ಹಾಕೊಂಡಿಲ್ಲ ಅಂತ. ಇದ್ರೊಳಗೆ ಪ್ರೇಯರ್ ಇಲ್ಲ ಅದರಲ್ಲಿ.
During the pendency of the appeal, ಅವರೇ application ಹಾಕ್ತಿದ್ರು. Claimants ಹೊರಟೋಗಿದ್ದಾರೆ ಅಂತ.
ಅವರೇ ಹಾಕೊಂಡು.
Respondent number 1, respondent has died, my lord. His legal representatives are to be added.
ಅಲ್ಲ, this is not an impleading application. 151 ಅಲ್ಲಿ ಹಾಕಿದೀರಾ.
ಅದು ತಪ್ಪಾಗಿದೆ, my lord.
ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ರೆಕ್ಟಿಫೈ ಮಾಡ್ಕೊಳ್ಳಿ.
I am filing. I have correction ಮಾಡ್ತೇನೆ. 1 week time, within a week.
ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ಮ ಅಪೀಲ್ ಅಬೇಟ್ ಆಗುತ್ತೆ ಅಷ್ಟೇ. It is finally 10 days time is granted to cover office objections. Yes, sir.
So number 7, Ananta Krishna Bhatt.
I appear for the appellant, my lord. Second respondent, third time process ಕೊಡಬೇಕು. I will pay by publication by 10 days.
I
For
represent
second
proposed
respondent.
respond.
2 weeks time is granted to do the needful.
Respondent.
Impleading application ಯಾರ್ದು?
I represent the
I
proposed.
have filed application for impleading insurance company, which was as against the owner. Owner alone was impleaded in the trial court because owner had not disclosed the insurance. Now we came to know that that is insurance to that
What
bus.
do you say? He can't
I represent proposed respond.
Yes, proposed respondent, Mr. Shrikant Rao appears.
Proposed R4. He can't. ಏನ್ ಹೇಳ್ತೀರಾ?
Yeah, I represent it. But it's anyhow subject to proof of policy that my liability will be settled. That's why it may be allowed, madam. I have no objection to all that.
Policy, you admit the policy?
ಇಲ್ಲ ಪಾಲಿಸಿ ಇನ್ನ 18 ಪಾಲಿಸಿ ಕನ್ಫರ್ಮ್ ಆಗಿಲ್ಲ ನಮ್ಗೆ. It has to be remanded if I have to give. No, I have to be given an opportunity to file my objections and contest a case on merits.
They have given the policy number, it seems.
ಅದೇ verify 18 ಪಾಲಿಸಿ ಅವ್ರಿಗೆ they are unable to trace it. That's it.
ಅದಕ್ಕೆ ಬರ್ಕೊಳ್ಳಿ. ನಾನು ಕೌನ್ಸಿಲ್
Paper publication, 10 days time, your lordship.
to file counter to I1 of 2024. Appellant's counsel requests time to do the needful in respect of respond number 2. List after 2 weeks.
Much obliged.
Much of-
So number 8, Jagdish Kundappa, Sampath A.
For appellant. R7 is award service.
This matter, my lord, I may be permitted to file an application for release of the amount of 4 lakhs. my lord.
ಮಾಡಿ ಹಾಕೋದು.
And it's in my hand, my lord, lordships may consider and pass.
My lord, questioning that filed by the owner of the vehicle, my lord, is liability in question, my lord. Is a necessary party of the R7, my lord, is.
Who is
This
asking?
matter, lordships may recollect, my lord, earlier, my lord, they kept filing the application.
Service ಆಗಿ ಬರ್ಲಿ ಆಮೇಲೆ ಹೇರೆ ಮಾಡಿ ಡಿಸ್ಪೋಲ್ ಮಾಡ್ಬೋದು ಸ್ವಾಮಿ.
Not a party.
Commendable matter.
Why you have not, you have made him party?
Lord, they were, my lord, he is the owner. We made him as a party, my lord, he did not turn up. He was placed ex parte, and my lord, the ex parte order was passed on 26 lakhs.
In R6 and 7.
Yeah, the respondent was one Setu.
Please, my lord, he is the sole, who is the appellant, my lord.
Of the vehicle, my lord.
This,
My lord, he wants to implement some more persons to say, my lord, this was a mistake on the impleading applicants, not me, my lord. That is what he wants to contend.
leading applicants.
Please, my lord, he filed 3 applications or some 2 applications to implement some more persons.
That is appellant has filed.
That amount, my lord, is 7, my lord, is satisfied the award.
One
Where
of the-
filing the eight-
You had content, you had not appeared before the tribunal.
No, my lord, they were not even a party.
Expertise ಆಗಿರೋದು.
Expert is.
ಹೌದು ಎಕ್ಸ್ಪರ್ಟ್ ಇರೋದು. ಅವರು R7 ಜೊತೆ ಎಲ್ಲ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಂಡು ಕ್ಲೋಸ್ ಮಾಡ್ಕೊಂಡಿದ್ರು. ಆಮೇಲೆ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಫೈಲ್ ದ MEC ಎಕ್ಸ್ಪರ್ಟ್ ಮೇಲೆ.
Correct, ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಂದು ಎವಿಡೆನ್ಸ್ ಮಾಡಿಸ್ಬೇಕು. How can you impleading as a party?
ಅಯ್ಯೋ ಸ್ವಾಮಿ
How
ನಾನು
is
ಎಕ್ಸ್ಪರ್ಟ್
it?
ಇಲ್ಲ ಅಲ್ಲಿ ಏನಾಗಿದೆ ಅದು ಸೆಟ್ಲ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿ ಕ್ಲೋಸ್ ಆಗೋಗಿತ್ತು ಮ್ಯಾಟ್ರ್. ಆಫ್ಟರ್ ದೆನ್ ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆಗಿ ಫೈಲ್
ಯಾವಾಗ?
ನಮ್ಮ ನಾಲೆಜ್ ಗೆ
In the
ಬರಲಿಲ್ಲ.
same MEC case it was closed?
ಅವಾಗ ಏನಾಗಿದೆ ಎಕ್ಸ್ಪರ್ಟ್ ಇದ್ದಿದ್ದಗೋಸ್ಕರ
No, was it out of court or within
Out
the
of
court?
court. My lord, what he says, my lord, is
ಇದಾಗಿ
after accident.
Court ಅಲ್ಲಿ ಆಗಿಲ್ವಲ್ಲ? Why did you not contest the matter and now you are seeking adjournment?
fact is not it denied that my lord.
Who has not denied?
No, no.
Claimant
ಅದೇನ್ ನೀವು ಎಲ್ಲಿ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಆಗಿಲ್ಲ? How do you say he has not?
ಇಲ್ಲ ಅಲ್ಲಿ ಎಕ್ಸ್ಪರ್ಟ್ ಇರೋದ್ರಿಂದ ಆ ಆಪರ್ಚುನಿಟಿ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ನಾನು
How do you, on your own say that it is not, it is an admitted fact?
immediately post after service of notice my lord I will dispose of the matter.
No, my lord, so since my lord 4 lakhs amount, my lord, they have deposited. I may permitted to release the amount. My lord, the application is my hand, my lord's lordship.
ಅಲ್ಲಿ ಹೋಗಿ ರಿಜಿಸ್ಟರ್ ಫೈಲ್ ಮಾಡಿ.
Please.
Request finally. 1 week time ಅಲ್ಲಿ ಕಾಂಟೆಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ, ಅಪಿಯರ್ ಆಗೋದಿಲ್ಲ, ಇಲ್ಲಿ ಬಂದು ಬೇರೆ ಬೇರೆ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡು ಪ್ರೊಲಾಂಗ್ ಮಾಡ್ತಾರೆ.
ಅಲ್ಲ ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಪೇಪರ್ ಪಬ್ಲಿಷನ್
10
ಮಾಡಿ
days
ಇದು ಮಾಡಿದ್ರೆ
attend to the
ಅದೇ ಅಡ್ರೆಸ್ ಅಲ್ಲಿ ಇದ್ದ
Mailing
ನೋಟಿಸ್ ಜಾರಿ
picture.
ಆಗಿದೆ.
IA number ಎಷ್ಟದು? ಈಗ 294 days delays in filing the appeal.
ಹೌದು ಸರ್ 294 days.
They are filing which appeal against respond number 7. ಇಲ್ಲಿ impleading application ಅನ್ನು ಹಾಕದೆ ಡೈರೆಕ್ಟ್ಲಿ ಇಂಪ್ಲೀಡ್
They
ಮಾಡಿದ್ರು.
have made a party, my lord.
ಫೈಲ್ ದ ಅಪ್ಲಿಕೇಶನ್
ಅದು ಅಲೋ ಆಗಿತ್ತು.
ಇಲ್ಲ
ಇನ್ನು ಆಗಿಲ್ಲ. Even before it's allowed, my
ನೋಟಿಸ್
lord.
ಜಾರಿ ಆಗಿಲ್ಲ ಅಂತ ಹೇಳಿ ಪೆಂಡಿಂಗ್ ಇದೆ.
Lordship passed an order last time.
ಅಲ್ಲ ಇದು ಅಲ್ಲಿ ಬರ್ದಿ ಮತ್ತೆ ಹೇಗೆ ಬರೆದ್ರು ಅವ್ರ ಅಪೀಲ್ ಮೆಮೊದಲ್ಲಿ? ಅಪ್ಲಿಕೇಶನ್ 24. 1 of 24 is condonation of delay. 3 of 24 is for additional documents. So 2 of 24 is for
Page
impleading.
number 38 min. IA number.
Impleading application pending ಇದ್ರೆ appeal ಮೆಮೊದಲ್ಲಿ how did they ಆದ್ರೂ ಡಿಲೀಟ್ ಮಾಡಿಲ್ವಾ ಅದನ್ನ?
So in this regard, my lord has passed last night on order.
Pending in appeal memo. ಈಗ 6 ಗೆ ಸರ್ವಿಸ್ ಆಗಿದೆ, ಬರೀ 7 ಗೆ ಮಾತ್ರ ಬಂತು. Waiting notice.
ಸರ್ವ್ ಆಗಿದೆ, ಸರ್ವ್ ಆಗಿದೆ.
7
ಸರ್ವ್ ಆಗಿದೆ.
6 ಗೆ
Someone represented me
Here.
for 6.
ಅಲ್ಲ, ಹಾಗಾದ್ರೆ ರಿಜಿಸ್ಟ್ರೇಷನ್ ವೆರಿಫೈ ಆಯ್ತದೆ ನೋಡಿ. ಅದು ನಿನ್ನೆ ಒಂದು ಅರ್ಜಿ ಸರ್ಕಿಲ್
7 ಸರ್ವ್ ಆಗಿದೆ, 6 ಸರ್ವ್ ಆಗಿ ಕಲೆಕ್ಟ್ ಹಾಕಿದ್ದಾರೆ ಸಂತ.
ಯಾವ ಇಯರ್ MVC ಅದು?
Lord's MVC is of the year 2022. Date of accident,
2022.
please, 14/7/22 is the date of accident.
ಇಲ್ಲಿ we can't hold the trial here. ನೀವು at the most it should be remanded. If at all you had any good cause for not appearing. ನಿಮ್ಗೆ ಡಿಲೇ ಆಗುತ್ತಲ್ಲ, ಏನ್ ಹೇಳ್ತೀರಾ? ಅವ್ರನ್ನ ಅಲ್ಲೇ ಹೋಗಿ ಇಂಪ್ಲೀಟ್ ಮಾಡಿ ಅವ್ರು ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು.
ರಿಮೈಂಡ್ ಮಾಡ್ಕೊ.
That could be, my lord, normally he has to be given an opportunity, my lord, some.
He's already deposited some amount that will be kept in fixed deposit subject to the result of the trial claims
Fix a date also.
on the date
ಅಲ್ಲಿ
of the
ಹೋಗಿ again
appearance.
these people filing applications and serving ಡಬಲ್ ಆಗುತ್ತೆ. ಇಲ್ಲೊಂದ್ಸರಿ ನೋಟಿಸ್ ಹೋಗಿ ಬರ್ಬೇಕು, ಅಲ್ಲೊಂದ್ಸರಿ
That's, Lord's, and also, my lord, the opportunity to reconsider the entire claim because,
entire.
please, it could be remanded, my
On
lord.
the date
On the
of
issue
his
kept open
appearance,
by-
he will file.
All issue kept open my lord.
On the date of your appearance, you will
got
file statement of objection.
Statement of objection, whatever you want to implead or whatever you want to do, you have to do there only. ಅಥವಾ if somebody else is the owner, you can lead evidence to that effect.
Please.
Where is the need of impleading them? ಹಾಗೆ ಮಾಡಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಬಹುದಾ ಅರ್ಥ
Please.
ಬಂದು ಇಲ್ಲ ಅಂದ್ರೆ ಇದು ಅಗೇನ್
It will prolong.
ಬಂದಿಲ್ಲ ಯಾವತ್ತು ಹೋಗಿತ್ತು ನೋಟಿಸ್ ಫಸ್ಟ್ ಟೈಮ್
Third time, madam,
Third
5-2.
ಬರೋದು ಸಿಗೋದೇ ಇಲ್ಲ. Is there any understanding between the appellant and that respondent number 7?
ಇಲ್ಲ ಏನಾಗಿದೆ ಈಗ ನಂಬರ್ ಫೈಂಡ್ ಔಟ್ ಮಾಡಿದೆ ಅಟ್ಲೀಸ್ಟ್ ಟೇಕ್ ವಾಟ್ಸ್ಆಪ್.
ಅಲ್ಲ ಕರೆಕ್ಟ್.
You can't lead your defense for the first time in this appeal. You did not appear and lead your defense. Where is the question of entertaining all this?
ಆಯ್ತು ರಿಮೆಂಡ್ ಆಯ್ತು.
ಯಾವಾಗ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದ್ದ ಯಾವಾಗ ಇದು ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಅದಕ್ಕೆ ಆಮೇಲೆ ಐ ಕಾಪಿ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ ಇದೆ. ನಾವು ಮಾಡಿದ್ದಲ್ಲ ಇದು ಮೊದಲು ಡೆಪಾಸಿಟ್ ಮಾಡದೇನೆ ಎಕ್ಸ್ಟೆನ್ಷನ್ ಮಾಡಿಸ್ಕೊಳ್ತಾ ಹೋದ್ರು. ಇಲ್ಲ ನೋಡಿ ಫೈರ್ ರಿಜೆಕ್ಟ್ ಇದೆ. ಆರ್ಡರ್ ಯಾವಾಗ ಆಗಿತ್ತು ನೋಟಿಸ್ ಇಲ್ಲ ಹೇಳಿದ್ರೆ ಯಾಕಂದ್ರೆ ಇಲ್ಲಿ ಇವ್ರು ಅಪಿಯರ್ ಅದಕ್ಕಿಂತ ಮೊದಲು ಹೇಳಿದಾಗ ಈಗ ಅದು ವಿತ್ ದಿಸ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ನಾವು ಇಟ್ ಕ್ಯಾನ್ ಬಿ ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್.
Please, it could be disposed of. They remind.
ಅಲ್ಲ ಹೇಳ್ಬೇಕು ಯಾಕಂದ್ರೆ submission referred ಮಾಡಿ ಮಾಡೋದು. This appeal is preferred by the respondent in MVC number 6966 of 2022 on the file of MACT, additional MACT, MACT and SCCH number 17 under the impugned by the impugned award, the Tribunal has granted compensation of Rs 27,86,250 payable by the present appellant. Appellant did not contest the matter before the Tribunal. An ex parte decree was passed. In these proceedings, the appellant has filed IA 2 of 2024 to implead proposed respond number 7 on the ground that he was the owner of the vehicle.
Custody of the vehicle, my lord, is
Custodian of the vehicle. Owner ನೀವೇ registered owner.
Owner ಇವ್ರೆ.
RC owner
ಆದ್ರೆ ಅವ್ರು ಸೆಟ್ಲ್ ಮಾಡಿ ನೀವೇ RC ಓನರ್ ಬರೀ ಅವ್ರು ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾರೆ ಅವ್ರ ಜೊತೆಗೆ ಅಂತ.
ಸೆಟ್ಲ್ ಮಾಡ್ಕೊಂಡಿದ್ದೆ ಅವ ಏನ ಇದನ್ನ ಲಿಫ್ಟ್ ಮಾಡಕ್ಕೆ ನಮ್ಮ ವೆಹಿಕಲ್ ಬಿಟ್ಟಾಗೆ ಅವರು ಟ್ರಾನ್ಸ್ಪೋರ್ಟ್ ಮಾಡ್ಕೊಂಡೆ ಅದನ್ನ ಇನ್ಸಿಡೆಂಟ್
He was in the custody of the offending vehicle and response 1 to 5, that is claimants,
custody
on settling the matter with him out of the court,
without my knowledge.
have filed MEC number 6966 of 2022, again making a claim. The notice issued to respond number 7 is not being returned. Moreover, all these things may be the defense for the appellant before the tribunal. Those issues cannot be adjudicated for the first time before this court, converting this court to the tribunal in the original side. Now, counsel for respond number 1 to 5. 4 lakhs deposit ಮಾಡಿದಾರ.
It's 4 lakhs deposit.
By virtue of the interim order of this court, the appellant has deposited. Tribunal ಮುಂದೆ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ.
ಅಲ್ಲೇ ಮಾಡಿದ್ದಾರೆ.
Rupees 4 lakhs.
Earlier is paid 4 lakhs, my lord.
ಅದೆಲ್ಲ ನಮ್ಮ ಮುಂದೆ ರೆಕಾರ್ಡ್ ಇಲ್ವಲ್ರಿ ನೀವು ಬರೀ ಹೇಳಿದ್ದೇ ಹೇಳ್ತೀರಾ. ನಿಮ್ ಪಾರ್ಟೀಸ್ ಅಲ್ಲಿ ಹೋಗೋದಿಲ್ಲ, ಕಾಂಟೆಸ್ಟ್ ಮಾಡೋದಿಲ್ಲ.
At the time of execution, I have deposited 4 lakhs there, my lord, and subsequent this appeal, my lord.
Execution ಅಲ್ಲಿ 4
ಅಲ್ಲಿ
lakhs.
total 8. ಅಲ್ಲಿ 4, ಇಲ್ಲಿ 4. As per
8
this honorable court at 4.
Correct, 8 lakhs. Since it was an ex parte decree, an opportunity Interest of justice requires that an opportunity be given to the appellant to put forth all his defense. Counsel for respondent number 1 to 5 concedes for remanding the matter for disposal in a time-bound manner.
And also, my lord, opportunity given for the respondents too, my lord, because they one notional income has been taken, my lord, all the opportunity. That's only observation.
The aforesaid facts and circumstances. The appeal deserves to be allowed. Deserves to be allowed. Hence, the following order: the appeal is allowed. The impugned judgment and award in a award dated 9/8/2023 in MVC number 6966 of 2022 is hereby set aside. The matter is remanded to the tribunal for fresh consideration. To avoid further delay, the parties are hereby directed to appear before the tribunal on date 4 weeks. 2 weeks. 2 weeks. Matigless delay ಮಾಡಿದ್ದಾರೆ ಇನ್ನೂರು ಏನೇನೋ ಮಾಡೋರಿದ್ದಾರೆ. ಸರಿ. 10/3. 10/3. The appellant shall without consequences shall follow on him. The appellant shall file his statement of objection on the date of his appearance in the case. If any of the parties fail to appear, the tribunal shall proceed in accordance with law. On the appearance of the parties, the tribunal shall give reasonable opportunity to both the parties. To evidence to lead evidence reasonable opportunity of hearing to both the parties. Hearing includes evidence also. Both the parties and dispose of the matter as expeditiously as possible. At any rate, within 4 months.
Please.
From the date of the appearance of the parties, the amount deposited by the appellant shall be invested in FD in the name of the claimants. ಎಷ್ಟು ಮಾಡೋಣ ಎಷ್ಟು ದಿವಸಕ್ಕೆ?
5 ಜನ. My lord, there are 2 minors, my lord. Total ಎಲ್ಲ major ಇದ್ದಾರೆ.
Shall be invested in FD in any nationalized / scheduled bank of the choice of the claimants. ಅದೇ 4 months ಅಂತ ಮಾಡೋಣ. 4 months. For a period of 6 months ಮಾಡೋಣ. ಇಲ್ಲಾಂದ್ರೆ ಅಂದ್ರೆ ನಿಮ್ಗೆ ಎಷ್ಟು ಮಿನಿಮಮ್ 45 days ಅದು ಬರೋದು. Reinvestment scheme ಎಲ್ಲ ಇರೋದು.
ಈ ಇದ್ರದ್ದು ಅಷ್ಟು ಐಡಿಯಾ ಇಲ್ಲ. ಫಿಕ್ಸ್ ಡೆಪಾಸಿಟ್ ಸರ್. 3 months.
Claimants ಅಲ್ಲ ಅವರು ಏನಾದ್ರು ಅಕಸ್ಮಾತ್ ಹೇಳಿದ್ರೆ ಕೊಡೋದು. Until the disposal of the claim petition, subject to the further orders of the tribunal.
Please.
Pending IS to dispose. All contentions of the parties are left open.
Regarding
Statutory deposit also is.
Pending IS to dispose.
Statutory deposit also is.
ಏನದು? Amount in deposit, if any, shall be transmitted to the tribunal forthwith.
regarding the impleading applicant, my lord, that.
ಅದು ಅಪ್ಲಿಕೇಶನ್ಸ್ ಟು ಡಿಸ್ಪೋಸ್ಡ್ ಅಂತ ಆಯ್ತಲ್ಲ. ಇಲ್ಲೊಂದ್ಸರಿ ಸರ್ವಿಸ್ ಆಗ್ಬೇಕು, ಅಲ್ಲೊಂದ್ಸರಿ
service.
These are all the ways of dragging the proceedings. Yes.
Cell number 9, Prashant Chandra SN.
The appellant, my lord. My lord, this is the owner's appeal, my lord. There is a
Statutory
connect.
deposit is not made.
My lord, there is a connected matter in the insurance appeal of MFS 6027 of 2024.
Even if insurance
My
company
lord.
appeal is there, you have to make the deposit.
My lord, in this case, my lord, our submission and the challenges with respect to the pay and recover only. The recover aspect is challenged, my lord. Insurance company has also challenged the appeal. And the statutory.
Whatever may be, the moment if you want, it is a precondition. Deposit is a precondition. 25,000 deposit ಮಾಡೋದಿರುತ್ತೆ.
My lord, on that aspect, may I submit?
Appeal is not maintainable. ಅಲ್ವಾ ಅದರಲ್ಲಿ? No appeal without deposit 166, 173 ಕೊಡಿ ನೋಡಿ. We direct you to deposit within 10 days, 2 weeks, whatever you say, otherwise appeal shall stand dismissed ಅಂತ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. No, 166 ಅಲ್ಲ 173 ಸರ್. Provides ಅಲ್ಲ subsection 4 ಏನಿದೆ. 173 proviso. Provided that no appeal by person who is required to pay any amount in terms of such award shall be entertained by the High Court, shall be entertained by the High Court unless he has deposited with it 25,000 rupees or 50% of the amount so awarded, whichever is less manner directed by the High Court.
My lord, in this we have also not sought for an interim order, my lords, for that reason.
ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಪೀಲ್ ನಾವು ರಿಜಿಸ್ಟರ್ ಮಾಡ್ಬೇಕಂದ್ರೆ ನೀವು ಫೈಲ್ ಮಾಡ್ಬೇಕು, ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕು. ಅಟ್ ರಿಕ್ವೆಸ್ಟ್ ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್ ಏನ್ ಸಬ್ಮಿಷನ್ ಮಾಡಿದಿರಿ ನೀವು? ಕೌನ್ಸಿಲ್ ಸಬ್ಮಿಷನ್
My lord, that the appeal, in the appeal filed by the insurer,
ಅಲ್ಲ, ಒಂದು ಅಪೆಲೆಂಟ್ಸ್ ನೇಮ್ ಡಿಫರ್ಸ್ ಅಂತ ಅದೊಂದಿದೆ. Statutory deposit to be made good since the same award it is challenged
by the insurance appeal, insurer, my lord,
Correct.
in 6027 of 2024.
Council submission on office objection regarding statutory deposit is overruled. ಇನ್ನೊಂದು objection ಇದೆ.
ಎರಡು
At
comply
request
ಮಾಡ್ತಾರೆ.
Finally, 10 days time is granted to comply both the office objection. Appellant name differs from the cause title of the appeal.
My lord, 3 weeks time may kindly be granted.
3 weeks, sir.
Yes, ma'am.
ಎಲ್ಲಿ ಇವರು? ಯಾಕೆ why is finding it so difficult to deposit 25,000? He was respondent number 1 ಅಲ್ಲ? Neons Anthony D'Souza.
Udupi district.
D'Souza. Opposite Krishi Kendra,
Udupi district, ma'am.
Brahmavara Taluk. ಎಲ್ಲಿ ನಿಯಾನ್ಸ್ ಅಂತನಾ? ಅದನ್ನ ಎಕ್ಸೆಪ್ಟ್ ಮಾಡ್ಕೊಳ್ಳೋಣ, ಅದನ್ನು ಇದು ಮಾಡ್ಬೇಕಲ್ಲ. ಅದೇ ಇವ್ರ ಕರೆಕ್ಷನ್. ಇದನ್ನ ನೀವು ಎರಡು ಹೆಸರು ತೋರಿಸ್ಬೇಕಷ್ಟೇ. ಇಫ್ ದರ್ ಇಸ್ ಮಿಸ್ಟೇಕ್ ಇನ್ ದ ಟ್ರಯಲ್ ಕೋರ್ಟ್ಸ್ ಆರ್ಡರ್, ಯು ಆರ್ ಕಾಂಟೆಸ್ಟೆಡ್ ಅಲ್ಲ, R1
Yes, ma'am. Expand.
ಎಲ್ಲಿ ಬರ್ಬೇಕು? Council submission and office objections rejected. Okay. At request finally, ಎಷ್ಟು 3 weeks ಬೇಕಾ?
3 weeks. ಅದ್ರೊಳಗಡೆನೆ ಮಾಡ್ತೀವಿ.
To comply the office objections, failing which the appeal shall stand dismissed.
My lord, if the office objections are complied, may it be connected with the insurance appeal. There is already a direction in that appeal, my lord, to connect this.
Comply ಮಾಡಿದರ್ತು ನಾವೇನು ಆರ್ಡರ್ ಮಾಡೋದಿಲ್ಲ.
Please.
So number 10, Hitesh Gowda BJ, Rajita TO for R1 and R2.
Your lordship, leadership. Lord, there is a repeated attempt by the respondents not to comply with the order at all. Your lordship, in this view, I would like to pray to this honorable court to consider my IA 1 and 2 together.
What is the order dated 29?
If the lordship
Oh,
has the last order.
ಇದೇನಾಯ್ತು?
Comply ಮಾಡಿದೀವಿ my lords. I'm filing my compliance
Visitation
affidavit.
took place?
Even
Times visitation took place on
yes, my lords.
Visitation took place on both the days, my lord.
If I may be allowed to speak, then possibly my.
Visitation took place on both the days.
all of you, 3 of you speak together. How
That's
will
why
you
I don't
come?
want, I'll not speak if they're speaking.
So you are for the appellant. You had to visit, no? I mean, they had to drop her.
Your lordship, they had to pick and drop and pick.
They will
And
bring
if
the
your
child.
leadership would see the affidavit filed by them, they are now seeking clarification of the word pick and drop. I asked myself, pick and drop in English itself is very categorical and clear. There is a need for clarification. So throughout the visitation,
First and 7th, they did not bring the child
they,
to the.
they got the child,
Huh.
but they sat with him throughout.
Huh.
Throughout. The child automatically was not free enough to talk to us. The order is very clear. It clearly says, if I can have the second paragraph, the learned counsel for respondent undertakes that they will bring the child to Karnataka Mediation Center, Bangalore on 1st and 7th of Feb at 3 p.m. for visitation and drop the child there up to 5. It is very clear. They will drop and then they will leave. If your leadership will see their affidavit, now they are seeking clarification of the English word pick and drop. It is very clear that they were to leave. They were to give some privacy. And it is not only this.
My lord, they didn't want the parents to be present throughout the visitation.
cases so we can dispose of it. What is that affidavit you are filing?
A compliance affidavit, my lords. I'm serving
You are also filing your report.
We are also filing. Now, if you ladies will see the para 3, I'm sorry.
You have not stated who is that official who said that there should be clarity of the order?
one.
You have
person.
not stated who is that official. Our people will not say like this.
A person from mediation center, my lords. A person.
Wherever you should tell their name. You cannot create a fictitious person there. ಹೇಳ್ತಾರಂದ್ರೆ ಮಗು ಜೊತೆ ಅವ್ರು ಏನ್ ಮಾತಾಡಿದ್ರು ಅಂದ್ರೆ ಅವರೆಲ್ಲ ಹೋಗ್ಲೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾರೆ.
So both of you all are determined to ruin the future of the child.
Unfortunately, Your Lordship, what has happened?
Very clear.
Can I just briefly?
In unison, you all are determined.
Can I just briefly say, child was abandoned when he was 1 year, 8 months old.
Very
He was
unfortunate.
abandoned.
Very unfortunate.
Left with the grandparents.
Extremely
He must have suffered massive anxiety.
The council, please don't argue the matter on merits.
No, I'm not.
Merits is available from the record. In the manner with which both of you all are conducting yourselves, even despite the best effort of this court to facilitate and some semblance of normalcy, you all are determined to ruin the future of the child.
Can I then seek?
Both of you all.
Can I then seek one minor indulgence of this honorable court?
Very unfortunate. Very unfortunate.
From my client, I give an undertaking. If this honorable court, after interacting with the child, feels that the child is comfortable with the parents, we will not insist on this appeal itself. We will be out of this court. I'm only saying, I am only seeking the welfare of the child. If this honorable bench is of the view that the child is best suited with the parents and is comfortable.
The manner in which the proceedings have been conducted up to this stage itself demonstrates the conduct of the appellant.
Appellants, no.
I'm for the appellant. Your Lordship will appreciate, for last 7 years, the child was with us.
Absolutely. 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 That is the conduct.
And he was bundled.
That is the conduct.
Learned counsel, why your parties stayed there after leaving the child?
Your Lordship.
Why your clients? Respond. Your affidavit, yaru. Ibru ondena iವರು. No, iವರು ಹಾಕಿದ್ರು. ಈಗ ಮಗು ಇವ್ರ ಹತ್ರನೇ ಇದೆ. No, with the parents. Child is with the
parents.
With the parents.
ಅಲ್ಲ ಬಟ್ ಇವ್ರು ಹಾಕಿದ್ರಲ್ವಾ ಕಸ್ಟಡಿ ಕೇಳ್ಕೊಂಡು ಅಪ್ಪೆಲೆನ್ಸ್ There were two petitions. Sir. One is by the parents. Hmm. But, child was earlier with a child. ಇದನ್ನ ಅವ್ರಿಗೆ ಕೊಟ್ಟಲ್ವಾ ಅಲ್ಲಿ ಇದೆಲ್ಲ ಕ್ವಶನ್ ಕೇಳಿದ್ರು ಇದೆಲ್ಲ ಕೇಳಿದ್ರು ಅಂತ ಇವ್ರು ಕೇಳ್ಬೇಕು ಅಂದ್ರೆ ಇವರು ಪ್ರೆಸೆಂಟ್ ಇದ್ರು ಅಂತ ಆಯ್ತಲ್ವಾ ಸರಿ ಅಂದ್ರೆ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ನಾಟ್ ಪೇರೆಂಟ್ಸ್ ಕಸ್ಟಡಿ ಗ್ರ್ಯಾಂಡ್ ಪೇರೆಂಟ್ಸ್ ಕೊಡ್ಬೇಕು ಅಂತ ಆಗುತ್ತೆ ಅವಾಗಲ್ಲ ಡ್ಯೂರಿಂಗ್ ದಟ್ ಪೀರಿಯಡ್ parents, these parents were not supposed to stay. Correct. ಈಗ ಇಷ್ಟು ಹೊಡೆದಾಡೋದ್ರಲ್ಲಿ ನಾನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇದೆ ನಾವು ಲಾಸ್ಟ್ ಟೈಮ್ ಇಲ್ಲಿ ಬಂದಿದ್ರು ಮಾತಾಡಿದ್ರಾಗ ಶ್ರೀರಂಗಪಟ್ಟಣದಲ್ಲೆಲ್ಲ ಹೋಗಿ ವಿಶಾಖಪಟ್ಟಣಕ್ಕೆ ಹೋಗಿದ್ದಾರೆ. This was only for the interim arrangement up till this day. You argue the main matter itself.
I have absolutely no cause, but I would only request this honorable court. If the child is being traumatized at a particular premise, I ask myself.
Just yesterday or day before yesterday's judgment of the Supreme Court has come. Have you read that? Other court officer ನಮ್ಮ ಲಾ ಕ್ಲರ್ಕ್ ನಾನು ಕಳಿಸಿದ್ದೆ ತರಿಸ್ಕೊಡಿ ಅದನ್ನ
Leadership, I know
not in the station. I send it ತರಿಸಿ ಅದನ್ನ ತರಿಸ್ಕೊಳ್ಳೋಣ ಮೇನ್ ಮ್ಯಾಟರ್ ಮಧ್ಯಾಹ್ನ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ನಾವು ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ. both of you argue the matter in the afternoon.
Yes ma'am.
So leadership, the
You are trying to show your command over the child, both of you. You want to own the child.
I ask myself,
you are treating it as a kingdom or as a commodity.
3 orders violated, one after the other. 3 orders violated.
Correct. What is your Mr. Counsel? Tell us what is your client's legal right? Now they have succeeded before the trial court.
No. If I ask myself, if your leadership,
what is your client's legal right over the child?
If the order is patently illegal, if the order itself is wrongly appreciating the evidence, then can it actually be referred to
That's
as a
what
judgment?
we'll show you that judgment of the Supreme Court. Just in the afternoon.
Past conduct is
you
coming back to
see, you are not able to create a bond with your own daughter.
Your ladyship kindly appreciate.
Then how do you take care of your grandchild?
It was her own conduct when she left the child
Mr.
at
Counsel,
1 year 8 months.
Any working woman, sometimes she might have left it in her
Then
custody.
she would come back after 3 months, 4 months, 5 months, 1 year, after 7 years.
So it is property to relinquish, right?
Your lordship,
property
And
to
is it
relinquish.
have you?
can I say something?
No.
Is it not the welfare of the child which has to be seen?
That we'll see. We'll see you argue the matter in the afternoon. Yeah, are you claiming it by adverse possession?
No, absolutely not. On merits.
But afternoon you can argue the matter.
Your ladyship, I am only saying.
Judgment has become easy. Yes.
May I only submit this? Let the child.
Afternoon we'll argue here both.
Yes.
of you. Argue this.
Yes.
Link ಕಳಿಸಿದ್ದೆ judgment receipt, guardians and WhatsApp. You are not there. You take out that judgment.
Your ladyship, the lower court records are here. I'm just trying to, because that will be very relevant. Because not all the evidences have been found.
Because last time condonation of delays. Delays for what? I'm sorry. for stay, direction. And in these matters, they don't want to argue the main matter, generally very interim applications, directions. Pandilva? Then we'll call for the records. This is from Bangalore court only, no? ಯಾವ court ಅದು?
Srirangapatna court.
We'll get it on telephonic requisition. We'll the affidavit. We'll take on record.
Ladyship, may post it
What
for-
is your affidavit? These matters should be solved in an amicable manner between the parties. All right, we'll.
My client is here.
ಇನ್ನೊಂದು affidavit ಅವ್ರೇನೋ ಕೊಟ್ರಲ್ಲ ಕೊಡಿ. So allegations and counter allegations. Group of 5 lawyers. 2 relatives. Yes, they say that you came with a group of 5 lawyers, 2
Yes.
relatives. Why did you do that?
We were outside only, my lords. We didn't even interfere anything. We did not come with 5 advocates and all.
You
I
are
was the
also
only
matching them.
Oh, my lords. I was the only person who was accompanying them.
After all, your daughter.
Unfortunate. I
Matching
have
jeans.
nothing to say. I have
Jeans.
nothing.
And you want that to percolate to your grandchild.
Personally, your leadership and your lordship, I have tried to mediate between them, but somehow I think all the efforts, even earlier, the predecessor benches have been.
They are determined to litigate up to the highest court. I come in the way.
I would say nothing on it. I would say nothing.
10 kilogram weight child has no. Please. What the child will do if both of you keep doing like this?
He calls
Can I
aunt
work on it?
mother.
Both counsel submit the affidavits of appellant number 1, appellant number 1 and respondent number 2. Respondent number 2. Both have made allegations against each other. And then made allegations against each other that each other did not permit the implementation of visitation order passed by this court on 29/1/2025. And instead of again delving on this, we can hear the main matter. The parties are not able to come to a peaceful resolution, and the child's welfare is at stake. Therefore, it is just to hear the main matter itself. Call for admit andre time hogutte. Registry shall secure the TCRs on telephonic requisition. List the matter for final disposal on 24th. Earliest.
Your leadership, it can be, if it is possible, this week on 14th. If it is possible on 14th.
14th ಯಾವತ್ತಾಗುತ್ತೆ?
Or it could be on 17th. Unfortunately, I have a preoccupation from 22nd. I'm sorry. So it
Sir,
could be-
you're local or
I come from Delhi University.
Bangalore is better than Delhi now. Climate. You
Any
stay
day,
here.
any day, no doubt about it.
You stay here. You can stay for a week also.
I keep traveling to Bangalore more often than I'm in Delhi actually.
Date one day. Which date you want?
If it could be 17th, it could be 18th, 19th, any day you got the outside.
17th ಬೇಡ ನೋಡೋಣ. 19th ಹಾಕೊಂಡ್ರೆ? What about 19th?
19th is
19th.
19th.
Both of you argue on the main matter on that day.
Leadership can fix the time 2:30 so that I don't have to come in the morning. If your leadership
You
so
can come at 10:30 only.
Okay, no
Yes.
problem, no problem.
Discuss next.
Deeply obliged. Deeply obliged.
Till number 11, B Pradeep, Sandesh TB.
Collected.
Hearing for the later Miller's appeal copy not.
Non-furnishing of acknowledged filing, served the copy and the caveat. Have received the copies, Mr.
ಇಲ್ಲ
Sandesh?
ನಾ ಕಲೀಗ್ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿದ್ರು ರಿಸೀವ್ ಮಾಡಿಲ್ಲ ಅಂತ. I will
Not
furnish
received the copy.
next week any date may be fixed madam. If I will do.
Third ಅಂತ
I will-
ಹೇಳ್ತೀವಿ, ಈಗ ಒಂದು ಕಾಪಿ
ಅಲ್ಲ ಇವಾಗ ಕೊಡ್ತೀನಿ ಇವಾಗಲೇ ಇದೆ ಸ್ವಾಮಿ ಕಾಪಿ ಇದೆ.
ಹಾ ಕೊಟ್ಬಿಡಿ, ಸರ್ಡ್ ಅಂತ ಬರ್ಕೊಳ್ತೀವಿ. ಜಡ್ಜ್ಮೆಂಟ್ ಎಲ್ಲ ಇದೆಯಾ ಅದ್ರಲ್ಲಿ? ಬರ್ಕೊಳ್ಳಿ. Counsel for the appellant serves the copies on the counsel for respond number 1 and 2. Okay, therefore office objections should comply. Who has moved it?
ನಾವೇ ಮೂವ್ ಮಾಡಿದ್ವಿ.
ಯಾವ್ದಕ್ಕೆ? ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇಲ್ವಾ ಇದ್ರಲ್ಲಿ?
ಇಲ್ಲ
caveat ಇದ್ದದೆ.
ಅವ್ರು ನೋಡ್ಲಿ ಸುಮ್ಮನೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಳ್ಳಿ.
Caveator is senior citizens, my lords, the.
ಎನಿವೆ ನಾವು ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್ ಅಂತಾನೆ ಮಾಡೋದು. 50%.
Please, my lords.
Then it
Subject to condition.
application for withdrawal. ಏನಿದೆ ಪಾಯಿಂಟ್ ಅಂತ? What is the?
3-1 ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿ ಅಲ್ಲಿ ಲೈಸೆನ್ಸ್ ಇಲ್ಲ ಅಂತ. 3-1 ಚಾರ್ಜ್ ಶೀಟ್ ಹ್ಯಾಸ್ ಬಿನ್ ಫೈಲ್ಡ್ ಮಿಲಾಟ್ ರೈಡರ್ ಆಫ್
ಏನ್ ರಿಕವರ್ ಬರುತ್ತಲ್ವಾ?
ಬರುತ್ತೆ.
ಮತ್ತೆ ಅವ್ರು ತಗೋಬಹುದು ಅವರು.
My lords, next week ಹಾಕಿದ್ರೆ finally they dispose of the.
ಕ್ವಾಂಟಮ್ ಮೇಲೆ what about
ಕ್ವಾಂಟಮ್ ಮೇಲೂ ಇದೆ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ
ಅವ್ರದ್ದು appeal ಇದೆಯಾ?
ಸ್ಯಾಲರಿ ತಗೊಂಡಿದ್ದಾರೆ.
they have not preferred any appeal?
No, my lords.
ಎಷ್ಟು? How much income is taken? 39,800.
41,120.
ಅಲ್ಲ ಅದಕ್ಕೆ ಮತ್ತೆ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಡ್ ಮಾಡಿ ನೀವೇ
ಅದರಲ್ಲಿ ಟ್ಯಾಕ್ಸ್ ಡಿಡಕ್ಟ್ ಮಾಡಿ ಆಮೇಲೆ 5%
33,160.
39,802
loss of
after deduction of tax.
loss of
25% of the income ಮಿಲಾಡ್.
ಟ್ರಾನ್ಸ್ಪೋರ್ಟೇಷನ್ ಅದೆಲ್ಲ ಕನ್ವೆನ್ಷನಲ್ ಹೆಡ್ ಅಂತೂ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಇನ್ಕಮ್ ಜಾಸ್ತಿ ತಗೊಂಡಿದ್ದಾರೆ.
ಏನು ಇಟ್ ವಾಸ್ ಎನಿ ಪ್ರೂವ್ಡ್ ಇನ್ಕಮ್ ಆರ್
ಎಂಪ್ಲಾಯರ್ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರು ಹೇಳಿದ್ರು 32,000 ಸ್ಯಾಲರಿ ಕೊಡ್ತಾ ಇದ್ವಿ ಅಂತ. ಅದರಲ್ಲಿ ಬೇರೆ ಬೇರೆ ಮಂತ್ ಅಲ್ಲಿ ಇನ್ಸೆಂಟಿವ್ಸ್ ಅದೆಲ್ಲ ಆಡ್ ಆಗಿರುತ್ತೆ. ಸ್ವಿಗ್ಗಿಯಲ್ಲಿ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು, ಡೆಲಿವರಿ ಮಾಡ್ತಾ ಇದ್ರು. ಅದಕ್ಕೋಸ್ಕರ ಅವರು 41,000 ಅಂತ ತಗೊಂಡ್ರು.
ಎನಿವೆ 75% ಡೆಪಾಸಿಟ್ ಮಾಡಿಬಿಡಿ. ಏನ್ ಅಷ್ಟಾದ್ರೂ ಅಷ್ಟೊಂದು ಹೆಚ್ಚಾಗೋ ಚಾನ್ಸ್ ಇದೆ. ವಾಟ್ ವಾಸ್ ಈಸ್
45 years.
44 years.
ಸ್ವಲ್ಪ ಟೈಮ್ ಕೊಟ್ರೆ ಕ್ರಾಸ್ ಅಪೀಲ್ ಹಾಕ್ಬಿಡ್ತಾರೆ.
ರೆಡಿ
ಕ್ಲಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕ್ಬೋದು ಅವರು.
ರಿಡಕ್ಷನ್ ನೋಡಿ ಸರ್, ಅದು ಅಪೀಲ್ ಎನೌನ್ಸ್ಮೆಂಟ್ ಆಗ್ತದೆ ಅಂದ್ರೆ ಬಟ್ ರಿಡಕ್ಷನ್ ಆಗ್ತದೆ.
Respondents are senior citizen, my lords.
Stay of execution of the impugned award, subject to till further order, subject to appellant depositing 50% of the award amount. 75%. 75% of the award amount. ಇಲ್ಲೇ ಮಾಡಿಬಿಡಿ, ಅವ್ರು ಇಲ್ಲೇ ತಗೊಳ್ತಾರೆ.
ಇಲ್ಲೇ ಮಾಡ್ತೀನಿ ಸ್ವಾಮಿ. ಮೀನ್ ವೈಲ್ ಮೇಲೆ TCR ಮೇ ಬಿ ಕಾಲ್ ಫಾರ್ ಮೇಲೆ ಒನ್ಸ್ ಫಾಲ್
ಮಾಡಿದ್ವಲ್ಲ ಕಾಲ್ ಫಾರ್ ಅಂತ ಆರ್ಡರ್ ಆಯ್ತು ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್. ಯಾಕಂದ್ರೆ ವೈ ವಿ ಆರ್ ಸೇಯಿಂಗ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಅವ್ರು ಏಜ್ ಇದ್ದಾರೆ, ತಗೊಳ್ಳೋದಿದ್ರೆ ಇಲ್ಲೇ ತಗೊಳ್ತಾರೆ. ನೀವೇ ಪೇನ್ ರಿಕವರ್ ಆದ್ರೆ ನೋಟಿಸ್ ಹೋಗ್ಲಿ ಕೇವೇಟ್ ಆಯ್ತು. ಒಂದ್ ವೇಳೆ ಇಲ್ಲಿ ಕೊಟ್ರೆ ತಗೊಳ್ಳೋದಿದ್ರೆ ವಿ ಕ್ಯಾನ್ ರಿಲೀಸ್ ಹಿಯರ್ ಓನ್ಲಿ. And call for TCRs ಅಂತ ಆದ್ಮೇಲೆ issue notice to respondents.
ಅವ್ರು 1 to 3
ಅಲ್ಲ ಇವ್ರು he is
1 and 2.
1 and 2 ಅಷ್ಟೇ.
1 and 2 3 4 and 5 ಮಿಲಾಡ್ I will take steps. Or 5 is the wife ಮಿಲಾಡ್.
5 is the wife, my lords. Now
He was made respondent.
ಅವರು ಸಪರೇಟ್ ಆಗಿ ಇದ್ರು ಅಂತಾನೆ ಹೇಳ್ಕೊಂಡಿರಲ್ಲ. ಅವರು ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ದಾರೆ ಟ್ರಯಲ್ ಅಲ್ಲಿ.
she is also married, my lords. Therefore
issue notice ಏನು ಇಲ್ಲಿ ಬಂದ್ರೆ ಬರ್ಬೋದಲ್ವಾ?
ಅದೇ ಅದಕ್ಕೋಸ್ಕರ ಸ್ಟೆಪ್ಸ್ ತಾಂತೀನಿ. 3 4 5 ತಗೊಂಡು
ಕಾಲ್ ಫಾರ್ TCRs ಅಂತ ಆಯ್ತಲ್ಲ. ಸಬ್ಜೆಕ್ಟ್ ಟು ಡೆಪಾಸಿಟ್ ಆಫ್ ಸೊ ಅಂಡ್ ಸೊ. ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕ್ಬಿಡಿ, ಡೆಪಾಸಿಟ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮೊದಲು. ಲಿಸ್ಟ್ ಆನ್ 4 weeks ಆದ್ಮೇಲೆ
1/4. Till number 12, Vaishali Hegde, yes, Jagan Babu.
For the appellants, my lord.
I have few judgments, my lord, may be passed. I am for the respondent. This appeal itself is not maintainable. 43(1)(a), my lord, in view of the, my lord, the prohibition under section 19(1) of the Family Court Special Act. My lord, the filing itself is, my lord, void. 41(3)(a) is not applicable.
Which is that judgment now? Search ಮಾಡ್ತಾ ಇದ್ದೀನಿ ನಿಮ್ಗೆ. Which is that judgment directly on the point?
My lord,
ಇದು intermediary
My lord, special act and first one is the Supreme Court, my lord. Special act under section 11(1) and the general act, my lord. Page number,
that is under the criminal procedure code.
also it's a special act and the general law, my lord.
Special occurrence ಅಂತನಾ?
Yes, my lord.
The second one, Kerala. 88 to 99.
My lord, three bench decision, my lord, page number 4. My lord, page number 4, 3. When the act excludes the court, then it is obvious that it excludes an appeal against any type on an interlocutory order. The non-absentee clause was thus put to section 11 of the act. So the bar appeals against any interlocutory order, whether it is an intermediate nature or is quasi-final.
Correct,
That-
then what will be the remedy?
But remedy, they have to prefer an, my lord, writ petition, my lord, before the single bench.
This act, this is in respect of the Special Courts Act.
Can complete, then you can argue. Yes.
Please, my lord.
Then, my lord, para number 5 also, the right of appeal should not be restricted unless such a construction is unavoidable, where the right of appeal is expressly excluded by providing that no appeal shall lie against interlocutory order. It is not possible to stretch the language of the section to give a right of appeal when no such right has been conferred. Therefore, in view of the non-absentee clause, section 11(1) of the Act cannot be construed to contain a right of appeal even against an interlocutory order. Amongst the three bench, my lord, one is concurring, one his lordship, his lordship justice is dissenting. Then, my lord, another judgment your lordship gets at page number 92.
For the proceeding here. ಅದೇ ಡೈರೆಕ್ಟ್ಲಿ ಫ್ಯಾಮಿಲಿ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಯಾವ್ದಾರ ಕೇಸ್ ಇದೆ ನೋಡಿ ಅಂತ.
Ink page number 92, my lord, another judgment on the same point.
Under the Family Courts Act only.
This is under Family Court Act.
88.
Page number 92, my lord, 1990 SEC online Rajasthan. My lord, the relevant para, page number 94, para number 11, my lord.
ಕೇರಳ ಹೈಕೋರ್ಟ್ ಇಂದ ಕೊಟ್ಟಿದ್ದೀರಾ?
This is Major Raja P. Singh versus Sundar Kumari. Para number 11, my lord.
Page number 94.
94, para number 11.
Yes.
The object of this special law of the Family Courts Act is to decide the matrimonial cases in a speedy manner. If the order rejecting or allowing an amendment application will be termed as the case decided for the purpose of this act and is appealable, then in the ordinary course of law, the decision of such cases would take years to come to reach the finality of the matter. In order to achieve the object of the act, speed.
This was not a return of plaint.
This is
For
not a
amendment.
written after, it's not an interlocutory application.
Application for
It's an
complaint
amendment, my lord.
of signature. Directly on the point ಯಾವ್ದಾರ ಇದೆ ಅಂತ ಕೇಳಿದ್ವಿ ನಾವು. What is this page 88? What is this judgment in page 88?
Then, my lord, the Family Court Act 1901,
ನಮ್ಗೆ ಗೊತ್ತಿದೆ ನಾವು.
Family Court Act, my lord. When there is a family court, this 43(1)(a) is not maintainable. Now, this MFA is filed under section 43(a) of the Civil Procedure Code. That is not maintainable, my lord. It is settled.
Jurisdiction ಕ್ವಶನ್ ಮಾಡಿರ್ತಾರೆ. ಅದನ್ನ ಅವರು ಆ ಕಂಟೆನ್ಷನ್ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಅದ್ರ ಮೇಲೆ ರಿಜೆಕ್ಟ್ In this Kerala High Court judgment, what was the view taken?
Not Kerala High Court judgment.
Whether it has jurisdiction or not, another decided.
My lord, that is filed under 19(1). Office raised an objection. Page number 89, just above 4A. My lord, the respondent has also raised contention that the appeal is not maintainable as an appeal under section 19(1) of the Family Court Act would lie only against final order and not against an interlocutory order. My lord, the order of jurisdiction, my lord, either way it is an interlocutory order. Even if it is termed as intermediary or, my lord, the quasi-final order, my lord, it cannot be construed as a final order.
What has jurisdiction of the hand? Yes, yes, these are all the judgments you are relying.
My lord.
Yes.
My lords, the question is whether this is an interlocutory order or a final order, my lord. Although it is styled as an interlocutory order because the trial judge says that order on IA filed under Order 7, Rule 11, it is allowed in the Bardidare. But then, my lords, the order in effect has the trapping of finality because insofar as that court is concerned, the matter ends there, my lord. Now, although the plaint is returned, I have to start afresh before a new court. Therefore, my lord, the trial, the proceedings insofar as that court is concerned, that is the Family Court Bangalore Urban District, that has attained finality, my lord.
You're so confident. Why did you not mention the appeal is under section 19?
My lords,
Why have you mentioned that this appeal is under Order 43, Rule 1A? Why have you not mentioned under section 19?
my lords, that may be a typographical error. But if that is the case, my lord, I can carry out an amendment and it can be heard, my lord. If I have to amend the cause petitions, I'll do that, my lord. But appeal is still maintainable. Appeal, whether under 19 or under Order 43, Rule 1A, it's an appeal at the end of the day.
Difficult question of law is involved.
My lords, in fact, a similar question I had arisen before this honorable court. Different coordinate bench of this honorable court.
Yes, judgments on the point.
Please, my lord. Adanano, I had produced it on the last occasion, my lord, along with my list of authorities dated 29th of January 2025. The judgment starts at page 65.
65.
Please, my lord. This also, a petition for divorce was filed by the wife against the husband. Divorce was granted. Thereafter, wife filed an
65.
page 65.
This is under custody of child.
No, but then section 19 of the Family Courts Act, that has the court has gone into that provision, my lord. Head note C.
What was the order challenge there?
My lord's order was custody was given to the mother. Of the child was given to the mother. That was challenged.
That was interim custody or final custody?
The final ಕೊಟ್ಟಿದ್ರು divorce proceedings ಆಗೋಗ್ಬಿಟ್ಟಿತ್ತು.
Final order.
Appeal.
The final order.
ಬಂದೇ ಬರುತ್ತೆ.
No, my lords, but then the court has observed what amounts to a final order, what is an interlocutory order. Adide adralli.
Which paragraph?
Para 13 at page 72. This honorable court has referred to other earlier judgments of the Supreme Court. Para 13, I may be permitted to read. My lord.
Proceedings were pending on the file of IA-5 was filed by the appellant under section 26 of the Hindu Marriage Act seeking custody of the ward. Okay.
Please read para 2, 3, 4 first. We'll get there.
Please, my lord.
No order was passed. The appeal is.
This was after decree was passed. 235 indicates it's a final order.
Dispose ಆಗಿ ಹೋಗಿರುತ್ತೆ. If the order made by the court, if it brings the proceedings come to an end without intervention of the party person, such as expiry of time limit and happening of an end, not prescribed by the if order is made. It's just this issue policy. If we finally dispose of the matter in this paper, it is final. The decision is given in one way, we will finally dispose of the matter in this book, but if given in the other, we will allow the action to go on, then not a final, but interlocutory order. If it is made in aid of them, in aid of the final order or the decree. Generally speaking, an interlocutory appeal is made by the judicial forum or the court from time to in aid of the during the pendency of in aid of the final order or decree to be made after the adjudication of the statute. This is not made in aid of the final order. Till disposal of the case and the Here you have brought a very typical case for us. ನಮಗೂ ಇಲ್ಲಿ ಏನಂತಾರೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ತಾರೆ ಅಂತ ಕೇಳಬೇಕಾಗಿತ್ತು. Simply because an order cannot be regarded as a final order, the court cannot come to a conclusion that such order should be an interlocutory. In other words, an order, though not a final order, nevertheless may not necessarily an interlocutory order, will be an order for the purpose of further therefore, for that court, it is final order now. For that court, proceedings are terminated before that court. 19(1). Yes, what? You read the judgments which he has given?
Lord,
More particularly.
Lord, that is,
the
one is final order.
No, no.
The first judgment is 1968, my lord.
Many court bitbidi. You go to ILA 2003 Karnataka page 4431. And page 65 ನಲ್ಲಿ ಇದೆ ನೋಡಿ.
65.
ಸ್ವಲ್ಪ ನೀವು ಅದು ಓದ್ಕೊಂಡು ನೋಡಿ ಇನ್ನೊಂದ್ಸರಿ ಹೇಳಿ ಬೇಕಂತ. ಆಲ್ಸೋ.
ಆಯ್ತು.
This judgment is clearly on the point, my lord.
But this, okay, I'll go through. It's a final order.
Not the similar case. This is a different case. Andre,
My lord,
after disposal, they had filed an application for custody.
then para 18, my lord, it says that if it's in aid of the main relief, then it can be considered as an interlocutory order. Here, it's not in aid of the main relief, my lord. My plaint itself has been returned.
It is in aid of main relief only because it is not rejected. It is given to you back to present it before some other court.
That would not be in aid of the main relief, my lord.
Right.
And so far as that court is concerned, proceedings are terminated, my lord. So this has the effect of a final order itself. And the Supreme Court also in various cases has held that.
Itself or
Supreme Court also has in various cases held that, my lord, an order may be final in respect of one aspect and interlocutory in respect of another aspect.
Supreme Court judgment, only so many Supreme Court judgments are quoted there. They say if an order is passed in aid of the final order that may be issued, then it becomes interlocutory order. If the main case itself is disposed of, then it becomes.
Then in that case, the first judgment, my lord.
ಬಂದೇ ಬಂದಿರ್ಬೇಕು ಇಂಥ ಕೇಸ್ ಏನಂತ ಮಾಡಿರ್ತಾರೆ ಅಂತ ನೋಡೋಣ. 130 ಬರಬೇಕು. ಇವತ್ತು ಕೊಡ್ತಾ ಇರೋದ ಇದು ಇದಕ್ಕೇನೋ ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಏನಿಲ್ಲ ಅಂತ ಬರ್ಕೊಂಡು ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ submits respondent number 1. There is only one respondent, no?
Two respondents, my lord.
Two respondents. Respondent number 1 submits. Adre innu notice hogilla avrige. Submits memo with citations of both counsel and as requested by both counsel list on date.
A short date may be given, my lord.
I seek for 10 days time.
My lords, the maintainability.
I will go through and make submission. 10 days time, not long time, 10 days.
20.
Please, ma'am.
Hearing on again. Bill number 13, O Mahesh, Vijay Kumar SC.
Appear for the appellant.
Appearing for respondent number 6.
GMCPCL ಬರುತ್ತೆ ಸ್ವಲ್ಪ ಆ ಬ್ರಾಂಚ್ ಅವ್ರು ಕರೀಬೇಕು ಇವ್ರನ್ನ ಕರೆಕ್ಟ್ ಹೇಳಿದ್ರೆ ಗೊತ್ತಾಗ್ಬೇಕು ಬರೀ MF ME ಇವ್ರದ್ದು ಬೇರೆ ಬ್ರಾಂಚ್ ತಾನೆ GM ಅಲ್ಲ ಆಮೇಲೆ ನಮಗೆ ಜುಡಿಷಿಯಲ್ ರಿಜಿಸ್ಟರ್ನ ಬರಕ್ಕೆ ಹೇಳಕ್ ನೆನ್ಕೊಂಡು ಎಸ್
I am appearing for respondent to, respondent number 6, your worship, owner.
Yes.
There is a
I appear for appellant, my lord, 5 days delay may kindly be condoned.
Appeal is on what ground?
Appeal on the ground, my lord, that there is no nexus between the injury and the death. On the contrary, that it was negligence of the deceased himself who was riding a two-wheeler without license.
You appear for respondent.
Respondent number 6, your worship. I am owner of the vehicle.
What about respondent number 1 to 5 served and represented ಅಂತ ಇದೆ? ಅದರಲ್ಲಿ
By
minors
substituted service, they were served.
ಇಲ್ಲಿ respondents 2 and 3 are minors.
And all the respondents were served by
On the last date.
substituted service on 2/7.
You were directed to file application for appointment of
Yes.
guardian for the.
Application was sent, it is not yet come, my lord. Application was sent.
Then why are you arguing on the application, interim application? Well, appeal against respond 2 and 3 shall stand dismissed ಅಂತ ಹೇಳಿ ನಮ್ಮವ್ರು ಬರ್ದಿಲ್ಲಲ್ಲ ಇಲ್ಲಿ.
Minors, my lord, minor.
The peremptory order dated 28/1/2025. So far as response 2 and 3 is not complied. Therefore, appeal against response 2 and 3 stood dismissed. ಈಗ ಅದೆಲ್ಲ ಪಾಯಿಂಟ್ ಅವ್ರ ಮೇಲೆ ಎಲ್ಲಿ ಉಳಿಯುತ್ತೆ? If against them it is dismissed. There cannot be.
Nexus, my lord. The deceased himself, there was no nexus between the injury and the death. And he.
If the appeal is dismissed against response 2 and 3.
They are minors, my lord. Earlier, they were, my lord, served by substituted service. On 2/7, you lost my.
Counsel, why don't you understand? You
Yes.
said you seek appointment of guardian for response 2 and 3. You did not do that. Now appeal against them is dismissed. There cannot be two conflicting findings in one judgment. You say you are on the point of liability.
Well,
It cannot be different against them.
Question of, my
Dismiss
lord,
the appeal against others also then.
it is only apportionment, my lord. If it comes to.
ನೀವು ಹೇಳಿಲ್ವಲ್ಲ ಲಾಸ್ಟ್ ಟೈಮ್ ನಾವು ಪ್ರೀವಿಯಸ್ ಆರ್ಡರ್
The mother.
ಅರ್ಥ ಆಗಿರುತ್ತೆ ಆಗಿರೋದಿಲ್ಲ ಮತ್ತೆ ನಾನು ಕೌನ್ಸಿಲ್ ಪಡೆದಾದ್ಮೇಲೆ ಅಪ್ಪೀಲ್ ನಿಮ್ಮದನ್ನು ನೋಡಿ ಗ್ರೌಂಡ್ ಸೇಲ್ ಮಾಡೋಣ. DL ಏನು DL ಇರ್ಲಿಲ್ಲ ಅಂತನಾ? ಪ್ಲಾಂಟಿಂಗ್ ಆಫ್ ದ ಡ್ರೈವರ್ ಅಂತಾನೆ. The impugned awarded challenge questioning the liability of the appellant insurer. When appeal against the response 2 and 3 is dismissed, there cannot be dismissed. The order of the tribunal becomes final against in respect of those respondents unless therefore there cannot be any different view against the other claimants. That is claimant, I mean respond number 1, 4 and 5, no? 4 and 5. Now we have to dismiss the entire appeal if you do not do the needful.
But I have sent the, my lord, as per your lordship, this thing, I sent the application for appointment of a guardian.
Is your in-house this thing?
Time may be extended, my lord. I'll try again.
As requested by the appellant's counsel, as a final chance, list on appeal against other respondent does not sustain ಅಂತ ಬರ್ದಿಲ್ಲ
25-2.
Great.
Seal number 14, Murliyam.
Appellant, my lord. 2 years, my lord. Condone the delay and recall the order for compliance of
2019 ಅದು.
Yes, please.
ಅಲ್ಲ ಅದಾಯ್ತು. ಎಷ್ಟಿದೆ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ಸ್?
8 objections, second set.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಟ್ಟಿಲ್ವಾ? ಏದ್ ಸೆಕೆಂಡ್ ಸೆಟ್ ಆಫ್ ಅಪೀಲ್ ಪೇಪರ್ ಕೊಟ್ಟಿಲ್ಲ.
Yes, please, ma'am. I'll submit within week, madam.
As a precondition for consideration of IA 1 and 2 of 2023, pending of office objections on the appeal shall be complied within 10 days. 1 week ಅಲ್ಲ 10 days ಕೊಡ್ತೀವಿ. ಮಾಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ application dismiss ಆಗುತ್ತೆ.
Please.
Failing which IA number 1 and 2 of 2023 shall stand dismissed.
Bill number 15, Murliyam, same one, you 10 objections.
Connected.
Same.
Connected ಅಂದ್ರೆ arising out
Two
of same.
petitions, same incident filed another petition.
ಅದು ಕೊಡಿ ನೋಡೋಣ. ಇನ್ನೊಂದು ಅಂದ್ರೆ ಕನೆಕ್ಟೆಡ್ ಇದ್ರೆ ಈಗಲೇ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಬರುತ್ತದೆ. ಇದು MEC 395 of 2016.
ಹೌದು.
ಇದು MEC earlier matter.
Two MEC petitions filed before, was filed before the
396.
same incident.
Accident is same.
Same.
ಹಂಗಂದ್ರೆ ಇದೆರಡು ಒಟ್ಟಿಗೆ ಮಾಡ್ಕೊಳ್ಳೋಣ. ಕನೆಕ್ಟ್ ಮಾಡಿ ನಾನು ಅಷ್ಟು ಯಾವ್ದು 14 and 15. These two are appeals arise out of the same accident. Therefore, they are connected to each other. Adadmele at request finally 10 days time is granted. Sorry, at request pending consideration of mother ಹೇಳಿದ್ರೆ failing which ಎರಡರಲ್ಲೂ ಅಷ್ಟೇ I 1 and 2 shall stand dismissed. Yes. 10 days.
Bill number 16, Harish HV, Govind Rai Kamath K.
Here for the respondent wife. Apart from pending IAs, I have presented belatedly cross objection. Initially, it was 2 GNWCs filed by wife and husband. Both of them were clubbed together, and his petition was dismissed and my petition was allowed. Therefore, he has come in an appeal, and I have filed belatedly cross objection. So,
Copy serve ಮಾಡಿದೀರಾ last time?
copy serve ಆಗಿದೆ.
Instead of appearing in this, my lord.
ಹರೀಶ್ ಅದರಲ್ಲಿಂದ 16.2 ನಲ್ಲಿ acceptance of ವಕಾಲತ್. Miss, what do you say for condonation of delay and cross objections?
My lord, 200 and odd days, my lord. They had entered into and filed wakalat here and they were watching. And my lord, they are aware. And later, my lord, after nearly 26 days, my lord, they filed this cross objection. My lord.
Husband and wife.
Husband and wife,
How old is the child?
my lord, 8 years old, my lord.
Now 9 years.
9 years, 23/1/2016.
Child is with who?
Child is with the mother.
Mother. I appear for mother.
Bangalore.
Also.
Bangalore.
Mother, my lord,
Bangalore.
Also.
Bangalore.
Yes.
And my lord, mother filed a petition for divorce.
Father has visitation right?
My lord, visitation rights are given, but my lord, from past,
What is the visitation right?
my lord, visitation rights that 2 hours every week, every Sunday. And my lord, on birthday 5 to 7:30.
Is it going on?
No, my lord.
Yes.
Virtually, my lord, it is not.
Great.
It's going on, madam.
It is not. I'll file an affidavit to that extent.
So whether it's going on or not is also a dispute to be adjudicated.
Yes, lordships. Because my lord,
Apart from the main matter.
apart,
Just for both of.
All right.
lord, the child
No,
is,
no, just to understand the scope.
it is true, lordships. On merits, my lord, it's different aspect altogether. When they go, my lord, even in the weekends,
Why
my
4
lord,
cases?
child,
ಅಲ್ಲ ಎರಡು visitation ಇದೆ.
my lord, one filed by father, one by mother, my lord.
ಅದು ಬಿಟ್ಟು ಇದು ಒಂದೇ ಅಂದ್ರೆ substance is one. One was filed by the mother.
What has happened to the marriage?
ಅಲ್ಲ ಇಲ್ಲಿ
Whereas
prostrate
Dismissed.
petition
it-
filed by wife
decreed.
for divorce is dismissed. And my lord, counterclaim filed by husband is allowed, lord.
That orders attain finality.
That has attained finally.
Yes, ma'am. Yeah. They are living separately.
Wife
Yes,
also filed for divorce.
Wife filed a petition for divorce and subsequently, my lord, amendment was made by husband and
What was the counterclaim of the husband?
counterclaim for divorce.
23.
Then the court, my lord, dismissed the claim of the wife and allowed the claim of the
What was
husband.
the ground for a divorce?
My lord, the ground for divorce is cruelty.
Wait,
By her, my lord, is dismissed, holding that
proceedings have attained finality.
attained finality, lordships.
21,
Was not challenged by the
They are
wife.
not challenged by anybody.
2021.
Though earlier I had filed restitution petition, my lord, only two things, my lord, in this case. Whether the order passed by the court, my lord, is just and proper, because only summer vacation and no other vacations are given. And that too, my lord, 2 hours on Sundays time is given. I need to go approach the doors. My lord, the child is not coming. They are tutored, my lord, the child is not coming. In spite of many, my lord, second thing is, my lord, whether this, can there be a joint parenting, my lord? Both of them, husband and wife, my lord, they are fighting and ended up in a divorce. They both are happy. Now, my lord, father wants to even to meet the child also, my lord. That's not happening. Forget about the decree passed by the court.
Both are not happy. You're trying to ensure the others are happy.
The specific
My lord.
performance, specific relief act, there is a one provision.
Lordships.
Allah, adandre, sorry, an agreement which needs continuous monitoring cannot be specifically enforced anta. ಹಾಗೆ ಇದು ದಿನಾಲು ಅವ್ರ ಮನೆಗೆ ಅವ್ರು ಹೋಗಿ ಬಂದ್ರ ಇವ್ರು ಹೋಗಿ ಬಂದ್ರ ನೋಡೋದು ಯಾರು?
Lord, if both of them, my lord,
Some way.
if both of them understands in the best interest of the child, that would suffice, my lord. It's not that, my lord, father is taking the child or forcibly or something like that.
IAS ಎಲ್ಲ ಇದೆ ಅದನ್ನ ಮುಗಿಸ್ಕೋಬೇಕು. IAS ಅಲ್ಲ ಇದು. ಮೊದಲು will do this delay condonation and acceptance of wakalat other
My
things.
lord,
Then both
I
of
mean,
you keep the child also present, you be present one day.
Yes, my lord. Yes, my lord.
please, my
Yeah.
Then
That will also help me, my lord, because I am not coming in the way and I have been categorically advising the child.
But-
It's the child who is refusing. If this honorable court comes to my rescue,
See,
I will
arrangement
definitely
is
go by the words.
Simple. Fix a date, parties present, child present. You'll have an order of
this
during the pending the appeal one interim arrangement.
26
Then appeal will be
days
heard.
delay also will condone.
my lord, I may not object for all that.
Anyway, because she is
I go by
No.
anything this honorable court says.
My lord, even I am not even filing objections. I'll leave it to this court, lordships.
16.1 ಅಲ್ಲಿ ವಕಾಲತ್ ಆಫ್ ಶ್ರೀ ಹರೀಶ್ HV for respondent is taken on record. ಅದಾಯ್ತಾ? Then 16.3 ನಲ್ಲಿ orders ಅನ್ನಯ್ಯ 1/2023. ಏನ್ ಹೇಳಿದ್ದಾರೆ ರೀಸನ್?
The reasons, if we go strictly by reasons, my lord, they may have to file better affidavit.
ಡಿಲೇ
In respect of
Give me the
16
delay.
and 16.
delay, my lord, what? There was a change in counsel. So we were NVC advocates. She was not advised to file a cross objection. So subsequently it was filed. Yeah, it was overlooked, my lord. Yeah, it's a humble.
Ignorance of law is saying, and
ಇದು
so she suffered because the order was passed,
orders on
visitation rights was given.
16.2, 16.3 ಎರಡರಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. Orders on I number 2 of 2023 in MF crop 42 of 2023 and 1 of 23 in MF crop number 43 of 2023. Third both side, considering reasons assigned to explain the delay. Delay up to 26 days in filing the appeal is condoned in the interest of justice. The above applications are disposed of accordingly. Okay. On hearing both side, 16 to 16.3 only. It is found appropriate to interact with the child and the parties. Therefore, parties and child shall be present before the court on
24th, can it be, lordships?
No, beyond that, beyond 26th, I will not be.
Why, man?
Yeah, 26th I may need.
26th ಆಗ್ಬೋದಲ್ಲ beyond
26th, I think.
So 26th is a holiday.
27 or 28.
27th. 27 at 1:30.
At 1:30, lordship.
1 ಗಂಟೆಗೆ ಬರಕ್ ಹೇಳಿ ಇಲ್ಲ ಅವ್ರು.
Please.
Yes, ma'am.
Both of them are residing Bangalore.
Yes, ma'am.
Yes, lordships.
ಯಾವತ್ತಾಗುತ್ತೆ? ಸ್ಕೂಲ್ ಏನಾದ್ರು ಇದೆ ಈಗ ಎಕ್ಸಾಮ್ ಬರ್ತಾ
ಇಲ್ಲ,
ಇರುತ್ತಲ್ಲ.
We'll manage.
Standard, lordship.
Third standard.
27. ಒಂದ್ಸರಿ ಸರಿ 27th ಅಲ್ಲ ಅವ್ರಿಗಾದ್ರೂ ಎಕ್ಸಾಮ್ ಇರುತ್ತೆ ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇದೀವಿ ಅಷ್ಟೇ.
I may have to ascertain. If there is anything, I will keep my colleague informed. If there is an examination, otherwise he will definitely come.
ಹೀಗ್ ಮಾಡಿ ಎಕ್ಸಾಮ್ ಇದ್ರೆ ಅದ್ರ ಬದಲು ಒಂದ್ 4 ಗಂಟೆಗೆ ಬರಕ್ ಹೇಳಿ ಅಷ್ಟೇ.
ಆಗ್ಬೋದು sir. ಆಗ್ಬೋದು.
Keep it up at 1:30 lordships. If has any inconvenience to the child.
Both of you can speak.
We'll keep the court informed. Definitely.
ಯಾವ್ದ್ರ ಟೈಮ್ ಕಮ್ಮಿ
Much.
27th.
Apart from this,
Yes.
at the intervention of both of you all,
Hmm.
agree on an amicable arrangement. Otherwise, you will land up with an order which both of you are unhappy with.
Yes, ma'am.
Okay.
Yeah,
And
I go by that.
Child needs access to both parents. Please keep that
Definitely,
in mind.
definitely, madam. Yes.
Child cannot grow up with only
Single
access to one
parenting, not
parent.
for-
May be having many apprehensions in the minds of each of other
Have any
parties.
apprehensions, you
Malad,
place
we'll
it-
work it out.
If you have any apprehensions, you place it on record in some form that can be addressed. But
Well,
arrangement, try to make it amicable
Definitely.
One,
Yes.
till the next day.
Definitely.
ನೀವು ನೋಡಿ ಮಾತಾಡಿ.
only one submission, my lord. What they say is, I don't want to say anything on merit, my lord.
ಬಿಡಿ. ನಾವು ಹೇಳೋದು ಹೇಳಿದ್ದೀವಿ.
We'll definitely,
They say child is not ready, child is not willing.
ಒಂದ್ ನಿಮಿಷ ಕೇಳಿ.
we'll definitely report, madam. I got that, madam.
ನೀವು we know that even if you say the parties will be having their own
Yeah,
views,
Definitely.
but if you try to advise them, at least to some
Make an
extent,
endeavor.
work.
Perfect.
No,
Till
destroy.
before the next day, try to
Definitely.
see what progress you all can make.
We shall try our level best.
Definitely.
Lordships.
You are helping both of them, more particularly the child.
It is true, lordships.
27-2. Number 17, VC Shivanegoda, Nayak Krishna.
I have filed the application, paper publication, Samyukta Karnataka, Bangalore.
Yes, R4 is the owner.
Please. Yes.
ಏನಂತ ಬಂದಿತ್ತು ಹಿಂದೆ? Insufficient redress. Trial court ಅಲ್ಲಿ they had contested or not?
Yes, not contested. Not contested.
Next party na?
Yes, have.
By pleader
ಇಲ್ಲ,
case ಇದಾರೆ ಯಾರೋ ಇದಾರೆ.
Contested, KSG.
ಎಲ್ಲಿ ಅಡ್ರೆಸ್?
Bangalore,
Bangalore. Which paper you want to take?
Samyukta Karnataka, Bangalore edition.
Lesson I number 1 of 2025. Third, we are satisfied that service of notice on respond number 4 in the ordinary course is not probable in the near future, and she is evading the notice. Therefore, the appellant is permitted to take notice to respond number 4 by publication in Samyukta Karnataka Kannada daily newspaper Bangalore edition as paid for. Notice shall be published on or before
11-3,
11/3, notifying the hearing date as
1-4.
1/4. I number 1 of 2025 is disposed of accordingly. List on 1/4.
Much.
Till number 18, Pawan Chandra Shetty.
My lordship.
862%.
My lordship, we have complied the office objections, my lordship.
Applied ಅಂತ ಬರ್ದಿದೆ. You filed it in 2022 application. 2023. So 1 year ಬೇಕಾಯ್ತಾ? IA ಮೇಲಿನ objection ಅನ್ನು ಮಾಡ್ಕೊಳ್ಳೋಕೆ. United India Insurance Company. Interest delay ಮಾಡ್ಬೇಕು ನಾವು. 2 ವರ್ಷ 3 ವರ್ಷ if you keep it pending for recalling, why they should pay the interest if you succeed?
Apologies, my lordship.
Orders on I number 1 of 2023. The records show that, heard the appeals also. Records show that there is delay in filing the appeal also. How much delay is there? 208 days.
Yes, my lordship.
There is 208 days delay in filing the appeal itself. Though the appeal was filed in 2022, the office objections were not complied. Therefore, by order dated 8/6/2023, the appeal was dismissed. The above application is filed to recall the said order. For the fault of the appellant, the respondents cannot be compelled to pay the interest for during the pendency, for the delay occurred during the pendency of this appeal. However, considering the reasons assigned, the order dated 8/6/2023 dismissing the appeal is recalled with a condition that if the appellant succeeds, he shall not be entitled to interest on the enhanced compensation for the period. Appeal is filed on 19th October. 19/10/2022 till this date. Okay. IA ಎಷ್ಟಿದು? 1/23 is disposed of accordingly. ಈಗ notice ಕೊಡ್ಬೇಕು. Why you do like this? ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಮಾಡೋದು ಹೇಗೆ?
Any other connected matter?
No, my lord.
Two claim.
United
Only one appeal?
Yes, my lord.
ಯಾರಿದ್ದಾರೆ? ಯುನೈಟೆಡ್ ನವ್ರು ಯಾರಿದ್ದೀರಾ? ಯಾರು ಇದ್ದಾರೆ? ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇನ್ಶೂರೆನ್ಸ್
GS Marlaya.
GS Marlaya, lawyer standing counsel for respondent 3 is direct to accept notice for respondent number 3. ಅದೆಲ್ಲ ಮಾಡ್ಕೊಂಬಿಡಿ. ಏನ್ ಉಳಿದವ್ರಿಗೆ ನೋಟಿಸ್ ಹಾಕ್ಬೇಕಾ? What is the order?
My lordship will file the dispensation in the counter.
R1 and 2.
R1 and R2, my lordship.
So, lawyer counsel for the appellant submits memo for dispensation of notice to respondents 1 and 2. This is MVC number 242, ಅಲ್ಲ? 1,82,630. 9% interest. 1, 2, 3 are joint R3. Whether include award, the liability to pay compensation is passed to respondent number 3, the insurer. Therefore, notice to respondent number R2 exported. 1 and 2 is dispensed with as paid for. Okay. ಎಷ್ಟು ಡಿಲೇ ಇದೆ ನೋಡಿ ಇವ್ರೆ. ಆಮೇಲೆ ಹೇಳ್ತೀರಾ? ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
Number 90.
ಆಫೀಸರ್ ಮಾಡ್ತಾರೆ.
Mushtaq Ahmad.
ಎಲ್ಲ ಬರೀ ಇವತ್ತು ರಿಕಾಲಿಂಗ್ ಆಫ್.
Lord, I am representing Mushtaq Ahmad.
ಹ್ಮ್.
ಏನೋ ರಿಲೇಟಿವ್ ಏನೋ ಎಕ್ಸ್ಪೈರ್ ಆಗಿದಾರಂತ ನಾಟ್ ಇನ್ ಸ್ಟೇಷನ್ ಮೇಲೆ 1 week accommodation. IFR recalling application. Non-compliance of office objection ಮೇಲೆ ಡಿಸ್ಮಿಸ್ ಆಗಿದೆ. ಕಂಪ್ಲೈ ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳಿದ್ರು.
ಅಪೀಲ್ ಫೈಲ್ ಮಾಡುವಾಗ 128 days ಡಿಲೇ. ಮತ್ತೆ ಈ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕೊಳ್ಳುವಾಗ
ರೀಕಾಲಿಂಗ್ ಹಾಕ್ಬೇಕಾದ್ರೆ ಡಿಲೇ ಆಗಿದೆ.
169 days ಡಿಲೇ
ಆಗಿದೆ. ವಿತೌಟ್ ಇಂಟ್ರೆಸ್ಟ್ ಅಂತ ಡಿಲೇಡ್ ಪೀರಿಯಡ್ಗೆ ಮಾಡ್ಬೋದು. ನಾಟ್ ಎಂಟೈಟಲ್ಡ್ ಫಾರ್ ಇಂಟ್ರೆಸ್ಟ್ ಫಾರ್ ದಿ ಡಿಲೇಡ್ ಪೀರಿಯಡ್.
1 and 2 of 2023. There is a delay of 128 days
ಹೌದು.
in filing the appeal itself. Further,
162.
for non-compliance of the office objections, the appeal was dismissed on T3/2023. The above applications are filed to recall the said order and condonation of delay of 169 days in filing such recalling such application for recalling. Case of death ಇದು.
ಡೆತ್ ಪೆನಲ್ಟಿ.
Same for the fault of the appellants, respondents cannot be compelled to pay the interest for the delayed period. Therefore, however, considering the reasons assigned to explain the lapses, the order dated, the order delay ಆಗಬೇಕಲ್ಲ ಮೊದಲು. Delay of 169 days in filing IA 1/2023 is condoned. And yeah, 169 in filing IA 2/2023 is condoned. The order dated 3/3/2023 dismissed and the appeal for non-compliance is hereby recalled with a condition that if the appellants succeed, they shall not be entitled to interest on the enhanced compensation for the period 6/12/2022 till this day. Till this number 1/2022 or 23 ಅಲ್ಲ 1/2023 are disposed of accordingly. ಇದ್ರಲ್ಲಿ ಯಾರಿದ್ದಾರೆ? ಅವರೇ ಮರಳ ಯಾರಿದ್ರಲ್ಲ ಇದ್ರ PB Raju ಎಲ್ಲಿ? ರಾಜು, you are there for United PB Raju?
ಶಂಕರಡಿ PB ರಾಜು ಸರ್, ಅವರು PB ರಾಜು ಸರ್ ಇದ್ದಾರೆ. ಯುನೈಟೆಡ್ ಇಂಡಿಯಾ ಇದ್ದಾರೆ.
ಜೂನಿಯರು ಇದಾರ?
PS Jagdish.
Jagdish
ಆಯ್ತು ಬಿಡಿ ಅವ್ರಿಗೆ.
Jagdish Ila, United India. Raju sir.
ಯಾರಿಗೆ ಕೊಡೋಣ, ಸೀನಿಯರ್ ಕೊಡೋಣ, ಜೂನಿಯರ್ ಕೊಡೋಣ? ಜೂನಿಯರ್ ಇಲ್ಲ. ಬರ್ಕೊಳ್ಳಿ. ಶ್ರೀ ಪಿ ಬಿ ರಾಜು ಲಾಯರ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 is directed to accept notice for respond number 2. Respond number 1 ಏನು?
ಅದು dispensation memo, in case liability admitted, I will file dispensation.
ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ವಾ ಅದೇನ್ ಮಾಡಿ?
ಇಲ್ಲ, papers ಕೊಟ್ಟಿಲ್ಲ, ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಹೇಳಿದ್ರು.
ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 list on
28-3.
ಮುಚ್ಚೋಬ್ಲೆ.
Seal number 20. Nagratna S.
ಏನಂದ್ರೆ ಇಂಥದ್ದು ಈ ಸರಿ ನೀವೇ ಕೊಡಿ.
Ananda S.
ಇರಲ್ಲ ಇದ್ರಲ್ಲಿ ಹಾಗಿಲ್ಲ. Delay in filing the
7 days deal.
Shivanand. ಏನಿದೆ? What is the order first?
For restitution of conjugal right. Degree of restitution of conjugal.
Section 9 petition is allowed.
Yes, sir.
Is delay condone ಮಾಡ್ಬೋದಲ್ಲ?
ಮಾಡ್ಬೋದು. Yes, ma'am. Condone.
Why are you not willing for this restitution?
Restitution of conjugal.
Correct. Why are you agreed by that order?
She is actually not interested in going back, and it was hotly contested before the court became allowed.
Correct.
The thing is, she could not appear
She has
for giving her
initiated-
evidence.
She has initiated any proceedings? ಯಾವ್ದಾದ್ರು ಅಲ್ಲಿ ಎವಿಡೆನ್ಸೇ ಮಾಡಿಲ್ಲ ಅವರು.
ಅಲ್ಲ, ಅವ್ರು ಮಾಡಿಲ್ಲ ಸುಮ್ಮನೆ. She was not able to.
Submission, my lord.
At point of time.
After this decree, the husband filed a decree of divorce. The decree of divorce is granted.
ಅಲ್ಲೂ ಎಕ್ಸ್ಪರ್ಟೇನಾ?
Ex parte.
ಮತ್ತೆ ಎಕ್ಸ್ಪರ್ಟ್ ಆಗಿದ್ರೆ
But the court sent a notice, but
she had appeared and not contested. ಆ ಕೇಸಲ್ಲಿ
ex parte, place ex parte.
evidence
It didn't appear.
contested ಅಂದ್ರೆ she has not let in the evidence. Effectively contested ಅಂತ.
You are aware of the divorce?
No, we are not aware. The party has not told me.
Yes, I'll show the copy.
ಎದುರುಗ ಅಲ್ಲಿ ಇನ್ನು ಆರ್ಗ್ಯುಮೆಂಟ್ಸ್ ಮಾಡಿಲ್ಲ ಯಾವುದೇ
She has
ನೋ ವಿಟ್ನೆಸ್ ವಾಸ್
a baby. She has a baby.
ಅದೇನು ಅದ್ರ ಮೇಲೆ ಅಪೀಲ ಬರ್ಬೇಕಲ್ಲ ಇನ್ನೊಂದು.
Yeah, ಇದಾದ್ರೆ I'll make a confirmation with my party. I don't know whether she was served with this or not.
ಕರೆಕ್ಟ್. ಆರ್ಡರ್ಸ್ ಐ ಒನ್ ಆಫ್ ಅದೇನು ಏನ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ನೀವು ಕಾಪಿನ?
Copy ಕೊಡಿ.
ಅದನ್ನ ಕೊಡಿ.
Degree of divorce copy ಸರ್ವ್ ಮಾಡಿದ್ವಿ ಅವ್ರಿಗೆ ಕೂಡ.
ಹೀಗೆ ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
ಒಂದು
ದೊಡ್ಡಬಳ್ಳಾಪುರ. Now counsel correspond to the middle work, sorry, number comment. Now counsel correspond submits memo along with copy of the judgment in MC number 12 of 2023. Passed by the additional senior certificate. Expert temporary.
Expert.
Dodaballapura. Now counsel for the appellant submits that she has no instruction.
No, I don't have any instruction on this
Appellate
because she
is-
is not informed me about this, my lord. She's not informed. I'll just make an confirmation and I'll submit on
Anna
that.
Mera, the judgment in MC 12 of 2023. Orders and I number 1 of 2023. The judgment produced by the response counsel shows that judgment in MC number 1 of 2023 produced by the response counsel that was an expert decree. Considering the reasons assigned. ಇದರಲ್ಲಿ ಮಕ್ಕಳಿದ್ದಾರೆ, ಮಕ್ಕಳು ಅವ್ರ ಜೊತೆಗೆ
ಒಬ್ಬ ಮಗ ಇದ್ದಾನೆ.
assigned to explain the delay of 7 days in filing this appeal is condoned in the interest of justice. Admit all parties yes, interim stay of the interim decree, fill further orders. I number, I don't need a state 1 of 22.
One of
Where was that? ಮತ್ತೊಂದು ಕರೆಕ್ಷನ್ಸ್. Where is the application? Record ಅಲ್ಲಿ ಹೇಳಿದೆ. Orders and I one of the is disposed of accordingly. List after the, ನಾನು ಡೇಟ್ ಇಲ್ಲ ನಾ ಫಾರ ಬಿಟ್ಟು. Meanwhile, you can check that.
21,
Meanwhile, you can check that. What is the position?
21-3. Till number 21, C.R. Ravishankar, Vinay Bhatt for R1 to R3.
I use one folder. Documents.
Plain. The petition under 163A. Son died, father is the respondent. And there is no PA coverage also. And question of maintainability of the petition is not end. 17 ಲಕ್ಷ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅಲ್ಲ ಅದೇನು ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವು
ಲಾಸ್ಟ್ ಟೈಮ್ ಹೇಳಿದ್ರೆ ಅದಕ್ಕೆ ಎಲ್ಲ ತಂದಿದ್ದೀನಿ ತಾವು
ಯಾವ್ದದು ಕೊಡಿ
ಇದು ಜಡ್ಜ್ಮೆಂಟ್ ನಿಂಗಮ್ಮ
ಕೊಡಿ
ಅಂಡ್ ಆಲ್ಸೋ ಇದು ದೆನ್
ಯಾವ್ದು ಕೇಸಲ್ಲಿ ಬೇಕಾದ್ರೆ
Yes, we rely upon the Scandia insurance, especially relating to the when
ಯಾವ್ದು ಲಾರ್ಜರ್ ಬೆಂಚ್ ಯಾವ್ದು ನೋಡೋಣ ಏನು ಕೊಡಿ ಅದು ಎಲ್ಲಿದೆ ಜಡ್ಜ್ಮೆಂಟ್
ಸುನಿಲ್ ಕುಮಾರ್ ಅಲ್ಲಿ ಬಂದಿದೆಯಲ್ಲ, ಸುನಿಲ್ ಕುಮಾರ್ 3 judge bench followed by one more.
ಅಲ್ಲ ನೀವ್ ಹೇಳ್ತಿರೋ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ
ಇದೊಂದಿದೆ ಮತ್ತೆ ನಿಂಗಮ್ಮ ಒಂದಿದೆ ಅದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಒಂದು ಮತ್ತೆ ಆಶಾಲತಾ ಅಂಡ್ ರಾಮ್ ಕಿಲಾಡಿ.
ಹೌದು ಇಲ್ಲ ಅಂದ್ರೆ ನಾವ್ ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ನಮ್ಗೆ ಬೇಕಾಗಿತ್ತು ಹೌದಾ ಇದೇ ಕೇಸಲ್ಲಿ we try to see ಅಲ್ಲ ಇದು
ಸೀಕ್ವೆಂಟ್ ಬಂದ್ರೆ
ಗೊತ್ತು ನನ್ ಲಾಕ್ ಇದೆಲ್ಲ answer the question holding that in a proceeding under section 168 is not open for mention to raise any defense of negligence on the part of the ಅಲ್ಲ negligence they cannot raise ಆದ್ರೆ ಅವ್ರದೇ ಆಕ್ಸಿಡೆಂಟ್ ಇದ್ರೆ ಯಾವ್ದು ಕೊಡಿ ನಿಂಗಮ್ಮ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ
ಅದು ಲಿಸ್ಟ್ ಮಾಡ್ತೀನಿ.
ತಗೊಂಡ್ ಬಂದಿಲ್ಲ.
My lord, if lordship permits, only the few points on this particular case. The reason why specific
ಕಾಪಿ ಕೊಡಿ ನಿಮ್ದಾದ್ರು
we given,
ಅವ್ರದ್ದು ಒಂದು ಕೊಟ್ರು ನಮ್ಗ್ ಕೊಡ್ಬೇಕಲ್ಲ ಇಬ್ಬರಿಗೆ.
I have the second copy.
They want themselves to be enlightened.
No, lordship, it is not like that. I have only 2 copies, so I just want to pass it out once I make a submission. Why we particularly relied this particular case, the facts of this case almost similar to the fact.
1987.
Yes, lordship, the reason is, in this particular case in hand, the driver of the vehicle who put the keys.
Citation ಆದ್ರೆ ಹೇಳಿ ತೆಗಿತಾರೆ ಅದನ್ನು ಮಾಡೋದಿಲ್ಲ ನೀವು.
ACJ 2009 page 2020.
ಈಗ ಇಬ್ರು ರೆಡಿ ಇಲ್ಲ ಅಂದ್ರೆ ಇನ್ನೊಂದ್ ದಿವಸ ತಗೊಳ್ತೀವಿ ಅಷ್ಟೇ.
ಅಲ್ಲ ಇದು ಕವರ್ ಆಗಿದೆಯಲ್ಲ ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ಅಂತ ಹೇಳಿ ನಾನು ಐ ಥಾಟ್ ಕೊಡ್ತೀನಿ.
ಸೀನಿಯರ್ ಹೇಳೋರು ಯಾವಾಗ್ಲೂ ಸ್ಟಾರ್ಟ್ ವಿತ್ ದ ಪ್ರಿಮೈಸಸ್ ದಟ್ ಜಡ್ಜ್ ನೋಸ್ ನೋ ಲಾ.
ಆಯ್ತಾ ಗೊತ್ತಾಯ್ತು ನಿಮ್ಗೆ ಹೇಳಿದಿರಾ ಆದ್ರೆ ಇದು 2 ಜಡ್ಜ್ಮೆಂಟ್
ನೀವು ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು.
ಡೆಫಿನೆಟ್ಲಿ ಐ ವಿಲ್ ಡೂ ಇಟ್ ಇಲ್ಲ ನಾನು ತಪ್ಪು ತಿಳ್ಕೊಬೇಡಿ. ಆಮೇಲೆ ಈವನ್ ಅದರ್ವೈಸ್ ಇಲ್ಲ
ನಾಟ್ ರೆಡಿ.
That if lordship permits, I just want to make one submission relating to this particular case we already handed over to the court. The reason is, in the particular Scandia's case, the driver puts the key and leaves the vehicle there, and the cleaner who doesn't have a license had moved the vehicle when he was not occupied the seat. The accident is happened. The person who moved the vehicle doesn't have a DL. That is the reason the claim of the insurance company has been considered that the owner of the vehicle is violated the condition. But by looking into the entire evidence that is deposed before the MACT, the owner of the vehicle who was undergone an eye operation and is lying in the bed, and he has nowhere been handed over the vehicle to his son. He is totally independent.
Case is very simple.
Yes, lordship.
Case of self-accident.
Yes.
Due to the negligence of the rider.
Yes.
Covered under 163A.
That is that.
Covered Nivadi. You all don't place the judgment on record unnecessarily.
ಅಲ್ಲ ಈವನ್ ಯುವರ್ ಶಿಪ್
They're all not new legal positions.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಯುವರ್ ಶಿಪ್ ಈವನ್ 163A ನಲ್ಲಿ ಫಾದರ್ ಈಸ್ ದಿ
All arguments in the air.
Self accident. It is.
Yes, lordship. This is the
Covers are not ಅಷ್ಟೇ.
that is why I'm saying
ಕೊಡಿ ಅದು ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ. As requested by both sides.
Lingam again.
It's done.
ACJ 2009, 2020.
2 weeks ಬಿಟ್ಟು ಹಾಕೊಳ್ಳಿ ಅವ್ರಿಗಿಬ್ರಿಗೂ ಅರ್ಜೆಂಟ್ ಇದ್ದಂಗೆ ಕಾಣೋದಿಲ್ಲ.
ACJ 2020.
ಅದೇನ್ ಕೊಡೋದಿದ್ರೆ ಇಲ್ಲ ಒಂದು ಮೆಮೊ ಹಾಕಿಕೊಡಿ.
2020, 2009. ನಿಮ್ದು ಯಾವ್ದು?
22.
Candiate.
Manjunath
Milord,
Respondent,
I represent the appellant, Milord.
I seek 1 week time for filing objection, my lord.
Milord, on the last date of occasion also, Milord, the very same submission was made. Time was granted for the respondent to file objections.
Interim application by respondent. ಏನಾದ್ರು ಸ್ಟೇ
I seek,
ಗ್ರಾಂಟ್ ಇಂಟೀರಿಯಂ ಸ್ಟೇ ಅಷ್ಟೇನೆ.
I seek
Milord,
1
interim
week.
order is granted, Milord. Interim order is granted. There is an order, Milord, already.
What is the decree passed here?
Milord, decree of divorce was granted in favor of the husband.
Objection will be interim application before next day.
Last time also, Milord, the time was granted in order to file objections.
PCR ಯಾವಾಗ 2023 ಅಲ್ಲಿ.
Milord, on 4/8/2023, Milord, this honorable court has granted stay, Milord, stay of further.
With liberty to seek modification and extension.
No, Milord, I have sought for maintenance, Milord. Application under section 24 of Hindu Marriage Act is filed.
1 of 2023 is for stay.
Please, Milord. Milord, on 4/8/2023, Milord.
ಅದೇ ನಮ್ಮವ್ರು ತಪ್ಪು ತೋರಿಸಿದ್ದಾರೆ ಅವ್ರು ಹೇಳೋದು ಅಯ್ಯೇ 1 of 2024
Please, Milord.
the record shows it 4/8/2023 ಗೆ
Please, Milord.
ಅಯ್ಯೇ ಅವರು ಡಿಸ್ಪೋಸ್ಡ್ ಆಫ್ ಅಂತ ಹೇಳಿಲ್ಲ ಅಂತ. Absolute interim stay was granted on 4/8/2023 itself. However, there was no specific observation that IA 1 of 2023 is disposed of. The said interim stay is operating for all these days. Therefore, extending in view of making it clear that there is absolute stay, IA 1 of 2023 is disposed of. Absolute stay of decree in question. The interim decree, IA 1 of 2023 is disposed of.
Milord, IA 1 of 2024 is filed.
Earlier any
Please, Milord,
Granted.
7,000 granted during pendency of the petition before the family court, Milord.
There are several cases filed for 125 also filed.
Till disposal of the proceeding before that.
No, in 125 also granted.
Before
Petition filed under 125 also maintenance was granted. In the 24 also they granted file, still it is pending.
You say 7,000 was granted in the matrimonial case. That
Please,
was
Milord.
Apart from that, in 125 proceedings also granted.
now why he has filed is there was no permanent element is not granted.
No, Milord, permanent alimony is not granted in
sought
favor of
that?
me. No, Milord, I did not seek that relief.
Opposed to this decree, I mean.
Please, Milord, please, Milord. Please, Milord.
Not
Milord,
filed.
she has a college going female child. Milord, if your lordship can peruse page
I'll
number
file-
7.
I'll file my objection.
Granted.
How much maintenance are you paying?
I think the 7,000, that's what I.
Milord, 125 proceedings, Milord.
ಅಲ್ಲ ಇವಾಗ ದೇ ಆಕ್ಚುಲಿ ಅವ್ರ ತಾಯಿ ನೋಡ್ಕೊಬೇಕು ತಂದೆ ನೋಡ್ಕೊಬೇಕು ಅದೆಲ್ಲ ಇದೆ.
Correct. ಎಷ್ಟು how much was granted before the tribunal trial court?
And
7,000.
7,000, Milord.
ಸ್ಟಿಲ್
In
ಅರಿಯರ್ಸೇ
125
ತುಂಬಾ ಇದೆ ಸ್ವಾಮಿ ಕೊಡಕ್ಕಾಗ್ತಿಲ್ಲ ಈಗ ಅವ್ರಿಗೆ.
proceedings also, Milord, 7,000 was awarded.
ಯಾವಾಗ ಯಾವ ಇಯರ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದದು?
Milord, in 125 proceedings, Milord, in the year 2020, Milord, 7,000 is awarded.
ಇದು 125 ನಲ್ಲ 7,000.
In 125 proceedings and also in the divorce proceedings, Milord, 7,000 each.
ಅದೇ ಟೋಟಲ್ 14,000.
14,000, please, Milord, please, Milord.
ಈ 7,000 ಮೆಟ್ರಿಮೋನಿಯಲ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದೆ ಅವಾಗ ಅಂತ ಅಂದ್ರೆ
Milord, that was awarded on.
ಅವ್ರಿಗೆ ಗೊತ್ತಿಲ್ಲ ಸುಮ್ನೆ ಹೇಳ್ತಾರೆ.
That's what I'll file my objection. ನಮ್ಮ ಪಾರ್ಟಿ ಬಂದಿಲ್ಲ ಸ್ವಾಮಿಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್. He is teacher by profession. One week time may be granted. Detailed objection I'll file it.
ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರು ಅಂತ ಹೇಳ್ಬೇಕು. ಯಾವಾಗ ಕೊಟ್ಟಿದ್ರು 7,000 ಮೆಟ್ರಿಮೋನಿಯಲ್ ಕೇಸ್ ಅಲ್ಲಿ ಇಬ್ಬರಿಗೂ ಗೊತ್ತಿಲ್ವಾ?
ಇಲ್ಲ ಇಲ್ಲ
That's what I'll.
ಹೇಳ್ತೀನಿ.
There is more than 3 years ಆಗೇನಾರ ಇದ್ರೆ ರಿವಿಷನ್
Milord,
ಮಾಡಬಹುದು. ನೀವು
Milord,
ರೆಡಿ
Milord,
ಇರಲಿಲ್ವಲ್ಲ?
with order dated
Whether he has deposited whatever is ordered to be paid now.
Please, my lord, that
And
amount is.
it was deducting in the salary deduction attachment ಆಗಿದೆ. Salary attachment ಆಗಿದೆ. Teacher. Hindi teacher, salary attach ಆಗ್ತಾ ಇದೆ.
Lord, in fact, my
One-third of
lord,
his salary is
he is
attached.
not paying the arrears of maintenance also. There is arrears of 5 lakh rupees. My lord, in spite of
One-third
filing
of his salary is attached.
several petitions seeking recovery of the arrears of maintenance, my lord, he is not paying.
Attachment of.
ಕೊಟ್ರು ಏನ್ ಪ್ರಯೋಜನ ಆಗುತ್ತೆ ಹಾಗಿದ್ರೆ? Have you filed
Madam-
execution case?
Please, my lord, several petitions are filed seeking executing the orders passed in 125 proceedings. My lord, in fact, my lord, I have mentioned in my affidavit, my lord, with regard to all those. If your lordship can peruse paragraph number 7, my lord, page 4.
Salary attachment was issued, it was attaching the salary, my lord.
Page number 4, paragraph 7, my lord.
But yeah, sought from the date of this appeal.
Please, my lord.
ಅವಾಗಿಂದ ಕೇಳಿದ್ದೀರಾ this 7,000? ನಾನು consent for response seeks adjournment. 6 times file counted to I1 of 2024. Despite granting sufficient opportunity, counter is not filed. As admitted by both sides, before the trial court, interim maintenance of 7,000 per month was awarded. ಈಗ ಮಗು ಮತ್ತು ತಾಯಿ
ಇಬ್ರು ಇದ್ದಾರೆ ಹೌದು.
age of the child?
Lord, the
Major.
age of the child is
She's
almost
studying in a degree. Degree she is studying.
she is doing her BCA.
The couple have a daughter who is staying with the appellant. Duty is there. Therefore, considering the aforesaid facts and circumstances, the respondent is hereby directed to pay interim maintenance of rupees 10,000 per month to the appellant, in addition to what is awarded in the proceedings under section 120.
My lord, actually is getting salary 35,000 only. In 35,000,
Date of order. The said maintenance
his salary itself is 35,000, my lord.
filing of IA1 of 2024 till further orders. IA1 of 2024 is disposed of accordingly. The main matter admit ಆಗಿದೆ.
It is admitted, my lord. It is admitted on 4/8/2023 itself.
CRS ಬಂದಿದೆಯಾ?
Please, my lord.
Hearing after 2 weeks.
Seal number 23, Shomoga Nagaraj HH, C. Shankar Reddy.
Consistently ಕೇಳ್ತಾರೆ. ಯಾವ ರಿವಿಷನ್ ಫಸ್ಟ್ ಮಾಡಬಹುದು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ.
For appellant, my lord.
This is connected with
Sheet non-filing of wakalat by advocate for R1.
paper.
234 days delay ಏನ್ ಹೇಳ್ತೀರಾ?
Delay may be conducted subject to delay.
ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
Yes.
ಡೆಪಾಸಿಟ್ ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ವಿ. I have informed the other side also.
ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಟ್ಟಿಲ್ಲ ಇನ್ನು. ಈ ಫಸ್ಟ್ ಕೇಸ್ ಅಲ್ಲಿ ತಗೊಳ್ಳಿ 23 ಅಲ್ಲಿ.
First case.
First case ಅಲ್ಲಿ I am for appellant. Only delay in this. Delay 234
234 days delay ಇದೆಲ್ಲ. Will deny the interest and
because it was not their knowledge, because due to their inhale he was
how can you say it? ಎಲ್ಲ 55 ವರ್ಷ 39 ವರ್ಷ 38 ವರ್ಷದ
ಅಲ್ಲ Girijamma is wife of the deceased.
they were all
Only
All majors.
heard. Orders and even considering the reasons assigned to extended delay of 34 days in filing the appeal is condoned in the interest of justice, with the condition that if the appellants succeed in the appeal, they shall not be entitled to interest on the enhanced compensation for the delayed period of 34 days. IA1 of 2023 is disposed of accordingly. ಇದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಇದ್ರಲ್ಲಿ ತರ್ಸೋಣ ಅಷ್ಟಕ್ಕೆ ಇನ್ನೊಂದು ಹೇಳಿದ್ರಲ್ಲ. ಇಟ್ ಇಸ್ ನೋಷನಲ್ ಇನ್ಕಮ್ ತಗೊಂಡಿದ್ದಾರೆ ಹೇಗೆ? 8,22,000. ಏನು ವಾಟ್ ಇಸ್ ದ ಗ್ರೌಂಡ್ ಆಫ್ ಚಾಲೆಂಜ್?
no, they are the deceased was agriculturist and he was growing the ginger. He was earning 15 lakhs per year. I have produced account statement exhibit P 21 to 22.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ ಏನ್ ಡೆಪಾಸಿಟ್ ಮಾಡಿಲ್ವಾ ಇವ್ರೆ?
ಮಾಡಿದ್. I have informed the other side.
Concept of the appellant.
Now informed today. No.
Next time for compliance. Finally, ಎಷ್ಟು ದಿವಸ ಆಗಿದೆ ಇಲ್ಲ ರೀ ಸೆಕೆಂಡ್ ಸೆಟ್ ಕೊಡ್ಬೇಕು ಯಾವಾಗ ಕನೆಕ್ಟ್ ಆಗಿದೆ ಅದಕ್ಕೆ
ಡಿಪಾಸಿಟ್ ಆಗಿದೆ
2 weeks time is granted to
on 24/8/2023.
comply the pending office objections. If needful is done, issue notice to respond number 8.
8.
Left ಅಂತ ಬಂದಿದೆ ಅಂತ ಹಾಗಿದ್ರೆ
ನಾವು ಕ್ವಾಂಟಮ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ವಿ ಫೈಲ್ ಮೆಮೋ ಫಾರ್ ಹಾಕ್ಬಿಡ್ತೀವಿ ಈಗ ನೋಡಿ ಜಸ್ಟ್ ಐ ವೇಟ್ ಫೈಲ್ ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ನೆಕ್ಸ್ಟ್
ಸೆಕೆಂಡ್ ಸೆಟ್ ಇಲ್ಲ ಬರೋದಕ್ಕೆ ಇನ್ನೊಂದು ಬರೆದು ಕೊಡೋದಕ್ಕೆ ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಸೀಕ್ಸ್ ಡಿಸ್ಪೆನ್ಷನ್ ಆಫ್ ನೋಟಿಸ್ ಟು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 8. ನಿಮ್ ಲಯಬಿಲಿಟಿ ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋದಿಲ್ವಲ್ಲ ಹಂಗಂದ್ರೆ
There is no dispute about the liability, only quantum.
only questioning the quantum of compensation and not to the liability of the insurer. Considering the same dispensation notice to respondent number 8 is dispensed with as paid for. Respondent number 8 was respondent number 3 before the
8.
ಇದಕ್ಕೆ ಇನ್ನೊಂದು ಕೊಟ್ಟಿದ್ದೀರಲ್ಲ
18.
8 is the one.
ನಿಮ್ ಸೆಟ್ ಹೇಳಿ ಅಷ್ಟು 8 ಹೌದು ಅಲ್ಲೇನು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3ನೇ ಇದ್ರು ಅವರು ದಟ್ ಇಸ್ ಕರೆಕ್ಟ್ ನಾವು ಹೇಳಿದ್ದ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 3 ಓನರ್ ಆಫ್ ಮಾರುತಿ ವ್ಯಾನ್ notice to respond number 3 is dispensed with as paid for. Actually, 2 times granted to comply the other subsections. List all other ಒಂದು ಡೇಟ್ ಹೇಳಿ ಅದನ್ನ ನೋಟಿಸ್ ಹೋಗಿದ್ರು
27/3.
R2 ನಿಮ್ಮದ್ರಲ್ಲಿ ನೋಟಿಸ್ R1 ಏನಾಗಿದೆ
R1
ಗೆ ಅವರು 2 and 3 ಡಿಸ್ಪೆನ್ಸ್.
Seal number 24, P. Pradeep, Rangegowda NR.
Notice to R3.
Filed a memo for dispensation of notice to R3 Miller,
ಏನಿದು
challenging negligence and quantum.
ಅಲ್ಲ ವಾಟ್ ಇಸ್ ದ ಚಾಲೆಂಜ್ ಕ್ವಾಂಟಮ್ ಆರ್
Negligence as well as quantum. There is a head-on collision between two motorcycles. Car and deposited, no objection to withdraw the deposited amount.
ಕ್ವಾಂಟಮ್ ಏನಿದೆ what is the memo? Appellant has filed memo seeking dispensation of notice to respond on the ground that the liability of the insurer is not in the dispute. Considering the same, notice to respond number 3 is dispensed with as paid for. Memo is disposed of accordingly. ಮತ್ತೆ ಎರಡನೇದು ಇನ್ನೊಂದು ಏನು ನಿಮ್ದು ಡಿಲೇ ಇದೆ 23 days.
No objection.
Orders and I 1/2024. Now council for respond number 1 and 2. Concedes for condonation of delay of 23 days. Considering the same and the reasons assigned, the delay of 23 days in filing the appeal is condoned. The interest of this case, I 1/2024 is disposed of accordingly. Quantum and negligence ಅಂದ್ರೆ ಅವರು ಐ withdrawal ಹಾಕಿದಾರಲ್ಲ.
I have no objection. Maybe they may
Yeah.
permitted to withdraw.
How much?
19,54,806 has been done.
ಎಷ್ಟು
19,54,806.
now council for orders and I 1/2023 ಎಷ್ಟು 25. The response 1 and 2 have filed the application seeking withdrawal of the amount deposited by the appellant by virtue of interim order of this in compliance of interim order of this court. ಎಷ್ಟೆಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅವ್ರಿಗೆ ಒಬ್ಬೊಬ್ಬರಿಗೆ
Petitioner number 1 ಗೆ 60%,
40 ಕೊಟ್ಟಿದ್ದಾರೆ.
petitioner number 2 ಗೆ 40%.
Appellant's counsel concedes for withdrawal of the said amount. Consider the same. Tribunal ಅಲ್ಲೇ ಅಲ್ವಾ?
ಹೌದು.
Tribunal is hereby directed to digitally release amount in deposit to claimant number 1 and 2.
Mother and sister. Mother and sister.
The shares apportioned to them. Them and furnishing the required documents. I 1/2024 is disposed of. ಇದರಲ್ಲಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಂದ್ರೆ ರೆಕಾರ್ಡ್ಸ್ ಬರ್ಬೇಕಲ್ಲ?
Please.
After disbursement of compensation not records.
Admit, call for TCS. Tribunal shall submit the records after releasing the amount to claimant number 1 and 2. List of the receipt of TCS.
Seal number 25, N. Suresha.
140.
The judgment, the vehicle number is mistake.
Wrongly mentioned, ಅಂತನಾ?
KL, instead of yes, it is mentioned some,
Vehicle involved? KA
KL,
13?
KL 41, yes 0764. It is mentioned somewhere, sometime it is mentioned as N. 4567.
Oh, there were two petitions.
Yes, connected case.
Lorry KL 41?
Yes, 0764 is the, ಅದು N ಆಗ್ಬಿಟ್ಟಿದೆ. Judgmental ಆಗಿದೆ.
ಅಲ್ಲ ಕರೆಕ್ಟ್ ಇಲ್ಲಿ KL 41 ನೀವು ಅಲ್ಲಿ ಕೆಳಗಿನ ಕೋರ್ಟಲ್ಲಿ ಏನು ಡಿಸ್ಪ್ಯೂಟೇ ಮಾಡಿಲ್ಲ.
ಅದು
ಇಲ್ಲ ಅಲ್ಲಿ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಯಾವ ನಂಬರ್ ಇತ್ತು? ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಕಾಪಿ ಕೊಡಿ ನೋಡೋಣ, ಗೊತ್ತಾಗುತ್ತೆ.
ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ
ಅಲ್ಲಿ give us a copy of the claim petition, then we can consider this objection. Copy ಇದೆ ನಿಮ್ಮ ಹತ್ರ ಕ್ಲೈಮ್ ಪಿಟಿಷನ್?
1 week.
We come to know that whatever you are saying is right.
Yes, 1 week ಕಾಪಿ ಕೊಡ್ತೀನಿ. ನಾವು ಏನಂದ
Counsel for
complaint and FIR, it is mentioned as yes.
To produce a copy of the claim petition to ascertain whether the vehicle number mentioned in the judgment in the impugned award is correct or not. List after ಯಾವ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ ಯಾರಿದ್ದಾರೆ ಅದು ನೀವು ಬರೀ ಹಾಗೆ ಬರೆದು ಬಿಟ್ರೆ ಸಾಕಾಗುತ್ತಾ? ಮ್ಯಾನೇಜಿಂಗ್ ಡೈರೆಕ್ಟರ್ ನ್ಯೂ ಇಂಡಿಯಾ ಅಶ್ಯೂರೆನ್ಸ್ ಕಂಪನಿ, ಅಷ್ಟರಲ್ಲಿ ಅವ್ರು ಯಾರು ನೋಟಿಸ್ ತಗೊಳ್ತೀರಾ?
ನೋಟಿಸ್
ನೋಡಿ ಸಂಪ್ರತಿ ಅವರು ಯಾರು? ಇವರು ಶಂಕರ್ ರೆಡ್ಡಿ ಅವ್ರು ಯಾರಿದ್ದಾರೆ? ನ್ಯೂ ಇಂಡಿಯಾದವ್ರು ಯಾರು ಇಲ್ವಾ ಇಲ್ಲಿ? ಯು ಆರ್ ದೇರ್ ಫಾರ್ ನ್ಯೂ ಇಂಡಿಯಾ?
ನ್ಯೂ ಇಂಡಿಯಾ ಸರ್, ನಾನು ಕೊಡ್ತೀನಿ ಕಾಪಿ.
ಎಲ್ಲಿದ್ದಾರೆ? ಪ್ರದೀಪ್ನು ಕಾಣ್ತಿಲ್ವಲ್ಲ, ಅವ್ರ ಹಿಂದ್ ಕುತ್ಕೊಂಡವ್ರು ನಮಗ್ ಕಾಣೋದಿಲ್ಲ. ರೆಸ್ಪಾಂಡ್ ಅವ್ರ ಒನ್ಗೆ ಏನ್ ಮಾಡ್ತೀರಿ?
ಸರ್ವ್ ಮಾಡ್ತೀವಿ ಸರ್.
ಸರ್ವ್ ಮಾಡ್ತೀರಿ, ಹಂಗಂದ್ರೆ ಕಂಪ್ಲೈ ಮಾಡಿ ಅದನ್ನ ಅವ್ರ ಕಾಪಿನ ಸರ್ವ್ ಮಾಡಿ. ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
Connected matters.
Connected ಇದೆ. ಕನೆಕ್ಟೆಡ್ ಅದು ಅಂದ್ರೆ 2 ಕ್ಲೈಮ್ ಪಿಟಿಷನ್ಸ್ ಇತ್ತು. ಕನೆಕ್ಟೆಡ್ ಅದೇನಾ? ಹಂಗಂದ್ರೆ 2 25 ಅದರಲ್ಲೂ ಅವ್ರು ರೆಸ್ಪಾಂಡ್ 2ನೇ ಇದಾರೆ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪ್ನಿ. 25 and 25 6 26 these 2 petitions arise out of the common judgment. Therefore they are connected to each other. ಅದಾದ್ಮೇಲೆ ಈಗ ಏನ್ ಹೇಳಿದ್ನು ಅಲ್ಲ.
Number 27, B. Pradeep.
For the appellant in this case, not challenging the liability. But on that, the appellant has issued a liability only policy. The risk of pillion rider is not covered.
Not covered ಅಂತನ ಸೇಮ್ ಏನು notice and stay subject to deposit of 50% to date 1 and 6 weeks 1 deposit within 6 weeks from the date of.
Number 28, Anusha Nandish, B. Pradeep.
Hearing for the
For the
appellant,
second
my lord.
opponent.
I've served a copy, my lords, on the copy ಸಿಕ್ಕಿದೆ.
First case.
605 ಸರ್ವ್ ಆಗಿದೆ. ಇನ್ನೊಂದು ಕೊಡ್ತೀನಿ ಬೇಕಾದ್ರೆ. Case of death, my lords.
ಯಾರು ಸಿಗ್ನೇಚರ್ ಮಾಡಿ ತಗೊಂಡಿದ್ದು?
ಇದೆ ಕಾಪಿ ಇದೆ, ವಕಾಲತ್ ಹಾಕಿದೀನಿ ಫಸ್ಟ್ ಕೇಸ್. ಸೆಕೆಂಡ್ ಕೇಸ್
Connected matter also, my lords, coming up for the first time. Also,
Connected
sir,
matter ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತನಾ?
ಫಸ್ಟ್ ಅಲ್ಲಿ ಹಾಕಿದೀನಿ ಸರ್
this
ವಕಾಲತ್.
court had directed me, my lords, to serve a copy even in the connected matter. I've served a copy in that matter also.
ಹೇಳೋಣ.
My lords, in the first matter,
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಡಿಲೇ ಕಂಡನ್ ಮಾಡಿದ್ಮೇಲೆ ಅದಕ್ಕೆ
ಅಲ್ಲ ಡಿಲೇ ಜಾಸ್ತಿ ಇದೆ ಅಲ್ಲಿ.
ಫಸ್ಟ್ ಮ್ಯಾಟರ್ there is only 27 days delay.
ಇಲ್ಲ ಅದು ಕಾಸ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ typographical error. ಹೌದು
ತಪ್ಪಾಗಿದೆ.
ಹೌದು.
Totally ಎಷ್ಟು is
427.
they arise out of same award.
Same.
ಹಾಗಾದ್ರೆ ಅಲ್ಲೂ 391 days ಇರುತ್ತೆ.
ಹೌದು.
20 ನಮ್ಮ ಆಫೀಸರ್ ಏನೋ ಸಬ್ಸೆಕ್ಷನ್ ಎಕ್ಸ್ಪೆಕ್ಟಿಂಗ್
ಹಿಂದ್ಗಡೆ 4 ನಂಬರ್ ಬಿಟ್ಟೋಗಿದೆ ಅಲ್ಲಿ.
4 ನಂಬರ್ ಬಿಟ್ಟೋಗಿದೆ, but
27 days delay ಇದೆ.
but one of the appeal says 391.
ಮೊದಲು only 40 they had written only 42 it seems. ಆ 4 2 ಎರಡನ್ನು ಹೊಡೆದಾಕಿ 27 ಮಾಡಿದ್ರು.
27 4 ಅಲ್ಲಿ ಟೈಪ್ ಆಗಿಲ್ಲ.
ಇದು ಎರಡು
Both have to be the same number of days, my lords, in fact, because it's same date the judgment was passed also.
Both counsels admit that the actual delay is more than 27 days. 27. Both these appeals arise out of the same award. Therefore, registration, check and submit. What is the days of delays? Or ಮಾಡ್ಲಿ ಬಿಡಿ ಹಾಗಾದ್ರೆ ಹೇಗಿದ್ರೆ
Please.
28.1 ಅಲ್ಲಿ ಶ್ರೀ ಕೊಡಿ ಯಾರು
I've served a copy, my lords.
ಪ್ರದೀಪ್ ಅಲ್ಲಿ Pradeep understanding concept for respondent. ಅದರಲ್ಲಿ ಕರೆಕ್ಟ್ respondent is directed to take notice for respondent to ಉಳಿದಿದ್ದೆಲ್ಲ ಹಾಕಿದ್ರಿ ಇದರಲ್ಲೂ dispensation ಇನ್ನೊಂದ್ರಲ್ಲಿ ಮಾಡಿ
ಹಾಕಿದ್ದೀನಿ. I'll file it in this, my lords. In this subsequent one, I'll file it.
dispensation of notice for respondent number 1 connected matter ಅಲ್ಲಿ ಏನು ಡಿಸ್ಪೆನ್ಸ್ ಮಾಡಿದ್ರು ಅದನ್ನ ನೋಡಿಲ್ಲ ಇದರಲ್ಲಿ 391 days ಇದನ್ನ ಕಂಡೌನ್ ಮಾಡ್ಬೋದಾ ಇಂಟ್ರೆಸ್ಟ್
Interest may be of, maybe.
for the claimants 72 years 22 years how they are related one is
Son,
mother
son.
and
Mother and brother.
brother
Please, my lords.
ಒಂದು ಕಂಡೌನ್ ಮಾಡ್ಬೋದಲ್ಲ ಅದನ್ನ ಮಾಡ್ಲಿ ಇಲ್ಲ ಅದನ್ನು ನೀವು ಇಲ್ಲೇ ಕರೆಕ್ಟ್ ಮಾಡ್ಬಿಟ್ರೆ ನಾವು ಮಾಡ್ತೀವಿ ಬಟ್ ಆಫೀಸ್ ಅವ್ರು ಏನೋ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್
Correct ಇಲ್ಲೇ ಮಾಡ್ತೀನಿ.
ಇದು ಡೇಟ್ ಆಫ್ ಅವಾರ್ಡ್ ವಾಸ್
My lords, date of award, my lords, was 11th September 23.
23 ಅಪೀಲ್ ಅದರಲ್ಲೂ 2020 ಅದು ಇನ್ನೊಂದು ಅಪೀಲ್ ಫೈಲ್
Appeal was filed on 28th January 25, my lords.
ಅದರಲ್ಲಿ 20th January 2025
Lords, as per my
ಅದೇ ದಿವಸ ಆಗಿದೆ
same, everything is same. As per my calculation, it's 406 days, my lords.
406 days ಇವನ್ ಇದ್ರಲ್ಲನು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ ಇಲ್ಲಿ ಮತ್ತೆ ಅವ್ರಿಗೆ ರಿಜಿಸ್ಟ್ರಿಗೆ ಹೇಳೋದೇ ನೀವೇ ಕರೆಕ್ಟ್
ಹಾ,
ಮಾಡಿ
ನಾನೇ ಮಾಡ್ತೀನಿ.
406
I'll stick to 406 days in both appeals.
ಹಂಗಂದ್ರೆ ಬಿಟ್ಬಿಡಿ ಟೈಮ್ ಇದ್ರಲ್ಲಿ ಇಲ್ಲಿ ನೋಟಿಸ್ ತಗೊಳ್ಳೋದೈತಲ್ಲ ಪ್ರದೀಪ್ ನೋಟಿಸ್ ತಗೊಂಡಾದ್ಮೇಲೆ ಎರಡು 28 and 28. Counsel for the appellant fairly concedes that in both these matters there is delay of 406
days
in filing the appeal. Certified copy exclude ಮಾಡಿದೀರಾ?
ಹಾ.
Beyond period, whether you applied beyond period of limitation.
ಹೌದು, ಅಪ್ಲೈ ಮಾಡಿರೋದು ಸೇಮ್ few days ಅಷ್ಟೇ ಲೇಟು, but I've calculated it's about 406 days.
Considering the reasons, orders in 1 of 25, considering the reasons assigned in both the cases for the conversion of delay. Delay of 406 days, 406 days in filing the appeals is condoned. In the interest of justice, with the condition that if the appellant succeed, they shall not be entitled to interest on enhanced compensation for the delayed period of 406 days. IA 1 of 2025 in both the cases are disposed of accordingly. ಇದರಲ್ಲಿ ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾಗುತ್ತಲ್ವಾ? Records are required.
May not be required, my lords.
Yellow notional income, na?
Yes, my lords. I have not produced any document.
We refer it to the Lok Adalat if notional income idre.
It may be referred, my lords. Because, my lords, what is
Cases involved.
after 3 days, both of them have died. I have not produced any medical records, despite which I am claiming medical expenses as well. I have not produced any documents. Maybe refer to Lok Adalat, my lords.
ಏನು ಹಾಕಿಲ್ಲ ಇದು ಅಡ್ಮಿಟ್ 2 ಕೇಸಿಂದ ಒಂದರಲ್ಲೇ ಎವಿಡೆನ್ಸ್ ಆಗಿದೆ ಏನು ರೆಕಾರ್ಡ್ ಇಲ್ಲ ಅವ್ರು ಹೇಳೋ ಹಾಗೆ ಶಿ ಇಸ್ ವೆರಿ ಫೇರ್ ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCRs listed matters are referred to Lok Adalat. Number 29
This case I appeal for the appellants, my lord. I appeal for the appellants, my lord. This is claimant's appeal for enhancement.
Completed any jurisprudence of motor accident cases? Yes. Yes. Yes.
This is the claimant's appeal, my lord, for enhancement of compensation. And insurance company appeal is also pending in MFA number 4407/2024.
That appeal.
That appeal is filed by the insurance company. Second respondent here is
Advocate ಯಾರು?
Advocate Mr. Lingraj HS.
HS Lingraj.
ಹೌದು.
29 ನಲ್ಲಿ ಶ್ರೀ HS Lingraj nurse standing counsel for respondent is directed to accept notice for respondent. ಉಳಿದಿದ್ದೆಲ್ಲ ಬರ್ಕೊಳ್ಳಿ. What about respondent?
R1, yes, I will take notice, my lord, because their appeal is regarding negligence and also quantum. Notice has to go to the first respondent. I will take note.
It is submitted that this matter is connected to MFA number ಹೇಳಿದ್ರು
MA 4407/2024.
4407/24. List both the matters together on
27-3.
Much obliged.
For admission, till number 30, Kundika Ishwar Bhatt, D. Vijay Kumar. For R1, R. Gunshekar. For R2,
My lord, one submission, my lord. On behalf of Gunashekar, my lord, he is not well, my lord, kindly take that tomorrow, next week, my lord. Gunashekar, my lord. R2.
R2. Admission again.
Gavrila.
Admission is between the appellants.
Simple matter, it can be disposed of also. There is no much dispute, my lord.
Jointly again, jointly 50.
Allah.
1 and 2 jointly.
Our
One
vehicle, is insured with
Represents this.
Oriental Insurance Company. My lord, we have paid a sum of rupees 2,75,000 to the claimant as an initial interim compensation because immediately after the accident, he was admitted to the hospital and we have paid the hospital bill. My lord, now we are seeking reimbursement of that amount. That amount is not in dispute. Even the insurance company also not disputed, owner also, claimant is also not disputed.
Yes, my lord.
There is no dispute with regard to the liability also. Only that particular amount is to be paid to the KSRC.
He has to pay, no?
They have to pay.
ಮಾಡ್ಬೇಕಲ್ಲ.
Yes.
ನೀವ್ ಅಷ್ಟೇ ಇದ್ರೆ ನೀವು ಹೋಗ ಕಾಂಟೆಸ್ಟ್ ಮಾಡ್ತಿರ್ತೀರಿ. Okay. Admit ಮಾಡಿ ಇನ್ನೊಂದು connected matter.
ಈಗಾಗಲೇ 2013 ಮ್ಯಾಟರ್ ಇದು.
ಕೊಡ್ತೀವಿ date.
Any short date, no problem.
2013.
13
You have to pay the interest on
No, I will verify with him and I will only submit, my lord. Kindly have next week, my lord.
Final disposal ಅಂತಾನೆ ಹಾಕೋಣ ಮತ್ತೆ admit ಆದ್ರೆ it comes on the
ಅಲ್ಲ, ಇನ್ನು ಮತ್ತೆ
top
late
of the list only.
ಆದ್ರೂ ಕೂಡ. Because last time only your lordship insisted to go on with the matter.
Yes, ನೋಡಿ ಅವರಿಬ್ರು ಮಾಡಿದ್ರೆ ಬರೀ calculation of
Only calculation.
Tomorrow,
case of injury.
and next week, my lord, I will verify with him and I will only appear.
Respond number 2 ನಾನು ಇದರಲ್ಲಿ
Respondent number 2 in both the cases.
List on. ಇದು ನಮ್ಗೆ ಈಗ ಒಂದು ವಾರ ಸ್ವಲ್ಪ we have some difficulties. 21st.
Much of
21st is the last day for us. 25th.
25th I may not be in station. 27th ಆಗ್ಬೋದು.
27.
much of
27-2. Still number 31, SPP.
For final disposal.
My lord, state prefers an appeal. State prefers an appeal against order of acquittal under section 366, 344, 376, clause 2 and 5, clause 1 and 6 of POCSO, my lord. The girl was aged around 17 years, 3 months at the time of incidents, my lord. Medical evidence is supportive in the case of the prosecution, my lord. Victim admits that she was in love with the accused and she eloped from the maternal uncle home of the victim, my lord.
Right. But during the trial she supported.
No.
She did not support. Then why
Only medical evidence is supporting. Trial, she is supporting to the fact that regarding sexual intercourse.
First age prove ಆಗಿದೆಯಾ?
A transfer certificate is marked.
ಟ್ರಾನ್ಸ್ಫರ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ತಗೋಬೇಕಾಗಿರೋದು ಆ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ.
In this
SSLC ಅದು ಇರ್ಲಿಲ್ಲ ಅಂತಂದ್ರೆ
SSLC marks card.
SSLC
marks
marks
card,
card
yes. She was studying second PUC, my lord.
ಎಕ್ಸಾಮ್ ಯಾವ್ದು ಎಕ್ಸಿಬಿಟ್
Studying second
ಟಿಕೆಟ್ ಹಾಕಿದೀರಾ?
transfer certificate.
Exhibit P11 is
Transfer certificate. I stand corrected, my lord. Transfer.
completed SSLC.
Yes, completed. She was studying PUC, my lord.
ಕರೆಕ್ಟ್. ಹಾಗಿದ್ರೆ ಅದನ್ನ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಬೇಕಾಗಿತ್ತು.
ಬೇಕಾಗಿತ್ತು.
SSLC ಮಾರ್ಕ್ಸ್ ಕಾರ್ಡ್.
Exhibit P11 transfer certificate is.
ಲಾಸ್ಟ್ ಅಟೆಂಡೆಡ್ ಸ್ಕೂಲ್. Juvenile justice rules. If completed matriculation, that certificate.
Yes, ma'am.
And in the absence of that, play school, first attended school.
First attendance.
Birth certificate, then other evidence you are not produced. Originally, ಹೇಗ್ ಮಾಡ್ಬೇಕು ಅಂತಂದ್ರೆ ವಿಕ್ಟಿಮ್ಸ್ ಫಸ್ಟ್
First attendance school we have not produced. Only transfer certificate which is exhibit P11.
And added to that she has not supported.
Huh?
Added to that she has not supported.
ಸಪೋರ್ಟ್ ಮಾಡಿ.
ಮತ್ತೆ ಯಾಕೆ ಅಪೀಲ್ ಹಾಕಿದ್ರಿ?
It might be admitted.
ಅಡ್ಮಿಟ್ ಮಾಡಿದ್ರೆ ಇನ್ನೊಂದಿಷ್ಟು ವರ್ಷ ಇರುತ್ತೆ. 2015 ಯಾರು ಇವರೇ
I appear for respondent to
Defect.
father of the,
ಅದೇ ಕರೆಕ್ಟ್, ನಾಟ್ ಫಾರ್ ದ ಅಕ್ಯೂಸ್ಡ್ ಕೌನ್ಸಿಲ್ SC ಶಿವರಾಮ್.
yes.
ಇದನ್ನೇ ಹಿಂದೆ ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ಅವರು ರಿಟೈರ್ ಆಗ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರು, ಆ ಕೇಸ ನೋಡಿ.
Shivram is not present.
ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 1.
Incident year
Year, my lord. Year is 2014, my lord. Date of incidents.
ಅದಕ್ಕೇನೆ ಹೇಳಿದ್ವಿ, ಇಷ್ಟು ವರ್ಷ ಆಗೋಗಿದೆ, ಅಡ್ಮಿಟ್ ಮಾಡಿ ಇನ್ನೊಂದು 10 ವರ್ಷ. If age is not proved, she has not supported.
She has supported to the extent that
No, they had
relationships, that intercourse and
age and other things.
other thing. But
Forced sexual act.
no, force ಅಂತೆಲ್ಲೂ ಹೇಳಲ್ಲ. ನಾನು ಪ್ರೀತಿಸ್ತಿದ್ದೆ, ಪ್ರೀತಿ ಮಾಡಿದೆ, ಪ್ರೀತಿಸ್.
Call for TCRs. Need but whatever. As per the records, the judgment indicates that victim was aged 17 plus. And according to the prosecution, the victim was aged 17 years 9 months, but her SSLC marks card was not produced. As submitted, she did not support the case of the prosecution regarding the forced sexual relationship. Therefore, call for the TCRs to examine whether there is a case for
The state. Obliged.
My presence may be.
TCRs. For their work community, Srimati So-and-so, counsel for respondent number 2 is present.
Number 32, ವಿವೇಕ್ ಹೊಳ್ಳ.
ಅಲ್ಲ, ನಾವು ಸಿಸ್ಟರ್ ಪ್ರೆಸೆನ್ಸ್ ನೋಟ್ ಮಾಡೋದಿಲ್ಲ. ಬ್ರದರ್ ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಯಾವ್ದೋ ಒಂದು ಕೇಸಲ್ಲಿ ನಿಮ್ ಬ್ರದರ್ ಬರ್ತಾನೆ ಇಲ್ಲ ನೋಡಿ. ಸಂತೋಷ್ ಹೋಗಿ ಯಾವ ಕೇಸ್ ಅದು, ಯಾವ್ದೋ ಕೇಸಲ್ಲಿ ಅವ್ರ ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ಅಗಲೆಲ್ಲ ತಗೊಳ್ತಾ ಇದಾರೆ, ಅದಕ್ಕೆ ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನಿಮ್ ಪ್ರೆಸೆನ್ಸ್ ನೋಟ್ ಮಾಡೋದಿಲ್ಲ. ಯು ಶುಡ್ ಕಮ್ ವಿತ್ ಯುವರ್ ಸಿಬ್ಲಿಂಗ್. ಎಸ್, ಶಿ ವಿಲ್ ಡಿಸೋಲ್ವ್ ದ ಬ್ರದರ್. ಅವ್ರು ಬಂದಾಗ ಇದನ್ನ ಹೇಳೋದಿಲ್ಲ, ಬಿಕಾಸ್ ವಿ ಆರ್ ಕಾನ್ಫಿಡೆಂಟ್ ದಟ್ ಹಿ ವಿಲ್ ಕಮ್ when your brother comes. Yes.
Yes.
Yes, madam, 4890.
Serial number 32, my lord. I'm appealing for
Not
the
for
appellate.
lack of
Matter has been
acknowledgement.
compromised.
Lord's order, it is compromised.
It has been
Compromised.
compromised.
Filing compromise petition also.
Deposit.
My lord was pleased to grant interim order modification of that on that day. It is,
What is that? No, I don't read it.
Lord, parties have settled at 26,50,000.
2 ವರ್ಷ ಲಿಸ್ಟ್
ಹೌದು. ಅದು ತಮ್ಮ ಆರ್ಡರ್ ಇಂದ ಮುಂದೆ ಇದು
25% ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ರು. ಈಗ ಏನ್
ಹೇಳಿ.
ಕಾಂಪ್ರಮೈಸ್?
ಈ ಕಾಂಪ್ರಮೈಸ್
They have reconciled or?
no no that only challenge the permanent alimony.
ಚೆನ್ನೈ ಮೂವ್ ಮಾಡಿದ್ರೆ
Only with regard to the alimony.
Permanent alimony we are
alimony
accepting
had challenged.
26,50,000.
Divorce, we have accepted, both of them have accepted the divorce part.
Sum of $1 lakh to the respondent.
One submission, my lord. As per the bank records, the demand draft is drawn in the name of R. Sindhura. So as per the petition, her name is Sindhura Rajgopal.
Rajgopal. Parents
So
are
that
also
may kindly be noted, my lord.
26,50,000 by DD.
please.
ಡಿಮಾಂಡ್ ಡ್ರಾಫ್ಟ್ ಟುಡೇ ಆಲ್ ಆರ್ ಗಿವಿಂಗ್.
Yes, to the DD they are giving it.
ಅಲ್ಲ, ಇಷ್ಟು as against $1 lakh, she has
Yes.
agreed to for 26,50,000.
My lord may ask, is that
ಇದ್ದಾರೆ,
is present?
ಕೇಳ್ತಾ ಇದ್ದೀನಿ.
Yes.
You represent,
I represent the respondent.
respond.
They have stayed only for 78 days, my lord. I may submit to, even in the judgment.
My lord may ask her. I have asked.
She is also working.
She is working, she is drawing 1,60,000 rupees salary.
ನಿಮಗೆ ನೀವ್ ಹೇಳಕ್ ಶುರು ಮಾಡಿದ್ರೆ ಹಂಗಂದ್ರೆ ಅವರು ಹೇಳ್ತಾರೆ.
ಇಲ್ಲ.
We are asking him, not you.
Please, my lord.
Yes.
My lord, she is satisfied with the amount which is being paid.
ಈಗ check the DD.
DD, demand.
Or how does she get it in cash if the name is different?
No, in her bank account, she has, that's the name that she has given.
That is
the
ಇಲ್ಲಿ ಇದ್ರಲ್ಲಿರೋ ನೇಮು ಅಲ್ಲಿಗೆ.
Oh.
That's the reason, madam. Your lordship may kindly note that part of the demand draft.
Put it. Sorry, ma'am.
Both mother Appellant is represented through his power of attorney holder.
Mother.
Yes, my lord. She is here.
Correct.
Power of
Stand, stand.
attorney holder of the appellant.
Madam, copy of the demand.
Respondent, power of attorney holder of the appellant, and both counsel are present. Parties submit compromise petition under order 23 will be CPC. Heard the parties on the compromise petition. Is idರಲ್ಲಿ agreed for 26,50,000. ನೀವು ಅಷ್ಟು ಕೊಡೋದಕ್ಕೆ ನೀವು
ಕೊಟ್ಟಿದ್ದೀವಿ. We have already handed over the.
They have to hear the parties, not the advocate, on the compromise petition. Yes. Parties agreed to the voluntary execution of the compromise petition and the terms of the same, which read as follows. Is an extract from the report. Respondent admits the receipt of demand draft for rupees 26,50,000 as stated in para 4 into bracket 1 bracket 11 as stated in para 4 of the para 4 of the compromise petition in full and final settlement of her claim. The appeal, who had filed the decree for divorce?
The wife had filed it, respondent had filed. 13/4/22 is the order, ma'am, granting divorce.
Petition was filed by her.
How is it?
Followed with cause.
Challenge is only in respect of permanent alimony, my lord.
By the impugned judgment and decree, the trial court has granted a decree of divorce in favor of the present respondent under section 13(1)(1)(a) and alimony of rupees $1 lakh permanent alimony. Now the parties have, the appellant has challenged only the decree only so far it relates to the permanent alimony.
Please.
Permanent alimony. Invokes the compromise petition.
Not for modification.
Satisfied that the compromise under the compromise petition, the parties have agreed for confirmation of the divorce decree and only modification with regard to the permanent alimony.
Please.
Permanent alimony. Satisfied that the compromise petition, compromise is admissible under law. Therefore, the same is recorded. Hence the following order. The appeal is allowed. The impugned decree, so far it relates to compromise, permanent alimony is modified as follows. The impugned decree in MC number 1997 of 2018 on the file of third edition Principal Judge Family Court, Bangalore. So far it relates to the permanent alimony is modified as follows. Petitioner wife is entitled to
2650.
Permanent alimony of 26,50,000. And she has received the same. Received the same the DD number so and so.
DD.
What she's.
No, she showed the DD in form of.
All right. ಅಲ್ಲ ಅದೇನೋ ಒಂದು ಇನ್ನೊಂದು ರೆಕಾರ್ಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಇಲ್ಲ ಹೆಸರು ದಿ ಸಿಂಧೂರ ರಾಜಗೋಪಾಲ್ ಅಂತ ಇದೆ.
ಬಂದ್ಬಿಟ್ಟಿದೆ ಅಲ್ವಾ?
ಇದೆ.
ಇದೆ, but DD is in the name of R. Sindhura.
Mention that in the compromise.
ಇದೆ, ಅದು ಇದೆ compromise.
Yes.
ಇದನ್ನ ಸುಮ್ಮನೆ ಇಷ್ಟೇ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ರೆ ಅದು ಕನ್ಫರ್ಮೇಶನ್.
Obliged.
Please. I will also place the Aadhaar card.
Obliged.
Number 33.
ಅದನ್ನ
ರಾಘವೇಂದ್ರ ಸಿ.
ಇಬ್ರು ಕೊಡ್ತಾ ಇದಾರೆ ಆಧಾರ್ ಕಾರ್ಡ್.
ನಮ್ಮ ಪಾರ್ಟಿಗೆ ಕೊಡಿಸ್ತಾ ಇದ್ದೀನಿ ಅವ್ರಿಗೆ.
ಇಲ್ಲ, ನಮ್ದು ಆಧಾರ್ ಕಾರ್ಡ್ ಏನ್ ತಂದಿಲ್ಲ.
ಅಲ್ಲ ಪವರ್ ಆಫ್ ಅಟಾರ್ನಿ ನೀವು ಇಲ್ಲಿಂದ ಹಾಕಿದ್ರೆ
along with the file, along with the power of attorney.
ಸರಿ. ಸಾಕು ಅಷ್ಟೇ. ಏನ್ ಬೇಕಾಗಿಲ್ಲ ಅದೇನ್ ಮತ್ತೆ ಸ್ಪೆಸಿಫಿಕ್ ಆಗಿ ಮೆನ್ಷನ್.
ಅಲ್ಲ, ತಗೊಳ್ಳೋರು ಇದ್ರೆ ಸಾಕು.
Yes, next.
Public.
Judgment was passed, Your Honor. Against a deceased person.
New India Assurance Company.
New India also.
New Indiaದವ್ರು ಯಾರೋ ಇದ್ರಲ್ಲ ಅವಾಗ ಮರಳಯ್ಯ ಯಾರು?
ಆಗ್ಲೇ ಇದ್ರು ಇಲ್ಲೇ.
ಹಾ?
ಆಗ್ಲೇ ಇದ್ರು.
ಇಲ್ಲೇ ಇದಾರಲ್ಲ
ಮರ್ಲಯ್ಯ.
ನ್ಯೂ ಇಂಡಿಯಾ ನೀವಿದ್ದೀರಿ ತಾನೆ?
New India.
ಮರಳಯ್ಯ ನಾನು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಫಾರ್
Notice.
ರೆಸ್ಪಾನ್ಸಿಂಗ್.
Dispensation, I will respond number 1 and 2 ಗೆ dispensation.
ನೋಟಿಸ್ ಫಾರ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ.
Third.
ಅದು ಉಳಿದೆಲ್ಲ ಹಾಕ್ಬಿಡೋದು. ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ಅಪೀಲಿಂಗ್ ಸರ್ವಿಸ್ ಮೆಮೋ ಫಾರ್ ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆಫ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಶಾಲ್ ಡೆಪಾಸಿಟ್.
Respond number 1 is in the mother of the deceased, Your Honor. I am for the wife of the deceased. So respond number 1 is the file the petition before the lower court.
Correct.
ಅದರಲ್ಲೇ ನಮಗೆ compensation.
You are seeking dispensation to
ಇನ್ನೊಂದು ಕಾಪಿ.
ಯಾರಿಗೆ dispensation ಕೇಳ್ತಾ ಇದ್ದೀರಿ?
Respond number.
ಕ್ಲೈಮೆಂಟ್ಸ್ ಅಲ್ಲ ಅವ್ರಿಗೆ one is claimant.
ಹೌದು ಸ್ವಾಮಿ. She is in a mother of the deceased, Your Honor.
Respond number 1 Jarina, wife of the deceased Bijli. This is Roshan. ಈ ಕ್ಲೈಮೆಂಟ್ ಯಾರಾಗಿದ್ರು? ಮದರ್.
Mother. So ನಾವು ಅದರಲ್ಲಿ wife use.
You have
Is lower court, I am the respondent number 1.
correct. Why do you want to seek dispensation to respond number 1?
Yeah, he is in already ಅದರಲ್ಲಿ ಆರ್ಡರ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. There is a 40% of the mother and 60% of the.
ಕರೆಕ್ಟ್. ಇಲ್ಲ ಅವಾರ್ಡ್ ಆಗಿದ್ದಾದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ. if at all it is enhanced.
ಆಗ್ಬೋದು sir.
No.
Otherwise,
We thought that the driver.
Act 2 yours.
ಆಯ್ತು ಬೇಕಂದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ.
ಆಗ್ಬೋದು.
For dispensation of notice to respond number 2.
ಎಲ್ಲ correction.
Under the included award, the liability to pay compensation is concerned to respond number 3, the insurer. Therefore, notice to respond number 2 is dispensed with as paid for. ಏನಿದ್ರಲ್ಲ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಕೇಳಿದ್ದೀರಾ ಏನು?
Announcement ಇವಾಗ.
ಏನಿದೆ ಕ್ವಾಂಟಮ್ ಇದನ್ನು ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ?
ಹೌದು.
Heard admit all parties yes admit ಮಾಡಿದ್ದೀರಾ? Issue notice to respondent number 1. List down
27-3. So number 34, KP Bhuvan.
Yeah, for appellant one.
ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಬೇಕಾ? Sir of the vehicle. ICICI ಅವ್ರಿಗೆ ತಗೊಳ್ಳಿ. Respond number 3. Who is respond number 3? Driver?
Driver of the vehicle.
ಯಾರು? ICICI.
PH Jagdish, Ashok N. Patil, Krishna Kishore.
ಯಾರು ಸರ್ ಮಾಡಿ PS ಜಗದೀಶ್.
Please, madam.
She PS Jagdish, Lawrence Standing Counsel correspondent is directed to take notice correspondent to liability is against owner only. Issue notice to respect. Admit to ಮಾಡಿದ್ರಲ್ಲ delay ಏನಿದೆ. Admit call for discuss. Issue notice to respond number 1 and 3.
My lord, the 1 to 3 ಆಗ್ಬೇಕು ಇದರಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಅಗೇನ್ಸ್ಟ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಹೂ ಇಸ್ ದ ಓನರ್ ಆಫ್ ದಿ ವೆಹಿಕಲ್. ಮೈ ಲಾರ್ಡ್, ನಾವು ಕೇಳಿರೋದು ಇವಾಗ ಇನ್ಶೂರೆನ್ಸ್ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಕೇಳಿದ್ವಿ, ಪೇ ಅಂಡ್ ರಿಕವರ್ ಕೇಳಿದ್ವಿ.
ಕರೆಕ್ಟ್. ಆದ್ರೆ ಅವ್ರಿಗೆ ಒಂದ್ ವೇಳೆ ನಿಮ್ದು ಕ್ಲೇಮ್ ಅಡ್ಮಿಟ್ ಮಾಡ್ಲಿಲ್ಲ, ಅಕಸ್ಮಾತ್ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಆದ್ರೆ ಅವ್ರಿಗೆ ಗೊತ್ತಾಗ್ಬೇಕಲ್ಲ. ಯಾರು ಚಾಲೆಂಜ್ ಓನ್ಲಿ ದಟ್ ಪಾಯಿಂಟ್ ಅದು ಇಟ್ ಈಸ್ ಅಗೇನ್ಸ್ಟ್ ಹಿಮ್. ಅದಕ್ಕೆ ಹೇಳಿದ್ವಿ. ಅದಕ್ಕೆ ಅವ್ರು ಹೇಳೋದು ನಾವು ಬರೀ ಪೇ ಅಂಡ್ ರಿಕವರ್ ಮಾಡ್ಕೊಳ್ಬೇಕು ಕೇಳ್ತಾ ಇದೀವಿ ಅಂತಾರೆ. ಇವನ್ ಅದರ್ವೈಸ್ ಒಂದ್ ವೇಳೆ ನಾವು ಎನ್ಹಾನ್ಸ್ ಮಾಡಿ ಏನಾರು ಮಾಡಿದ್ರೆ ಅವಾಗ ಫೈನಲ್ ಹಿಯರಿಂಗ್ ಬಂದಾಗ ಏನಿರುತ್ತೆ ಅಂತ ಗೊತ್ತಿರೋದಿಲ್ಲ. ಅವ್ರು ಕೇಳಿದ್ರೆ ಕೊಡ್ತೀವಿ. ಡಿಸ್ಪೆನ್ಸೇಷನ್ ಆರ್ತಿ ಕೇಳ್ತಾ ಇದ್ದೀರಾ?
ನೋ ಮೈ ಡಿಸ್ಪೆನ್ಸೇಷನ್
Is the rider of the
ರೈಡರ್ ಆಫ್
ಬೇಕಾ?
ಡಿಸ್ಪೆನ್ಸ್
ನೋಡಿ ಇದು ಬರ್ದಿದ್ದಾರೆ. ಕ್ವಾಂಟಮ್ ಅನ್ನು ಕ್ವಶನ್ ಮಾಡಿದ್ದಾರೆ. Issue notice to respond number 1 and 3. List down
27-3. Seal number 35, Manjunath G. Kandekar, K. Lakshmipati.
I have challenged the trial court order, my lord, restitution of conjugal rights. Even though the petition for maintenance and petition for divorce has been pending consideration before the trial court, my lord.
Not getting any evidence. Notice records and state evidence.
Custody of the child also.
Custody?
Custody of the child.
Here
When
direct
petition for maintenance and petition for custody of the child is pending consideration, my lord,
are pending still.
before the trial court.
Like as a counterblast to that. Heard evidence all parties, yes. Issue notice to the respondent. Entry
My lord.
stay as paid for.
Lakshmipati and
Stay may be granted, my lord.
Oh, ಯಾರು ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ? 8240 ಅವ್ರಿಗೆ ಸರ್ವ್ ಮಾಡಿದ್ರಿ ತಾನೆ? ಏನು ಆಫೀಸ್ ಆಫ್ ಸೆಕ್ಷನ್ ರೈಸ್ ಮಾಡಿಲ್ಲಲ್ಲ, ಕೇವೇಟ್ ಸರ್ವ್ ಮಾಡಿಲ್ಲ ಅಂತ. ಸರ್ವ್ ಮಾಡಿದ್ರಿ ತಾನೆ?
ಹೌದು ಸರ್.
Entry stay as paid for till further orders. I have 1/24 is displayed.
Number 36,
Receipt of TCS.
Mohammed Gurfan.
Seeking enhancement.
Enhancement. Petitioner.
Appeal was in time, my lord. Issue notice to respondent.
Superintendent of Police, Sagar, KZID, Bangalore. Government side, okay, sir.
Government vehicle.
How much is awarded?
9 lakh.
9,34,000. Respond number 3 shall deposit the compensation.
9,34,000.
HCGP ಸರ್ವ್ ಮಾಡ್ಬೇಕಾ ಇಲ್ವೋ? ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ನೋಟಿಸ್ ಬೇಕಾ?
Madam,
ಮತ್ತೆ ಡಿಸ್ಪೆನ್ಷನ್ ಮೆಮೊ ಹಾಕೊಳ್ಳಿ. ನೋಡಿ KZID ಗೂ HCF ಅವರೇ ಅಪೇರ್ ಆಗ್ತಾರೆ ತಾನೆ? ADCP learned HCP ಈಗಿದ್ರು ಸ್ವಲ್ಪ is directed to accept notice for respondent number 2 and 3. Appellant's counsel shall serve the copies on him. His name shall be shown for the said respondent. So the causes accordingly. You shall find the memo of appearance. Memo of appearance in 2 weeks. First. Appellant's counsel submits memo for dispensation of notice for respondent. Under the influence of liability to pay compensation is fastened against respondent number 3. Therefore, notice to respondent number 1 is dispensed with as paid for. ಏನು ಬರೀ ಕ್ವಾಂಟಮ್
madam.
ಏನು ಇನ್ಕಮ್ ಏನಾದ್ರು ಪ್ರೂಫ್ ಹಾಕಿದ್ರಾ? ಇಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. Not produced any proof of income. You have not examined anybody.
No, because he is agriculture and he is aged over 60 years.
Admit call for TCS.
Good.
Cell number 37, MR Hire method.
Appearing for appellant.
Yes.
In this petition, the petitioner in trial court filed a petition for dissolution of marriage by decree divorce under section 31A and 1B. In these proceedings, the respondent filed an application for maintenance under section 24 and 26, my lord. And interim orders also granted, allowed by pay by 3,000 per month interim orders also. Thereafter, matter posted for petitioner evidence. Petitioner examined himself PW1.
Order 9, Rule 9 application is rejected now.
Yeah.
It was dismissed for non-prosecution.
Non-prosecution.
Petition has been very careful and not any.
Due to inconvenience of
Engaging the same counsel, you were appearing in execution case.
this matter.
He was informed about the dismissal. There was delay also in filing the application under Order 9, Rule 9.
My lord, inconvenience, due to inconvenience of that MC petition dismissed.
ಯಾವ year of the
Yeah.
MC petition? 2009 MC petition.
Yes, ma'am. 2011. 2009.
When we will make an observation that we shall go on paying how much maintenance is awarded in other cases?
No, my.
You were only just now submitting.
No, then same case, maintenance
How much?
awarded 3,000 rupees per month interim maintenance.
Then you will issue notice subject to you depositing that interim maintenance even before this court.
ಒಂದು notice ಹೋಗ್ಲಿ.
ಒಂದು ನೋಟಿಸ್ ಹೋಗ್ಲಿ, ಒಂದು ನೋಟಿಸ್ಗೂ ನಾವು ಅಷ್ಟು ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ. ಥರ್ಡ್ issue notice ಇಲ್ಲೇ ಡೆಪಾಸಿಟ್ ಮಾಡಲಿ, subject to deposit. Third, issue notice to the respondent subject to appellant depositing litigation expense of this 25,000 before this court within 2 weeks and gone paying interim alimony of rupees. ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ? interim alimony ಅನ್ನು ಅಂತಾರೆ. ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾರೆ? Gone depositing ಅಂತ ಮಾಡ್ತಾರೆ. What is he doing? ಸೀನಿಯರ್ ಅಲ್ಲ, ನೀವು ಈ ರೀತಿ ಆರ್ಡರ್ ಮಾಡಿಸ್ಕೊಂಡ್ರೆ ಅಂತ ಅವ್ರು ಬೈತಾರೆ.
ಪ್ರೈವೇಟ್ ಕಂಪನಿ ವರ್ಕ್ ಮಾಡಿ. ಪ್ರೈವೇಟ್ ಕಂಪನಿ ಎಂಪ್ಲಾಯ್.
ಪ್ರೈವೇಟ್ ಕಂಪನಿ ಏನಂತ ತಗೊಂಡ್ರೆ ಸಬ್ಜೆಕ್ಟ್ appellant depositing 25,000 before this court within 2 weeks. Okay. If the said amount is not deposited within 2 weeks, the appeal shall stand dismissed. List on the 2 weeks on minute. Notice will be issued only if you deposit the interim.
Much.
Yes. 3-3. Number 38, Syed Abdul Saboo.
I am for appellate in this case, my lord. The case of injury, my lord.
Yes.
It's a case of injury. I am challenging the disability, my lord.
You are only on the point of quantum?
Disability, my lord. Disability, my lord. 70% has been assessed by the doctor, but Tribunal has awarded only 16%.
Disability?
Yes, my lord.
ಯಾರು ರಾಯಲ್ ಸುಂದರಮ್ನವರು? Who is the royal people here? ಯಾರಿದ್ದಾರೆ ನೋಡಿ.
R1 to be discussed with me. I'll file application.
ರವಿ ಸಂಪ್ರತಿಕ್ ಸರ್ ಮಾಡಿ.
Yes.
Standing counsel for respondent is directed to accept notice for respondent. What about respond number 1?
I'll discuss, I'll file my application before register.
Counsel for the appellate seeks dispensation of notice to respond number 1. Under the influence award, the liability to pay compensation is fastened to respond number 2, the insurer. Therefore, the appellant's counsel for notice to respond number 1 is dispensed with as paid for. The appellant's counsel shall submit a memo to that effect in the registry. ನೀವು ಮೆಮೊ ಹಾಕ್ಬೇಕು ರಿಜಿಸ್ಟ್ರಿಯಲ್ಲಿ.
Yes, my lord.
ನೆಗ್ಲಿಜೆನ್ಸ್ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
ಹೌದು ಸರ್.
ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್
ನೆಗ್ಲಿಜೆನ್ಸ್ ಇಲ್ಲ, ಇಟ್ಸ್ ಎ ಡಿಸಬಿಲಿಟಿ ಕನ್ಸಿಡರ್ ಮಾಡಿಲ್ಲ.
ಡಿಸಬಿಲಿಟಿ ಅದಕ್ಕೂ ರೆಕಾರ್ಡ್ ಬೇಕಾಗುತ್ತೆ. ಡಿಸಬಿಲಿಟಿ.
Yes, ma'am.
ಅಡ್ಮಿಟ್ ಕಾಲ್ ಫಾರ್ TCS. List of the receipt of TCS. Number 39, GS Marlaya.
My lord, appellant is the insurance company. Negligence and quantum is challenged. Minor petitioner, 32,64,000 awarded. And there was a contributory negligence also. I am ready to deposit 50%. Stay, IA2 may kindly be.
Delay ಇದೆಯಾ ಇದರಲ್ಲಿ?
Delay ಇಲ್ಲ sir. IA1 is not pressed. IA2 is the.
Issue notice to the correspondence. Interim stay. At the same subject to deposit of 50% of the award amount before the tribunal.
Yes. 6 weeks.
IA. 6 weeks. 6
Yes,
weeks. IA2 of 2025
IA2.
is disposed of accordingly. List of 1-4. 1-7. SB Haldi.
The claimant's appeal, Malad. The tribunal has dismissed the claim petition, Malad.
Why? Accident not proved antana?
Please, Malad.
Why it is dismissed?
That dismissed on the reason that, Malad, the claimants have not given particular, the color of the vehicle, Malad.
ಇವರು ಬ್ಲೂ ಅಂತ ಹೇಳ್ತಾರೆ, that was seized by the grey color ಅಂತ ಹೇಳಿ. On that reason that,
Involvement of the vehicle was disputed.
color of the vehicle more that, number same.
Echo central ಯಾರಿದ್ದಾರೆ? Echo central ಯಾರಿದ್ದಾರೆ? ನಮ್ಮ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇದೆ ಇಲ್ಲ ಸರಿ ಇಫ್ಕೋ ಅಲ್ಲ ಎಕೋ
Echo.
ನಿಮ್ಗೆ ಗೊತ್ತಿದೆ ಯಾರಿದ್ದಾರೆ
ಇಲ್ಲ ಇಲ್ಲ
ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ ಹಂಗಂದ್ರೆ
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಡಿಲೇ ಏನಿಲ್ಲ
ಡಿಲೇ ಇದೆ.
ಮಾಡಿದ್ವಿ ಕಾಲ್ ಫಾರ್ TCR ಇಶ್ಯೂ ನೋಟಿಸ್ ಟು ದ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಲಿಸ್ಟ್ ಆನ್
27.
ಗೊತ್ತಿರುತ್ತೆ ಯಾರೋ ಇದ್ರು ಅಂತ ಹಿಂದಿನ ಸಲ
ಪ್ರದೀಪ್ ಅವರೇ
ಪ್ರದೀಪ್
ಇರ್ತಾರೆ. ಬಹಳ ಕಡಿಮೆ ಬರ್ಕೊಂಡಿದ್ದಾರೆ ಇದ್ರೆ ನಿಮ್ಗೆ ಗೊತ್ತಿದ್ರೆ ಅವ್ರು ತಗೊಳ್ಳಿ. ನೋಬಡಿ ನೋಸ್ ಹಿಯರ್ ನೋಟಿಸ್ ಮಾಡ್ತೀವಿ
Please,
ಬರ್ಲಿಲ್ಲ ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ನೋಡಿ
ಪ್ಲೀಸ್ ಮಾಡಿ.
ಅವ್ರು ಬಂದಾಗ ಕೇಳಿಟ್ಕೊಂಡು ಬರ್ದಿಟ್ಕೊಳ್ಳಿ.
ಪ್ಲೀಸ್.
For further hearing, cell number 41, Srinivas Kumar DG, K. N. Srinivas.
In this matter, only I heard today, dictating judgment.
ಇದು ಬಸ್ ನಿಲ್ಸಿದ್ದು ಬಸ್ ಅಲ್ಲ ರೀ ಲಾರಿ ಸ್ಪೀಡ್ ಬ್ರೇಕರ್ ಇರಲಿಲ್ಲ. The lorry driver is also examined.
Please, my lordship. He specifically admitted that, my lordship, you are showing his hand
It was dark. No bus.
without giving any indication, my lordship. And suddenly stopped the vehicle.
Right, you relied on one more MFA order.
Please, my lordship.
ಅದ್ಯಾತಕ್ಕೆ?
That is, I have filed it along with memo, my lordship, on 4/1/2000.
For what purpose?
My lordship, in that judgment, the coordinate bench of this court, my lordship, set aside the contributory negligence fixed on the claimants.
ಎಲ್ಲಾಗಿದೆ contributing negligence finding?
Petition. He would have slowed down the law.
Where's the finding on contributing negligence?
Page number 23, para 23.
50% each and internal page 13 nalliде. Due to the rationale, both the drivers of the vehicles, so negligence attributed by both the drivers is assessed at 50% each. ಅದೇ ಎರಡರಲ್ಲೂ ಉಲ್ಟಾ ಇದೆ ಅಂತ ನಾನು
Operative portion ಇದೆಯಾ? Operative portion
petition ಇಲ್ಲೇ ಡಿಡಕ್ಟ್ ಮಾಡೋದು ಅಂತ ಕನ್ಸಿಡರ್
Operative portion ಅಲ್ಲಿ ಸೊಮ್ಮೆ
ಮಾಡಿದ್ದಾರೆ.
page number 18 ಅಷ್ಟೇ ಡೈರೆಕ್ಟ್ ಆಗಿ ಇದು ಮಾಡಿ
24 of the judgment ಅಲ್ಲ ಅದನ್ನ 24 50% ಅದು ಡಿಡಕ್ಟ್ ಮಾಡಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ. ಲಾಸ್ಟ್ ಟೈಮ್ ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದಾರಲ್ಲ ಇದು
ಎರಡೂ ಸೈಡ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದೆ.
ಅಲ್ಲ ಇದು MFA number 6182 ಇಲ್ಲಿ Santro car number so and so and lorry bearing number K06. We have considered submission made by the council. That is, there is a request. The only question that arises for our consideration of these appeals is with regard to quantum of conflict. Munegoda, the injured payments were invested and have not contributed to the happening of the accident. Admittedly, the car was driven by deceased master, and therefore 50% of amount would not have been deducted from the amount of function which was assessed by the tribunal. Other third party ಆಗ್ತಾರೆ ಅಂತ. ಅಲ್ಲ ಇದನ್ನ ನೋಡಿದ್ರು ಯಾಕಂದ್ರೆ ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರು ಅಂತ ಗೊತ್ತಿಲ್ಲ. Now, where is that judgment in MFA number, this MVC number? ಇದಲ್ಲ MVC 6180. 6180 judgment ಇದೆಯಾ? ಅಲ್ಲ ಏನ್ ಹೇಳ್ತಾರೆ
Are you satisfied with the 50% negligence?
No, my lordship,
No. Then
challenging
how do you
this.
get over the finding? This will not help you.
My lordship, kindly see the cross examination of RW one, my lordship, who is the driver of the offending vehicle.
Finding ಕೊಟ್ಟಿಲ್ಲ. Our third parties whomsoever may be negligent.
But the alleged accident taken place due to the rash and negligent driving of the offending vehicle, my lordship. He specifically admitted in this cross examination.
13,38,000.
The cross examination of
ಒಂದ್ ನಿಮಿಷ ತಡಿ, ಕೊನೆಗೆ ಏನ್ ಹೇಳಿದಾರೆ? Enhanced compensation. ಯಾರು ಕೊಡ್ಬೇಕು ಅಂತ ಆರ್ಡರ್ ಮಾಡಿಲ್ಲಲ್ಲ ಇಲ್ಲಿ. The enhanced compensation in MVC number shall carry interest at 6% from the date of the filing of the petition till realization. The aforesaid extent, the judgment passed in MVC number so and so is modified ಅಂತ ಹೇಳಿದ್ರು. ಇದರಲ್ಲಿ who has to pay ಅನ್ನೋದು ಇದರಲ್ಲಿ ಇಲ್ಲ.
ಇಲ್ಲಿ ಸಂಬಂಧಿಸಿದ ಪೇಜ್ ನಂಬರ್ 10 ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ
ಪ್ಯಾರಾ 8 ಏನ್ ಹೇಳಿದ್ರು?
ಇದ್ರಲ್ಲಿ ಕೋಆರ್ಡಿನೇಟ್ ಬೆಂಚ್ ಆಫ್
ಅಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರು ಅದರಲ್ಲಿ? anyhow the parties are not disputing ಅಂತ. We have considered the submissions made by learned counsel for the parties and have perused the records. The only question which arises for our consideration in these appeals is with regard to quantum of compensation. Admittedly, deceased Munegoda and injured claimants were the inmates of the car and have not contributed to the happening of the accident in any manner. Andre ಅವರು whether this they pay, they were the third parties, the claimants therein. So it doesn't matter ಅನ್ನೋ ರೀತಿಯಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. Admittedly, car was being driven by deceased Bhaskar and therefore 50% of the amount of compensation would not have been deducted from the amount of compensation which was assessed by the tribunal. They were the third parties, they were not the driver. So it was deducted. Whomsoever pay, it doesn't matter because they become the third parties. ಅದನ್ನಷ್ಟೇ ಕ್ವಾಂಟಮ್ ಅಷ್ಟೇ ಮಾಡಿಫೈ ಮಾಡಿದ್ದಾರೆ ಅದರಲ್ಲಿ.
But idರಲ್ಲಿ my lordship, if the driver of the offending vehicle if give proper indication, then the deceased would have
Judgment. Who is for the insurer here? Liability. Yes. Correct. ಅಲ್ಲಿ ಏನಾಯ್ತು ಅಂತ ಗೊತ್ತಿದೆಯಾ ನಿಮ್ಗೆ? Universe for R2. In these MVCs ಅವ್ರೇನು ಹೇಳ್ತಾ ಇದಾರಲ್ಲ 61, 80 ಎಕ್ಸೆಟ್ರಾ, ಅದರಲ್ಲಿ ಯಾರ ಮೇಲೆ ಲಯಬಿಲಿಟಿ ಬಂದಿದೆ ಕೊನೆಗೆ?
ಬಟ್ ಅಲ್ಲೂ ಕೂಡ 50% ಕಾಂಟ್ರಿಬ್ಯೂಟರಿ ನೆಗ್ಲಿಜೆನ್ಸ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅದರಲ್ಲಿ
ಅದು ಇಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿಲ್ಲ. ಮಿಸ್ರೀಡಿಂಗ್ ದಟ್. ಆ ಫೈಂಡಿಂಗ್ ಇಲ್ಲಿ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿಲ್ಲ. ಪ್ಯಾರಾ 8 ಅಲ್ಲಿ ಏನ್ ಹೇಳ್ತಾರೆ ಅಂದ್ರೆ ಅವರು they were not the driver or the insured. ಅವರು they are the third parties. ಅದಕ್ಕೆ ಯಾರ್ದು ನೆಗ್ಲಿಜೆನ್ಸ್ ಇದ್ರೆ it doesn't make any difference for them ಅಂತ ಹೇಳ್ತಾರೆ.
on that extent contributory negligence
where it shows that it is set aside contributory negligence finding.
ಕಂಟಿನ್ಯೂ ಅದೇ ಇದರಲ್ಲಿ ಪ್ಯಾರಾದಲ್ಲಿ therefore last line malash, therefore the finding recorded by the claims tribunal that the claimants are entitled to 50% of compensation is hereby set aside.
Correct. ಯಾಕೆ ಅಂದ್ರೆ in those cases claimants were not the driver, they were just inmates. ಅವ್ರಿಗೆ it makes no difference. 50% ಅವ್ರಿಗೆ insurer of that car and insurer of the lorry, both of them will pay because in your case he was the driver.
ಇದಕ್ಕೆ ಸಂಬಂಧಪಟ್ಟ my lordship kindly see the findings of the tribunal in my case my lordship.
One thing, relying on the evidence in this case, seeking modification is one thing. Relying on this judgment and seeking, saying that contributory negligence finding is set aside, that is incorrect.
Lordship, considering the
ಅಲ್ಲ ಅದು ಮಾಡಿದ್ದಾರೆ ಇನ್ನೊಂದು ಸರಿ ಹೇಳಿದ್ರು ಎಲ್ಲ ನಾನು ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ ಅಲ್ಲಿ ಇದು ಇತ್ತು ಅವನು he's admitted in the, he has admitted driver. ರಾತ್ರಿ 12ರಿಂದ 1 ಗಂಟೆ ಆಗಿತ್ತು. ಸಿಗ್ನಲ್ ಕೈಯಿಂದ ಸಿಗ್ನಲ್ ತೋರಿಸಿದೆ, ಅದು ಕಾಣ್ತಿರ್ಲಿಲ್ಲ, ಇನ್ನೊಂದು ಖಂಡಿತ ಇಲ್ವೋ ನನಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳೆಲ್ಲ ಹೇಳಿದ್ದಾರೆ.
The charge sheet filed against the driver of the offending vehicle, my lord. And also kindly see the.
We'll start dictation at 2:30, 1:30. ಅಲ್ಲ ಇದರಲ್ಲಿ ಇದೆ, ಅದು if you rely on that judgment that will not help you ಅಂತ ಹೇಳ್ತಿರೋದು.
Okay,
ಅವ್ರು ಹೇಳಿದ್ದು.
actually, Sumi, but considering the cross examination of RW1, driver of the offending vehicle.
Consider ಅಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, but still they have imputed some negligence.
Agrees.
A sketch of scene of accident ಅದನ್ನ ಲಾಸ್ಟ್ ವೀಕ್ ನೋಡಿ ತೋರಿಸಿದ್ರಲ್ಲ, ಫಸ್ಟ್ ಬಸ್ sketch is exhibit.
Exhibit. Sketch exhibit P5, my lord. P5.
ಡೆಫರ್ ಮಾಡಿದ್ದು ಇವ್ ಯಾವ ಪಾಯಿಂಟ್ಸ್ ಮೇಲೂ ಡೆಫರ್ ಮಾಡಿರ್ಲಿಲ್ಲ. ಅಡ್ವೊಕೇಟ್ಸ್ಗೆ ನೋಷನಲ್ ಇನ್ಕಮ್ ಕೊಟ್ಟಿರೋದು ಎಷ್ಟಿದೆ ತೋರಿಸಿ ಅಂತ 20,000 ತಗೊಂಡು
20,000. Coordinate bench also in another matter 20,000.
20,000
confirmed by.
ಏಕೆ ಭಟ್ ಅವರು ಯಾವ್ದಾದ್ರು ಅಡ್ವೊಕೇಟ್ಗೆ ಪ್ರೊಫೆಷನಲ್ಗೆ ಏನಾದ್ರು ನೋಷನಲ್ ಇನ್ಕಮ್ ಕನ್ಸಿಡರ್ ಮಾಡಿದ್ದು ಯಾವ್ದಾದ್ರು ಜಜ್ಮೆಂಟ್ ಇದೆಯಾ?
ಇಲ್ಲ, ಪ್ರೊಫೆಷನಲ್ಸ್ಗೆ the income is to be on a higher pedestal, number one. Number two, as the age advances, ಇಲ್ಲ ಇದು ತಾವೇ ರೀಸನ್ಸ್ ಕೊಟ್ಟು ಬರ್ಬೋದು. as the age advances, the income will be certainly be more.
ಆದ್ರೆ ಉಳಿದ ರೆಕಾರ್ಡ್ ಅಲ್ಲಿ ಭಾಸ್ಕರ್ ಮುನಿಕೃಷ್ಣ ಅಂತ ಇದೆ, ನೇಗೌಡನ ಮುನಿಕೃಷ್ಣ. Why the name of the father is not similar? Death certificate ಅಲ್ಲಿ ಮತ್ತೆ ನೀವು ಮೋಟಾರ್ ಆಕ್ಸಿಡೆಂಟ್ ಅಲ್ಲೆಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಬೇರೆದ್ ಬರುತ್ತೆ, ಅದರಲ್ಲಿ ಕೃಷ್ಣನ್ ಅಂತ ಇದೆ. ದಿಸ್
ವೆಡ್ಡಿಂಗ್ ಕಾರ್ಡ್, ವಿಸಿಟಿಂಗ್ ಕಾರ್ಡ್ ಎಲ್ಲ ಕೊಟ್ಟಿದೆ.
ಎಲ್ಲ ಮುನೇಗೌಡ ಅಂತ ಇದೆ, ತಂದೆ ಹೆಸರು ಏನೋ ಬೇರೆ ಇದೆ ಅದರಲ್ಲಿ. ಇಲ್ಲಿ ಕೃಷ್ಣಪ್ಪ ಅಂತ ಇದೆ, ನೋಡಿ. ಆಮೇಲೆ ಬೇರೆದ್ರಲ್ಲಿ ಅಥೆಂಟಿಕೇಟೆಡ್ ಡಾಕ್ಯುಮೆಂಟ್ ಎಲ್ಲ ಇಲ್ಲ ಇದೆ. ಅವ್ರ ವೆಡ್ಡಿಂಗ್ ಕಾರ್ಡ್ ಅಲ್ಲಿ ಅವ್ರು ಕೊಟ್ಟಿದ್ರಲ್ಲೇ ಸಣ್ಣ ಮುನಿ ಕೃಷ್ಣಪ್ಪ ಅಂತ ಇದೆ. ಯಾಕೆ ಈ ರೀತಿ ಬೇರೆ ಬೇರೆ ಹೆಸರು, ತಂದೆ ಹೆಸರು ಬೇರೆ ಬೇರೆ ಇದೆ? ಆದ್ಮೇಲೆ ನೋಡಿ.
ಇಟ್ಟಿದ್ದಾರೆ.
Further hearing? Cell number 41.
See, we may not be able to take up any matters except this up to 45, serial number 45. Anybody waiting after 46? Which 46 adjourn ಆಗಿದೆಯಲ್ಲ?
46 adjourned.
47?
Cell number 47, Shripad V. Shastri. Online ಅಲ್ಲಿ. Shripad V. Shastri.
Again, list after list after 2 weeks. 2 weeks, 2015 ಇದೆ. Date ಕೊಡು.
27 to
27, list on 27.
48, Nagraj Damodar. B. Pradeep.
Same ಹಾಕ್ಬಿಡೋಣ.
ಅದು 27.
27, 48.
49, O. Mahesh.
ಇದು 2017 ಇದೆ ಸ್ವಲ್ಪ ಲಾಂಗ್ ಡೇಟ್. List after 2 weeks. 2 weeks. Adjourn ಅಂತ list after. ಯಾರೋ ಏನೋ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇರಬೇಕು.
Cell number
List
50,
after 2
51 adjourned. 52, Renuka HR. N. Channakrishnappa.
List after 2 weeks.
53, Chandrasekharaya B. B. Pradeep.
List after 2 weeks.
54, KP Bhuvan.
Respondent, I filed my objection.
ID 54 ಅಲ್ಲಿ. You have filed applications. What are those applications?
No, I have not filed. I have filed objection, madam. Application to main petition.
Correct. What are those applications?
IA number 2 was for the stay and IA number 3 was for the interim entrance.
Karnataka respondent submits that counter to IA 2 and 3 of 2018 are filed in the registry. Registry shall verify and list after 2 weeks.
55,
2
O.
weeks.
O. Mahesh. A.K. Bhatt.
List after 2 weeks.
56 adjourned. 57, X. Rajshekhar. K.J. Sadashivaya.
After 2 weeks. Same.
58, Shriram Timupanayak.
Same.
Beulah Jamima.
Same. After 2 weeks.
2 weeks. 59, KP Bhuvan. B.S. Umesh.
ಇದು నేను ಅವ್ರಿಗೆ ಹಾಕಂತ ಹೇಳಿದ್ವಿ. ನಾನು ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 10 days ಅಂತ ಮಾಡಿ.
60, Deshraj.
ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ ಪೆಂಡಿಂಗ್ ಇದೆಯಾ? 2022 ಏನಿದೆ ಅರ್ಜೆಂಟ್ ಏನಾದ್ರು ಇತ್ತು ಅದರಲ್ಲಿ? ಆಯ್ತು ಬರ್ರಿ ಕರ್ಕೊಂಡು ಬೇರೆ ಆಯ್ತು ಬಂದಾಗ ನೋಡು. Matters are adjourned only up to 45. 2-3 days we may not be able to take up in the afternoon session.
Lordship, serial number 44, my lord.
Adjourn 44.
ತಗೊಳ್ತೀವಲ್ಲ ಫೈನಲ್ ಡಿಸ್ಪೋಸಲ್ ಇದೆ.
ಡಿಸ್ಮಿಸಲ್.
Lordship, ಅದು ನೀಡ್ಫುಲ್ ಡನ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ, ಪ್ರೋಸೆಸ್ ಕಟ್ಟಿದೀನಿ. ಡಿಸ್ಮಿಸಲ್ ಇದೆ.
ಮಾಡ್ಬೇಕು ನೀವು ಅದು ಮಧ್ಯದಲ್ಲಿ ಮತ್ತೆ ತಗೊಳ್ಳೋದಿಲ್ಲ. ಅದನ್ನೇ ನಾವೀಗ ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ
Cell number 41.
Respondent number 2. ಅಲ್ಲ ಹೆಸರು ಬೇರೆ ಶೀಟ್ ಅಲ್ಲಿ ಸಡನ್ ಆಗಿ ನಿಲ್ಲಿಸಿದ್ದಾರೆ. ಒಂದು ಬಾರಿ ದೂರದಿಂದ ಐದು ಸ್ಪೀಡ್ ಬ್ರೇಕ್ ಅರ್ಜಿಗಾರ ಕನ್ನಡದಲ್ಲಿ ಇದ್ದವರೆಂದರೆ ಸರಿ ಮಾಡ್ತಾನೆ. ನಾನು ಸ್ಪೀಡ್ ಬ್ರೇಕರ್ಗಳನ್ನು ಗಮನಿಸಿದೆ. ಅಂದ್ರೆ ಅವ್ನು ಸ್ಪೀಡಾಗಿ ಬಂದಿರಕ್ಕೆ ಸಾಧ್ಯ ಇಲ್ಲ, ಹಿಂದೆ ಸ್ಪೀಡ್ ಬ್ರೇಕರ್ಸ್ ನನ್ನ ಬೆಳಕೈ ತೋರಿಸಿ ಸೂಚನೆ ಕೊಟ್ಟಿದ್ದೆ. ರಾತ್ರಿ 12ರಿಂದ 1 ಗಂಟೆ ಸಮಯದಲ್ಲಿ ಕೈ ತೋರಿಸಿಕೊಡುವಂತ ಸಿಗ್ನಲ್ ಹಿಂದಿನವರಿಗೆ ಕಾಣುವುದಿಲ್ಲ. ನಮಗೆ ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳ್ತೇನೆ. ಸಿಗ್ನಲ್ ಕಾಣದೇ ಇರೋದ್ರಿಂದ ಲಾರಿ ಇಂಡಿಕೇಟರ್ ಸಿಗ್ನಲ್ ತೋರಿಸಬೇಕಿತ್ತು ಅಂದ್ರೆ ಲಾರಿಯಲ್ಲಿ ಇಂಡಿಕೇಟರ್ ಇರಲಿಲ್ಲ ಅಂತ ಹೇಳ್ತೇನೆ. ಅದಕ್ಕೆ 100% ಅವ್ರಿಗೆ ಹಾಕ್ಬೇಕಾಗುತ್ತೆ.
Alerts on submission, alerts. Serial number 58. It's adjourned. Date may be fixed, alerts. Last time I had argued on the matter. A date may be at least fixed.
And on road here, see what of see, we have some administrative.
Yes, alerts.
For
A
three,
date- a
3,
date
4
may-
days, we may not be able to take up in the afternoon session.
Alright.
4-3.
This appeal is preferred by the claimants challenging the judgment and award in the list of the 3678 alone passed by the fifth additional small causes judge and 24th ACMM, member NACP, Neohar Unit, Bangalore. The appellants were claimant number 1 and 2 and respondents. Response were respondent number 1 and 2 in MVC number 3678 of 2011 before the tribunal. For the purpose of convenience, the parties are referred to henceforth according to the ranks for the tribunal. Claimant number 1 is the wife and 2 is the mother of deceased Bhaskar on 26/6/2010 at 0040 AM when Bhaskar was driving car bearing registration number K03 ME7224 near Gambiranahalli village, Jangamakote Hobli, Siddaghatla Taluk. Ashoka Leyland lorry bearing registration number K075224. It was driven by RW1 is Rajavalli. RW1 S.A. Rajavalli was proceeding in front of the same car. And suddenly stopped. Resultantly, Bhaskar's car rammed into the lorry from the hindsight. In the accident, Bhaskar and one Munegowda suffered grievous injuries. Suffered grievous injuries and died. And other inmates, there are many other pictures of the car suffered injuries. At the time of the accident, respondent 1 and 2 were the registered owner and insurer of lorry bearing registration number K07 -5224. Claimants filed MEC 3678 of 2011 against the respondents, contending that the driver of Bhaskar was driving the car following all traffic rules, but the driver of the lorry was driving the same in high speed and suddenly without any indicators applied the brake and stopped the lorry. Resultantly, the car of Bhaskar collided on the hindsight in the lorry. They contended that the accident and death of Bhaskar occurred solely due to the actionable negligence on the part of the driver of the lorry. They further contended that deceased was working as was a practicing advocate and earning rupees 50,000 per month. And they were all dependent, both of them were dependent, solely dependent on his income. They further claimed that due to his death, they have suffered pecuniary and non-pecuniary loss amounting to rupees 30 lakhs, and the respondents are liable to compensate the same. Respondent number 1 did not contest the petition, though he tendered his evidence as RW1. Respondent number 2, the insurer, contested the petition, denying the actionable negligence on the part of the driver of lorry / RW1, and contended that Bhaskar himself was driving the car in rash and negligent manner and was solely responsible for the accident. Respondent number 2 further denied the age, occupation and income of the deceased and its liability to pay compensation. Before the tribunal, claimant number 1 was examined as PW1. Before tribunal, claimant was examined as PW1, and on behalf of the claimants, exhibit P1 to P21 were marked. On behalf of respondent number 2, RW1, the driver of the lorry, was examined, and RW2 connected the administrative officer of respondent 2 was examined as RW2. On behalf of respondent 2, exhibit R1 and R2 were marked. But they refer to that. The tribunal, on hearing the parties by the impugned judgment and award, held that the accident occurred, held that deceased Bhaskar and RW1 contributed 50% negligence each in occurrence of the accident. Tribunal considered the age of the deceased as 45 years. Notionally assessed his income at rupees 20,000 per month, deducted 1/3 from the same for his personal expenses, applied 13 multiplier, and awarded compensation of rupees and assessed compensation of rupees 20,80,104 on the head of loss of dependency. Tribunal in all awarded compensation of rupees 21,65,104 on different heads as follows. The judgment and page number of the appeal memo synopsis. awarded an assist on deducting 50% out of the aforesaid amount towards the contributory negligence of the deceased. Tribunal awarded compensation of this 10,82,552 with interest at 6% per annum payable by respondable to the insurer. The claimants have challenged the said awarding above appeal. Questioning the finding regarding the contributory negligence and the quantum of compensation awarded. Shri so and so learned counsel for the appellant claimants Srinivas Kumar DC na
Vijay Kumar ಅಂತ ಅವರು.
Vijay Kumar ಅವರ ಹೆಸರೇ ಬರ್ಕೊಳ್ರಿ. ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು ಲಾಸ್ಟ್ ಟೈಮ್ ನೀವೇ ತಾನೆ. Submissions of Shri Vijay Kumar into level document. After he only argued last time. ಇಲ್ಲ ಅದೇ ಅವರೇ ಲಾಸ್ಟ್ ಟೈಮ್ ಇವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರು. She has come this time only because it is by dictation. Last time ಇವರೇ ಇದ್ರಲ್ಲ ಅಂತ. Sorry. On the investigation, on thorough investigation, the police submissions of claimants and haki on the complaint of ಯಾರು complaint file ಮಾಡಿದವರು Srinivasaya. I think he was one of the inmate ಅಲ್ವಾ Srinivasaya complaint ಕೊಟ್ಟವರು injured. ಇಲ್ಲ ನಾನು ಮಲಗಿದ್ದೆ ಯಾರೋ ಬಂದು ಹೇಳಿದ್ರು on the complaint of one Srinivasaya. He is a relative of deceased ಅಲ್ಲ Srinivasaya. Interlocutory Rural Police on thorough investigation filed the charge sheet as per Exhibit P2 against the driver of the lorry. Eyewitness examine. She was injured. She has also filed another petition at the 14th. She is a party as event petition. Filed charge sheet against driver of lorry / RW1. Further, PW1 herself was the inmate of the car and injured eyewitness. She has also spoken about the negligence of RW1 in driving the lorry. RW1 himself, in his cross-examination, has given sweeping admissions showing his negligence, his exclusive negligence, absolute negligence in the occurrence of the accident. The tribunal, without properly appreciating the evidence, has recorded tribunal has imputed 50% negligence to the deceased himself, which is thoroughly erroneous. The compensation awarded by the tribunal, deceased was practicing advocate in a bank statement ಕೊಟ್ಟಿದ್ರು. Bank statement ಅಲ್ಲಿ ಏನೋ ಅದೇ ಇಲ್ಲ. Practicing advocate, aged 45 years. 45 years. Therefore, the notional income considered by the tribunal is on the lower side. Compensation awarded on the other heads is also on the lower side. So, submissions of Srinivasaya. K.N. Srinivas, counsel for R2. the charge sheet is not a conclusive proof of the negligence. Except PW1, no other eyewitnesses were examined by the claimants. The evidence and record shows that deceased had not maintained respectable distance and he was also rash and negligent in driving the car. The evidence of RW1 shows that there were speed breakers. Therefore, RW1 could not have driven the lorry in high speed soon after crossing those road humps. The order of the tribunal, the finding of the tribunal regarding the negligence is based on the material on record that does not warrant any interference. There was no proof of actual income of the deceased. Therefore, notional income considered by the tribunal is just one. And the future prospects ಕೊಟ್ಟಿಲ್ಲ ಅದೊಂದು ಹೇಳಿಲ್ಲ. ನಿಮ್ಮ argument ನಲ್ಲಿ future prospects is not avoided by the tribunal. ಅವರ argument ಇಲ್ಲ ಅವರ argument ನಲ್ಲಿ tribunal committed error in not awarding future prospects on the income of the deceased. The appeal is liable to be dismissed. Next one. You do not refer to your judgment only. That is in no way helpful to you. That judgment is in no way helpful to you. And considering the submissions of both sides and an examination of the material and record, the questions that arise for consideration of this in this court are: number one, whether the finding of the tribunal that the accident between the car car number K03ME7224 and lorry number K075224 occurred due to 50% contributory negligence of deceased Bhaskar and RW1, the driver of the lorry, is sustainable. Number two, whether the compensation awarded by the tribunal is just one. Next, regarding point number one, regarding negligence is the point. None of the parties dispute that on 26/6/2010 at 0040 hours near Gambirnahalli village, when Bhaskar was driving car number K03ME7224 and RW1 was driving Ashok Leyland lorry bearing number K075224. The car hit the lorry from the hind side. It's also not disputed that in the accident, Bhaskar and Munigowda, there is one more death, and Munigowda died. Other inmates of the car, including claimant number 1/PW1, sustained injuries. It is also not disputed that regarding the accident, on the complaint of one Srinivasaya, Sidlagatta rural Sidlagatta rural police registered FIR in crime number 162 of 2010 against RW1, the driver of the lorry, driver of driver of the lorry. And on investigation, charge sheet as per exhibit P2 was filed against RW1 for the offenses punishable under section 279, 337, 304A and 338 IPC. ಎಷ್ಟು ಜನ injured ಇದ್ದಾರೆ ಅನ್ನೋದು ಇದರಲ್ಲಿ. The contention of the claimants is that RW1 was driving the lorry in rashly and negligently and in the high speed and without any indicators suddenly stopped the lorry, which caused Bhaskar which resulted in car bearing number which resulted in due to which Bhaskar was unable to stop car number K03 ME7224 and that hit the lorry from hindsight, leading to accident and death. PW1 it is the settled position of law that please take your seats. It is a settled position of law that the proceedings under section 166 of proceedings under section 166 of the MA Act are summary proceedings and the principles of proof beyond reasonable doubt is not applicable and the evidence has to be appreciated on the on the principle of preponderance of probability. It is not true that the charge sheet is not the conclusive proof of the facts stated therein, but that has a presumptive value under section 114E of the Evidence Act. Coupled with the charge sheet, PW1, another inmate of the car and who was also injured, slash wife of the deceased, claimant number 1 issues. In her chief examination, spoke about the rashness and negligence on the part of RW1, which led to the occurrence of the accident. In her cross-examination, she denied the suggestions. Sketch it is to that as per the sketch. Extreme left side another one procedural. She denied the suggestion that her husband was responsible for the accident and not RW1. Whereas RW1 ಒಂದ್ಸರಿ ಮುಂದಿತ್ತು ಅನ್ಸಿರ್ತಾರೆ, ಇನ್ನೊಂದ್ಸರಿ ಹಿಂದಿತ್ತು ಅಂತ ಹೇಳಿದ್ರು. ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇಲ್ಲಿ ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಮುಂದಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ, ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಅದ್ರ ಹಿಂದೆ ಸ್ಪೀಡ್ ಬ್ರೇಕರ್ಸ್ ಇತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. Though RW1 in his chief examination claimed that when he was driving the lorry, he was driving the lorry in slowly and following traffic rules. And on seeing the speed breakers. And he's in front of the lorry, he's slowed down the lorry, but the victim himself came in a high speed and dashed against his vehicle. In the cross-examination, he says that the speed breakers were behind his lorry. That means he had crossed the speed breakers. In the the tribunal itself points out the additions of RW1 that the lorry had no indicator lights, no signal indicator lights. He admitted that the accident occurred between 12 midnight and 1 a.m., which is a pitch dark time. He says that he gave signal by waving his right hand. He gave signal to the vehicles which are coming behind him by waving his right hand. To the question that during such night hours, such hand signals are not visible to the persons who are coming behind the vehicle, he is pleaded his ignorance. If even assuming that the speed breakers were behind his vehicle, then there is no possibility for the victim to drive his car in a high speed. Nothing could be brought out in the evidence of RW1 to impeach the prima facie evidentiary value of the charge sheet, which was further corroborated by the evidence of PW1. The said evidence was not rebutted. But despite such being the things, the tribunal says that the driver of the car should have maintained respectable distance, and if he was driving slowly, the accident could not have occurred. The evidence and the above referred evidence shows that when there were speed breakers, the Bhaskar could not have driven the car in a high speed or rashly and negligently, and he could not have seen the lorry which was suddenly stopped due to such, which was suddenly stopped only with the indicator lights during such dark hours. Therefore, the conclusion of the tribunal that Bhaskar, who was driving the car, also contributed in the occurrence of the negligence accident is contrary to the evidence on record and unsustainable. The entire negligence has to be imputed to RW1, the driver of the lorry. Next one, regarding quantum. The claimants contended that deceased was earning rupees 50,000 per month by his advocate's profession. No, it is true that they had proved that he was a practicing advocate, but his income of this 50,000 per month was not established. If he was earning rupees 50,000 per month, certainly would have submitted income tax returns. But the same was not the case, but it was not the case of the claimants that deceased was an income tax assessee and paying the income tax. The bank statements, exhibit P17 and 18, the bank statement and the passbook, exhibit P17 and 18, did not indicate that he had income of this 50,000 per month as alleged. Therefore, Tribunal was justified in assessing his income notionally at rupees 20,000 per month. 2010 alla 2000 during ಎಲ್ಲ ಒಂದು ಕೇಸ್ ಲಿಸ್ಟ್ ಹಾಕಿಲ್ವಲ್ಲ ನೀವು ಇಷ್ಟು ಕಂಡಕ್ಟ್ ಮಾಡಿದ್ರು ಅಂತ. ಕರೆಕ್ಟ್ 16 ಯು ಶುಡ್ ಪ್ರೊಡ್ಯೂಸ್ ಸಮಥಿಂಗ್. ಅದಕ್ಕೆ ನಾವು ಹೇಳಿದ್ವಿ ಇನ್ಯಾವುದಾದ್ರೂ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದಕ್ಕಿಂತ ಜಾಸ್ತಿ ತಗೊಂಡಿದ್ರೆ ತಂದು ತೋರಿಸಿ ಅಂತ. ನೀವು ಅದನ್ನು ತೋರಿಸಿಲ್ಲ. However, justified. In the light of the ratio in the judgment in Pranay Sethi's case, and having regard to the age and occupation of this deceased, Tribunal ought to have awarded future prospects Pranay Sethi's case on the income of the deceased at 10%. 10%. He was 42 feet. Sorry, ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀನಿ ಒಂದೇ ನಿಮಿಷ. ಕರೆಕ್ಟ್. ಇನ್ನೂ ಎಷ್ಟು ತಗೊಂಡಿದ್ದೀನಿ? 25% ತಗೊಂಡಿದ್ದೀನಿ. ಸರಿ, ನೆಕ್ಸ್ಟ್ ಕೇಸ್ ಇರ್ಬೇಕು. 25%. 25%. Therefore, his monthly income comes to 20,000 plus 40% ಅಂದರೆ 6,666. ಎಷ್ಟು ಆರ್ಡ್ ಬಂದಿತ್ತು ಅಷ್ಟು ತಗೊಂಡಿದ್ದೀನಿ. 6,666. ಅಲ್ಲ, ಅದನ್ನು ಮೊದಲು ಡಿಡಕ್ಟ್ ಮಾಡಿ ಅದ್ರ ಮೇಲೆ ಮಾಡಿದ್ದೀನಿ ನಾನು. ಕರೆಕ್ಟ್. ಅವ್ರದ್ದು 1/3 ಡಿಡಕ್ಟ್ ಮಾಡಿ 20,000 1/3 ಎಷ್ಟಾಗುತ್ತೆ ನೋಡಿ? 6,666 ಆಗುತ್ತಲ್ಲ. ಅದನ್ನ ಮಾಡಿದ್ಮೇಲೆ 40% ಸೇರಿಸಿದ್ದೀನಿ. 40% ಅಷ್ಟೇ ತಗೋಬೇಕು, ವಿಚ್ ಕಮ್ಸ್ ಟು ಅಂತ ಬೇಡ. 25%. ಆಮೇಲೆ therefore ಇನ್ನೊಂದು out of the, since the deceased had 2 dependents, as per judgment of the Supreme Court in Sarala Orma's case, 1/3 has to be deducted from the income of the deceased for his personal expenses, and for his age applicable multiplier is 13. And deducting 1/3 for his personal expenses, the income of the deceased per month would be 20,000 minus 6,666 is equal to 13,334. And adding 25% towards future prospects, ಅದೆಷ್ಟು 3,333.25 ಬರುತ್ತಾ? 13,334 ಅದು 333.25 ಬರುತ್ತೆ. Deducting 1/3 for ಅದಾಯ್ತು. The income would be 13,334. 25% of the same would be 3,333.25. Therefore, his total income per month is 16,660. The 13,334 plus 3,333.25 ಮಾಡಿ rounded to 16,667. And compensation payable on the head of loss of dependence would be 16,667. ನಾನು ಅದನ್ನ ನೋಡ್ಕೊಂಡ್ ಮಾಡಿದ್ನ ಪೇಜ್ 45 ಅಲ್ಲ 45 ಕಂಪ್ಲೀಟ್ ಆಗಿತ್ತು ಅನ್ಸುತ್ತೆ ಅಲ್ವಾ? ಎಷ್ಟಾಗುತ್ತೆ age? ನಾನು ಇಲ್ಲ ಬರ್ತೀನಿ. ಇಲ್ಲಿ ಬರ್ತೀನಿ. 26/6/2000 date of birth. So he had completed 44 years. So ಅಂದ್ರೆ ಅಲ್ಲಿ 44 ಅವ್ರೇನು ಹೇಳಿರ್ಲಿಲ್ಲ ನಾನು 13 ತಗೊಂಡು ಅಲ್ಲೆಷ್ಟು ಅಪ್ಲಿಕಬಲ್ ಮಲ್ಟಿಪ್ಲೈಯರ್ ಇಸ್ ಹಂಗಂದ್ರೆ ಏನು ಸ್ವಲ್ಪ ಹೇಳಿದ್ನಲ್ಲ 14 ಅಲ್ಲಿ ನಾವು 45 years ಅಂತ ಹೇಳಿದ್ವಿ. had completed 44 years, not 45. 21ಗೆ 2010ಗೆ 44 45 ಅಂತ ಹೇಳಿದ್ವಿ. 44 ಅಂತ ಇಲ್ಲಿ ಬರ್ಕೊಂಡಿದ್ದೀನಿ, ಇಲ್ಲಿ ಬರ್ಕೊಳ್ಳೋದು 44 years. ಇವರು 39 years ಅಂತ ಹೇಳಿದ್ರು ಪಿಟಿಷನ್ ಅಲ್ಲಿ.
His total income per month is ₹16,667
into 12 into 14 ಆಗುತ್ತೆ. ನಾನು ಇಲ್ಲಿ ಮಾಡಿದ್ದು ಒಂದು ತಪ್ಪಾಗಿದೆ ಅಷ್ಟೇ. ಅದೆಷ್ಟಾಗುತ್ತೆ ನೋಡಿ ಕೋರ್ಟ್ ಆಫೀಸರ್? 28,000 28 lakhs 56
into 14 28,56,000.
ಇದ್ರ ಮೇಲೆ ಕೊಟ್ಟಿದ್ದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದ್ದಂಗಿದೆ ಅಲ್ಲ, ಅದೇನು ಬರೀ ಎಸ್ಕಲೇಷನ್ ಅಷ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ. ಇಲ್ಲ ಅದು ಏನೋ ಲವ್ ಅಂಡ್ ಅಫೆಕ್ಷನ್. As per the judgment of the Supreme Court in Karnataka this case and Magna General Insurance Company's case, compensation of is 40,000 on the head of consortium is with the escalation at 10% is payable to claimant number 1 and 2 each. Similarly, on the conventional heads of loss of estate and funeral expenses, they are entitled to compensation of 15,000 plus 15,000 with escalation at 10%. Over total estimate. Therefore, the just compensation payable is as follows. ಇದು 88,000 ಆಗುತ್ತಲ್ಲ ನೋಡಿ. 28,56,000, 88,000, 33,000,
29,21,050.
loss of dependency 28,56,000, consortium 88,000, funeral expenses 16,500, future prospect loss of estate 16,500, total
29,21,056.
29,21,056. ಏನು ರೌಂಡ್ ಮಾಡೋದು? ಅವ್ರು ಇಲ್ಲೇ ಮಾಡಿಫೈ ಮಾಡಬೇಕಾಗ್ತಿರತ್ತೆ ಅಲ್ಲ, ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಅಷ್ಟೇ ಅಲ್ಲ, ಇದರಲ್ಲಿ 2 ಫೈಂಡಿಂಗ್ ಚೇಂಜ್ ಆಗಬೇಕಲ್ಲ, ಅದಕ್ಕೆ ಮಾಡಿಫೈಡ್ ಆಸ್ ಫಾಲೋಸ್ ಅಂತ. ದ ಅಪೀಲ್ ಡಿಸರ್ವ್ಸ್ ಟು ಬಿ ಅಲೋಡ್ ಇನ್ ಪಾರ್ಟ್ ಅಂತ ಹಿಂಗೆ ಮಾಡಿದ್ನಲ್ಲ, ಅದಕ್ಕೆ there is no dispute that the lorry was covered by the insurance policy issued by respond number 2. Therefore, respond number 2 is liable to compensate the damages. Is liable to deposit the compensation with interest at 6% per annum. Hence, the appeal deserves to be allowed in part. Hence, the following order. The appeal is allowed in part. The impugned award is impugned award passed by the tribunal in emissal number 3678 of 2021 is modified as follows. The claim petition is partly allowed. Claimants are entitled to compensation of rupees 29,21,056 with interest thereon at 6% per annum from the date of the petition. Order ಆಗಿತ್ತಾ ಇದೇ ಕೇಸಲ್ಲಿ ನಾನು 4438 ಹೇಳಲ್ಲ.
The claim petition is partly allowed. The claimants are entitled to compensation of rupees 29,21,056 with interest thereon at 6% per
annum from the date of the petition till its realization, excluding 169 days delay. The single judge ಮುಂದೆ ಇದು ಮಾಡಿದಾರಲ್ಲ, ಇಂಟ್ರೆಸ್ಟ್ ಡಿನೈ ಮಾಡಿದ್ದಾರೆ, excluding the
Denial.
169 days, that is the delay, period of delay in filing the appeal. Respond number 2, the insurer shall deposit the aforesaid compensation before the tribunal within 6 weeks. 6 weeks. For said compensation. Within 4 weeks from the date of the receipt of a copy of his judgment. ಅದರಲ್ಲಿ ಅವರು ಅಪೋರ್ಷನ್ಮೆಂಟ್ ಅಮೌಂಟೇ ಮಾಡಿಬಿಟ್ಟಿದ್ರು ಅವ್ರಿಗಿಬ್ಬರಿಗೂ. ಹೇಗೆ ಮಾಡೋದೀಗ ಅಪೋರ್ಷನ್ಮೆಂಟ್? ಮದರ್ ಇದ್ದಾರ? ಬೇರೆ ಮಕ್ಕಳು ಯಾರು ಇಲ್ವಾ ತಾಯಿಗೆ?
ಇರ್ಬೋದೇನೋ ಗೊತ್ತಿಲ್ಲ ಸುಮ್ಮನೆ.
ಏನು ಮತ್ತೆ she has not remarried also, this lady?
No.
The claimant number 1 and 2 are entitled to compensation in the ratio of 70% and 30% each. Okay. Mother, on deposit of the amount, tribunal shall release 50% of 2011.
70% release.
50%.
More than 10 years.
Interest ಬಂದಿರುತ್ತಲ್ಲ ಅದ್ರ ಮೇಲೆ.
Interest ಜಾಸ್ತಿ.
ಈಗ ಸಬ್ಸ್ಟಾನ್ಷಿಯಲಿ ಇನ್ಕ್ರೀಸ್ ಆಯ್ತು. 29 lakhs ನೋಡಿ ಅಲ್ಲಿ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ರು ನೀವು ತಗೊಂಡಿಲ್ಲ. 21 lakhs ಇದ್ದದ್ದು. And she is a widow. ಬೇರೆ ಯಾರಾದ್ರೂ ಬೆನ್ನತ್ಕೊಂಡು ಕೂತ್ಕೊಳ್ತಾರೆ. So and so, on deposit of the amount, tribunal shall release 50% of the share of claimant number 1. ಇಬ್ಬರಿಗೆ 15 ಇಲ್ಲ ಅವ್ರಿಗೆ to her digitally and invest the balance amount of her share in any nationalized/scheduled bank of her choice for a period of 3 years. ಇದ್ರದ್ದು ಇವ್ರದ್ದು ಏನ್ ಮಾಡೋಣ, 1 ವರ್ಷಕ್ಕೆ ಮಾಡೋಣ. The share 75% out of the share of claimant number 2 shall be digitally released to her, and 25% of her share shall be invested in FD in any nationalized/scheduled bank of her choice for 1 year. For 1 year.
Motherಗೆ 1 year.
TCR. Trial court record may be attached.
The TCR ಅವ್ರದ್ದೇನು ಅಪೀಲ್ ಇಲ್ವಲ್ಲ, ಹಾಗಾಗಿ
ಇಲ್ಲ.
To the tribunal forthwith.
For further hearing, seal number 42, Gopal Krishnayan, FC Bitsur, for R2.
Claimants.
Copy of the judgment. ಇಲ್ಲ ನಾವಿದೆ ಯಾಕೆ
Appellant.
ಇವನು ಅಪ್ರಿಷಿಯೇಷನ್ ಆಯ್ತಾ, ಇವನು ಇಲ್ಲಿ ಬಂದು ಸಪೋರ್ಟ್ ಮಾಡಿದಾನೆ ರವಿಕುಮಾರ್ ಅನ್ನೋನು. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ ಅಂತ ನೋಡೋದಕ್ಕೆ ರವಿಕುಮಾರ್ ಕಂಪ್ಲೇನೆಂಟ್, ಹಿ ವಾಸ್ ದ ಕಂಪ್ಲೇನೆಂಟ್. ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ ಅಂತ ನೋಡಿದ್ರೆ ಇಲ್ಲಿ ಅವನು ಐ ವಿಟ್ನೆಸ್ ಆಗಿರೋದನ್ನು ಸಸ್ಪೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ. Nowhere his evidence is stated that he has witnessed the accident in question. As such, his evidence cannot be relied ಅಂತ ಹೇಳಿ. ಆಮೇಲೆ ಅಂದ್ರೆ ಏನ್ ಮಾಡ್ತಾರೆ, ಮೋಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸಲ್ಲಿ ಇಲ್ಲಿ ಬಂದು ಅಂತ ಹೇಳ್ತಾರೆ, ನಾನು ಬಿಡ್ಸಕ್ಕಲ್ಲ ಮಾಡಿದ್ದೆ ಅಂದ್ರೆ ಇಲ್ಲ, he has not lodged any complaint ಅಂತ. ಅಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವ್ನು ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡಿದ್ದೆ ಡಿನೈ ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ. ದಿಸ್ PW2 Ravikumar. Here he comes and says that he has filed the complaint. Now he was the eyewitness. Criminal case judgment shows that he has denied filing the complaint. There is nothing in the evidence of PW1 to show that accused being the driver of the vehicle in question. No vehicle is seized in his presence. Deny ಮಾಡಿದ್ದಾರೆ. Owner of the vehicle. ಇದು dismiss ಆಗಿತ್ತು, tribunal court ಅಲ್ಲಿ dismiss ಆಗಿತ್ತಲ್ವಾ? ಇದು ಅನ್ಸುತ್ತೆ. ಮೊನ್ನೆ ಮಾಡಲ್ಲ, ಇಲ್ಲ. Challenging the dismissal of the fictions. The claim fiction. The claim fiction. Claimants in MEC number 4710 of 2014 on the file of 13. ಇಲ್ಲ ಅವರು ಹೇಳಿದ್ವಲ್ಲ, ಅವ್ರಿಗೆ ಹೇಳಿದ್ವಿ, ಅವ್ರು ಹೌದೌದು ಅಂತ ಹೇಳಿದ್ರು. ಅವ್ರ ಐ ವಿಟ್ನೆಸ್ ಇರೋದು ಕಂಪ್ಲೇಂಟ್ ಡಿಸೋನ್ ಮಾಡಿದ್ದಾರೆ ಕ್ರಿಮಿನಲ್ ಕೇಸಲ್ಲಿ.
ಕ್ರಿಮಿನಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಬೇರೆ
ನೀವಿಬ್ರು ಕೊಡ್ಲಿಲ್ಲ, ನಾವೇ ನಮ್ಮ ಕೋರ್ಟ್ ನಮ್ಮ ಸ್ಟಾಫ್ ಹೆಲ್ಪ್ ನಿಂದ ತಗೊಂಡಿದೀವಿ. He has denied for having filed the complaint before the police.
That's for various reasons. They might have, because he was his friend. So
various reasons ಏನು ಅಲ್ಲಿ ಡ್ರೈವರ್ ಅನ್ನ see, if the vehicle and driver are planted, they will do this. ಇಲ್ಲ ನಾವು ನಿಜವಾಗೂ ಫ್ರೆಂಡ್ ಆಗಿದ್ರೆ ತನ್ನ ಫ್ರೆಂಡ್ ಕೊಂದವ್ರನ್ನ ಯಾಕೆ ಹೇಳ್ತಾರೆ?
ಅವನು ಫ್ರೆಂಡ್, ಅವನು ಆಕ್ಚುಲಿ ಡ್ರೈವರ್ ಆಲ್ಸೋ ಫ್ರೆಂಡ್.
ಅದಕ್ಕೆ ನೀವು ಕೊಡ್ಲಿಲ್ಲ ಅಂತ ಕಾಣಿಸುತ್ತೆ. ನಾವು ಅಷ್ಟು ದಿವಸ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ ಅಂತ ಕೇಳಿದ್ರೆ ಕೊಡ್ಲಿಲ್ಲ.
ನಮ್ಮ ಹತ್ರ ಅವಳು ಶಿ ಇಸ್ ವಿಡೋ.
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಸಿ ನಾವು ಡೌನ್ಲೋಡ್ ಮಾಡೇ ತಕೊಂಡಿದ್ರು. ಈಗ ಯು ವಾಂಟ್ ಟು ಗೋ ಥ್ರೂ ದಿಸ್ ಒನ್ಸ್ ಅಗೇನ್? ನಾವೇನ್ ಕೊಡೋದಿಲ್ಲ ನಿಮ್ಗೆ, ನೀವು ಹುಡುಕೋಬೇಕು.
ನೋಡ್ತೀವಿ ಸುಮ್ಮನೆ. ಐ ವಿಲ್ ಜಸ್ಟ್ ಡೌನ್ಲೋಡ್ ಅಂಡ್ ಸಿ.
ನೋಡ್ತೀರಿ ಅಂತ ಮತ್ತೊಂದ್ ದಿವಸ ಇಲ್ಲ ನೋಡ್ಬೇಕಾಗಿತ್ತು. ಇಷ್ಟೊತ್ತಿಗೆ ಆರ್ ಅಸಿಸ್ಟೆಡ್ ಬೈ ವೆರಿ ಯಂಗ್ ಜೂನಿಯರ್ ಎಲ್ಲ ಹುಡುಕ್ ಕೊಡ್ತಾರೆ, ಟೆಕ್ನೋಕ್ರಾಟ್ಸ್ ಇರ್ತಾರೆ ಅವರು.
ಒಂದ್ಸಾರಿ ನೋಡ್ತೀವಿ.
ಏನ್ ನೀವಿಬ್ರು ಕೊಡ್ಲಿಲ್ಲ? ಬೋತ್ ಕೌನ್ಸಿಲ್ ಹಿಂಗ್ ಬರ್ತಾರೆ. ಬೋತ್ ಕೌನ್ಸಿಲ್ have not produced the copy of the judgment, the date and last date order sheet. Order sheet copy. And order. Both council have not produced the copy of the judgment of the magistrate's court. In pursuance of any trial held on the basis of exhibit, trial held on the basis of exhibit P6, the charge sheet. However, and the same from the e-courts website, it is found that crime number estimated on the basis of exhibit P6, the charge sheet. The additional civil judge JMFC Hirur had registered, had taken cognizance on the basis of payment
on the basis of basic charge sheet.
Charge sheet filed in crime number 96 of 2014. The additional civil judge and JMFC Hirur took cognizance and registered case in CC number 569 of 2014. Conducted the trial and passed judgment. The printout of the said judgment is placed in the records. Heard further. Challenging the dismissal of their claim fiction. The claimants in MEC number 4710 of 2014 on the file of 13th additional small causes stage and MACP Bangalore have preferred this appeal. The appellants were claimants 1 to 3 in 1 to 3 and respondents 1 and response were respondent number 1 and 2 in MEC number 4710 of 2014 before the tribunal. For the purpose of convenience, the parties are referred to henceforth according to the ranks before the tribunal. On Prasad. It was alleged that on L1/7/2014 at 3 AM when deceased Chandra Mohan was traveling in car bearing number K01 MJ878. Prasad, no? They had shown Prasad as the driver of the car. No? Prasad Rajgopal, the driver of the car, drove the same in high speed and rashly and negligently so as to endanger the human life. Resultantly, the car turtled and fell in the roadside ditch. In the accident, Chandra Mohan suffered grievous injuries. And died. Claimants are the wife, minor son, and father of Chandra Mohan. They filed MEC number 4710 of at the time of the accident, respondent number 1 and 2 were the registered owner and insurer of car number K01 MJ0878. The claimants filed MEC number 4710 of 2014 against the respondents, alleging that the accident and the death of Chandra Mohan occurred due to actionable negligence on the part of car driver Prasad. They further claim that that deceased income ಈ ಕೇಸಲ್ಲಿ ಅವರು ಇದನ್ನು ಕನ್ಸಿಡರೇ ಮಾಡಲಿಲ್ಲ, ಕ್ವಾಂಟಮ್ ಕನ್ಸಿಡರೇ ಮಾಡಲಿಲ್ಲ. The deceased was running or working in the bar?
Running bar.
No, my lord, the bar
contention ಏನು ಅಂತ.
He was looking at
belongs to the
father.
Father of the deceased. Father of the deceased.
car.
ಅಲ್ಲ IT returns, bank accounts.
bar. ಅಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳಿದ್ದಾರೆ ಅಂತ.
He was just managing the bar.
Running a bar and restaurant.
ಅಲ್ಲ ಏನ್ ಹೇಳಿದ್ದಾರೆ, ನಾವು ಕಂಟೆನ್ಷನ್ ಹೇಳ್ತಾ ಇದೀವ್ರಿ. ಅಲ್ಲ, he had owned a bar and restaurant in his father's name ಅಂತ ಹೇಳಿದ್ದಾರೆ. They contended that deceased was running a bar and restaurant in his father's name and earning rupees 50,000 per month, and they were dependent on his income. They further contended that due to his untimely death, they have suffered damages to the tune of rupees 75 lakhs, and respondents are liable to compensate the same. Deceased mother, deceased's mother Padma is also the RC owner. Respondent is the owner of the, is the mother also.
Mother of this.
Mother.
Mother.
ಹೌದು.
Car belongs to the mother, respondent number 1.
ಏನಂತ ತಿಳ್ಕೊಂಡ್ರಿ? 11. Okay. Respondent. Respondent number 1 did, respondent number 1 none else but the mother of the deceased. She did not contest. And she contested, she has conceded. She conceded for allowing the petition. ನೋಡಿ ಇಲ್ಲಿ ಹಾಗಿದೆ ಜಡ್ಜ್ಮೆಂಟ್. ಇಲ್ಲ ಎಕ್ಸ್ಪರ್ಟ್ ಅಂತ ಹೇಳ್ತಾರೆ, ಒಂದ್ ಕಡೆ ಹಾಗೆ ಹೇಳ್ತಾರೆ, ಒಂದ್ ಕಡೆ ಸರಿ ಸರಿ. She did not contest the petition. Respond number 2 in other way conceding. Respond number 2 contested the petition, denying the occurrence of the accident due to the actionable negligence on the part of one Prasad in driving the car. The respondent number 2 contended that it was the deceased himself who was driving the car without possessing a valid and effective driving license. They further contended that respond number 1, the mother of the deceased had entrusted the car to the deceased who was not holding a license. Therefore, it is not liable to pay any compensation. Of course, the age, income, etc. of the deceased were also disputed. In support of the claim, claimant number 1 got examined herself as PW1. One Ravi Kumar, PG, PW2 was examined as a complaint from eyewitness. Eyewitness. Ravi Kumar, no, complainant was also himself was the complainant. Ravi Kumar himself was the complainant.
Complainant, please. Himself was a complainant.
Yeah, for the claimants, exhibit P1 to P12 were marked. She is insurance, police officer, who are RW 1 and 2?
RW. Insurance officers.
RW1 is
ಅಲ್ಲ ಅವರು ಒಬ್ರು ಡಾಕ್ಟರ್ ಇದ್ರು, ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ
surgeon government hospital
ಯಾರು? ಡಾಕ್ಟರ್ HB ಗುರುಪ್ರಸಾದ್ is surgeon.
Dr. Guruprasad alla madam.
Just they have produced.
He is a company official.
Adi Manish is company general. ಇನ್ನೊಬ್ರು ಯಾರೋ ಒಬ್ರು ಇವ್ರು ಇದ್ದಂಗಿದ್ದಾರೆ ಈ ಕೇಸ್ ಅಲ್ಲ.
Just they have produced documents.
ಇದು ಡಾಕ್ಟರ್ ಇಲ್ಲ, HB ಗುರುಪ್ರಸಾದ್ ಅವರು
HB Guruprasad is a company official.
ಇವ್ರು ಇರ್ತಾರಲ್ಲ, PhD ಡಾಕ್ಟರ್ ಅವರಿದ್ರು ಇರ್ಬೋದು. ಇಲ್ಲಿ ಬರ್ದಿಲ್ಲ, ಮುಂದೆ ಡಿಪೋಷನ್ ತೆಗೀರಿದ್ರು, ಇವ್ರು ಬರ್ದಿರ್ತಾರೆ.
ಅದು ಬೈ ಮಿಸ್ಟೇಕ್ ಡಾಕ್ಟರ್ ಅಂತ ಬಂದೈತಿ. Typographical mistake.
ಇಲ್ಲಲ್ಲ, ಕರೆಕ್ಟ್. On behalf of respondent number 2, RW 1 and 2 were examined and exhibit R1 to R4 were marked. MLC register extract ನಲ್ಲಿ ಏನಿದೆ ಪ್ರಸಾದ್ ಅಂತ ಅವ್ರು ಹೊಂದಿದ್ರೆ ಅವ್ರಿಗೂ ಇಂಜುರೀಸ್ ಆಗ್ಬೇಕಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. ಎಕ್ಸಿಬಿಟ್ R1 ತೆಗೀರಿ. The tribunal on hearing the parties by the include award. ಯಾರು? ಪ್ರಸಾದ್ ಅಂತ. ಅವ್ರನ್ನ ಇವ್ರು ಎಕ್ಸಾಮಿನೇ ಮಾಡಿಲ್ಲ, ಪ್ರಸಾದ್ ಅಲ್ಲ. ಇನ್ನೊಬ್ರು ಯಾರು? R1 ಅಲ್ಲಿ ಇಬ್ಬರದಿದೆ. 2 injuries. MLC pertaining to 2 persons ಅಲ್ವಾ? ಎಕ್ಸಿಬಿಟ್ R1 ಅಲ್ಲಿರೋದು.
ಹೌದು. Deepu and
related to only Prasad.
Prasad and Deepu.
Prasad and Deepa.
ಇನ್ನೊಬ್ರದ್ದು ಇರ್ತದ್ರಲ್ಲ.
Deepu.
Deepu ಇದ್ರಲ್ಲಿ ಇವ್ರದ್ದು ಯಾಕೆ ನೀವು ರಿಲೈ ಆದ್ರೆ ವಿತ್ ಹಿಸ್ಟ್ರಿ ಆಫ್
ಅವ್ರು ಬೇರೆ ಹಾಸ್ಪಿಟಲ್ ಅಡ್ಮಿಟ್ ಆಗಿದ್ರು.
ಅಲ್ಲ ಅವ್ರಿಗೆ ಇಂಜುರಿ
ಅವ್ರಿಬ್ಬರಿಗೂ ಆಗಿತ್ತು, ಪ್ರಸಾದ್ ದೀಪು.
ಮುಂದಿನ ಸೀಟ್ ನಲ್ಲಿ ಕುತ್ಕೊಂಡಿದ್ರು ಹಿಂಗೆಲ್ಲ ಹೇಳ್ತಾ ಇರ್ಬೋದು ಅದ್ರ ಸಲುವಾಗಿ held that the claimants have failed to prove that the car was being driven by Prasad as alleged. ಅಷ್ಟೆಲ್ಲ ಬೇಕಿರ್ಲಿಲ್ಲ. And the evidence on record. Prasad was driving the car. And PW2 was inmate of the car and the eyewitness. The tribunal ನಿಮ್ದು ನಂಬಿಲ್ವಾ ಅವರು? authors of R1 to 4 are not examined ಅಂತ ಹೇಳ್ತಾರೆ. Ultimately held that the claimants have failed to prove the occurrence of the accident as held, as alleged. And accidental death of
Chandramohan Reddy.
Chandramohan and dismiss the claim petition. But the said award is challenged in the above appeal by the claimants. Shri Gopal Krishna, now counsel, submits that on investigation, the police have filed the charge sheet against Prasad, and PW2 was the complainant eyewitness. The charge sheet was not challenged by Prasad, and respondents did not examine the said Prasad. He further submits that under such circumstances, the response did not rebut the aforesaid evidence. Therefore, the tribunal was in gross error in holding that the accident as alleged was not proved and dismissing the claim petition. Citations per contra, no citations ಇದೆ. ನೀವು ಇದು ಮಂಗಲ್ರಾಮ್ ನೀವೇ ರಿಲೈ ಆಗಿದ್ದ?
ಹೌದೌದು.
In support of his submission, he relies on the following judgment of the Supreme Court. Mangalram versus Oriental Insurance Company Limited and others. 2018 5 SCC 656. ಅದು ಎರಡು ಜಜ್ಮೆಂಟ್ ಆಗಿರಿ ನಮ್ಮ ಹೈಕೋರ್ಟಿಂದ ಜಸ್ಟಿಸ್ ಎನ್ ಕುಮಾರ್ ಅವ್ರದ್ದು. Per contra, Shri Betsur Leonard Counsel for respondent to submits that ಇಲ್ಲೇನೇ ಇತ್ತ ಕಂಪ್ಲೇಂಟ್ ಫೈಲ್ ಮಾಡೋದ್ರಲ್ಲಿ respondent number 1 is none else but the mother of the deceased, and Prasad was the friend of the deceased. If really the accident occurred due to his if really he was driving the car, the claimants could have examined him. It is further submitted that the charge sheet is not the conclusive proof of the occurrence of the accident as alleged, and the claimants have to probabilize their case. Then only burden shifts to the respondents to rebut such evidence. he submits that even otherwise, the evidence of RW1 and examine ಮಾಡಿದ್ದಾರೆ. Exhibit R1, the MLC register extract relating to Prasad shows that Prasad was traveling in the car and he was not the driver of the car. Therefore, thereby the respondents got response rebutted the evidence adduced by the claimants. Therefore, they are to have examined the said Prasad. He submits that the case was a clear collusion between the claimants, respond number 1, and charge sheet and other records were got manipulated at the behest of the claimants and respond number 1. NCC dismissal of the appeal. Next part. On hearing submission of both sides and examining the material on record, the question that arises for the consideration of the court are, number 1, whether the finding of the tribunal that the claimants failed to prove that the claimant, Chandra Mohan Reddy suffered accidental injuries leading to his death due to the actionable negligence on the part of one Prasad in driving car number K01MJ0878 is sustainable. Next. Regarding question if so, if so, what would be the compensation payable to the claimants? Next. Regarding point number 1, the parties are not yet dispute that claimant number 1 is the wife, 2 is the son, and 3 is the father. Respond number 1 is the mother of deceased Chandra Mohan Reddy. Mohan. It's also not disputed that on 11/7/2014 at 3 a.m. The car bearing registration number K01MJ0878 met with an accident near Buruzina Rappa Gate on Hiriyur Chitradurga NH4 and in the accident Chandra Mohan Reddy died and ಯಾರು ಪ್ರಸಾದ್ ಅಂಡ್ ದೀಪು ಅವರಿಬ್ಬರೇ ಹಾಕಿದ ಇಂಜುರೀಸ್ ಆಗಿರೋದು
Suffered injuries.
Prasad and
Suffered
Deepu, his wife, sustained injuries.
Wife
He
alla.
was sitting in the back seat.
Friend. And PWT also suffered minor injuries.
ನಾನು ಪ್ರಸಾದ್ ದೀಪು ಚಂದ್ರ ಮೋಹನ್ ರೆಡ್ಡಿ ಇವನ್ ಚಿತ್ರದುರ್ಗ his address was ಚಿತ್ರದುರ್ಗ ಅಲ್ಲ ಇದು
That is by mistake that I have given.
ರವಿಕುಮಾರ್
ಅಲ್ಲ wrong ಆಗಿದೆ.
It is not true that the burden of proving the fact that the said car was being driven by Prasad and he caused the accident and death of Chandra Mohan Reddy was on the claimants, but initial burden.
In fact, they have paid the one damage, my lord, accepting Prasad was the driver anta. Car one damage ಕೊಟ್ಟಿದ್ದಾರೆ.
Number 667. 667.
Paragraph 20 and Paragraph 20.
It is not true that in ಅದು ಬೇರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅನ್ನ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ
ಪ್ಯಾರಾ 20 ಅಲ್ಲಿ ಇದರಲ್ಲಿ
ಅಲ್ಲಿ ಅಲ್ಟಿಮೇಟ್ಲಿ ಇಟ್ ಇಸ್ ನಾಟ್ ಟ್ರೂ ದಟ್ ನಾನು ಏನೋ ನಾನು ಮಾರ್ಕ್ ಮಾಡಿದೆ ಇನ್ವಾಲ್ವ್ಮೆಂಟ್ ಆಫ್ ಡಿಸ್ ಇಟ್ ಇಸ್ ನಾಟ್ ಟ್ರೂ ದಟ್ ಇನ್ ಪ್ಯಾರಾ
20 ಅಲ್ಲಿ
case, the Honorable Supreme Court held that in the proceedings under section 166 of the Motor Vehicles Act, claimants were to merely establish their case on the touchstone of preponderance of probability, and the standard of proof beyond reasonable doubt cannot be applied by the tribunal while dealing such cases. But in the very next paragraph, it was stated that the reading of the next paragraph of the said judgment shows that such position prevails where filing of the complaint was not disputed. Further, more stringent than in criminal case. Claimant's eyewitness was discarded by the tribunal and the respondent in that case was acquitted in the criminal case concerning that. It cannot really prevent upon investigation. Oh, right. Therefore, in this case, it has to be examined whether the filing of complaint by PW2 and he being the inmate of the car / eyewitness was established even on the touchstone of preponderance of probability. Admittedly, PW1 was not the eyewitness to the incident. PW2 claims that he was the inmate of the car, but there is nothing to show that injuries ಆಗಿದ್ರ ಬಗ್ಗೆ ಅವರೇನು ಹೇಳಿದ್ದಾರೆ RW2
ಇಲ್ಲ ಮೈನರ್ ಇಂಜುರೀಸ್ ಆಗಿದೆ ಅಂತ ಹೇಳಿದಾರೆ
ಅಲ್ಲ ಅವ್ರದೇನು ಇದನ್ನ ಹಾಕಿದೀರಾ
ಇಲ್ಲ
MLC ಏನಾದರೂ ಹಾಕಿದೀರಾ
ಇಲ್ಲ ಮೈನರ್ಸ್ ಇಂಜುರಿ ಆಗಿ ಇಲ್ಲ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ವಾಸ್ ರೆಕಾರ್ಡ್ ಇನ್ ದ ಹಾಸ್ಪಿಟಲ್ ಇಟ್ಸೆಲ್ಫ್
ಏನಾದರೂ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದೀರಾ ಅವ್ರದ್ದು
ಇಲ್ಲ ಅವಂದೇನು ಮಾಡಿಲ್ಲ ಬಟ್ ಈ ಸ್ಟೇಟ್ಮೆಂಟ್ ವಾಸ್ ರೆಕಾರ್ಡ್ ಇನ್ ದ ಹಾಸ್ಪಿಟಲ್ ಇಟ್ಸೆಲ್ಫ್ ಬೈ ದಿ ಪೊಲೀಸ್
ಕರೆಕ್ಟ್ ಮೈನರ್ ಇಂಜುರಿ ಆದ್ರೂ
on statement to police recorded his statement in the hospital SST hospital ದಾವಣಗೆರೆ
ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲ ಇವ್ರೆ ನಾವು ಕೇಳ್ತಿರೋದಕ್ಕೆ ನೇರವಾಗಿ ಹೇಳಿ ಅವ್ರದ್ದು ಏನಾದರೂ
ಇಲ್ಲ ಅವರದೇನು ಹಾಕಿಲ್ಲ ನಾವು
MLC ನ ಏನಾದರೂ ಹಾಕಿದೀರಾ
ಇಲ್ಲ ಅವರದೇನು ಹಾಕಿಲ್ಲ
there is no mention PW eyewitness PW2 who claims to be the complainant and the inmate of the car / eyewitness in his cross-examination he claimed that he was sitting in the car and he also suffered injuries, but nothing was produced to show that, nothing like MLC register extract or own certificate were produced to show that he had suffered the injuries. ಎಲ್ಲ ಚಿತ್ರದುರ್ಗದವರು ಅಂತ ಒಪ್ಕೊಂಡಿದ್ದಾರಲ್ಲ. From where it has come. PW2 in his cross-examination admits that I have no treatment on record on that. Admits that he has no records to show that he has taken treatment in any hospital, though he claims that he has suffered minor injuries. He further admits that in the charge sheet, his address is shown as resident of Chitradurga. Then why and how he boarded the car from Bangalore should have been proved. He claims that he sat beside the driver and Prasad was the driver, but in exhibit R1, the exhibit R1, the MLC register extract produced and spoken to by RW1 states that Prasad gave the history of RTA while he was traveling in a car from Bangalore to Goa. Then skidded a got top size one. Therefore, it was incumbent on the claimants to prove, to examine the said Prasad, who was allegedly the friend of the deceased himself. If Chandramohan Magalki ಕೊಂತಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ. In the coordinate bench of this court in the judgment in Veerappa and another versus Siddhappa and another, taking judicial note of the rampant malpractices in ಇದೆಲ್ಲ ನಾನು ಅಂಡರ್ಲೈನ್ ಮಾಡಿಟ್ಟಿದ್ದೆ ಆನ್ಸರ್ ಏನಂತಂದ್ರೆ ಟೇಕಿಂಗ್ ಜುಡಿಷಿಯಲ್ ನೋಟ್ ಆಫ್ filing claim petitions to make wrongful gain from planting vehicles from the insurance companies. In para 16 of the judgment held as follows. It was held that while on making such observations, it was held that the charge sheet is not the conclusive proof of the occurrence of the accident in the manner alleged, and the claimants have to prove their case. ಇನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ ಅಲ್ಲದ್ರ ಮುಂದೆ ಇದು ರಿಪೋರ್ಟಬಲ್ ಅಂತಾನೆ ಇದೆ. This the aforesaid view was further reiterated by another coordinate bench of this court in the judgment in Mahadevi and others versus Shivputra and another. ಇದನ್ನ ನೋಡಿ ಇದು ರಿಪೋರ್ಟ್ ಇದ್ರೆ ನೋಡಿ ನಮ್ಗೆ in para 15 of the judgment, it was held that the initial burden of proving the accident is on the claimants. If the charge sheet is found to be deficient in truth, to tip the balance, to the balance, the claimants are required to adduce satisfactory evidence. Satisfactory. In this case, as already stated, the claimants and respond number 1 are the close relatives of deceased Chandra Mohan Reddy, and respond number 1 is the owner of the vehicle. She did not, respond number 1 did not choose to choose to contest the petition, nor examined, Claimant and respond number 1 did not choose to examine Prasad, and exhibit R1 goes contrary to their contention that goes contrary to the their evidence that Prasad was the driver of the car. So far as evidence of PW2, the reading of the judgment in CC number 569 of 2014 passed by the jurisdictional magistrate shows that he, before the criminal court, he did not support his complaint. Reading of para 14 of the said judgment shows that he disowned the complaint filed by him against Prasad. It was further held that he did not depose anything PW1 and exert, anything before the criminal court about Prasad being the driver of the car. Para 19 of the said judgment shows that nowhere in his evidence he stated that he has witnessed the accident in question. Therefore, his evidence was very PW3. I'm sorry. PW3 is very Ravi Kumar. That is not with reference to this evidence. Para number 19. PW3 is not this witness. The complaint P1 complaint. Magistrate court in ತಂದು ಹಾಕಿದ್ರೆ ಗೊತ್ತಾಗುತ್ತೆ, ಇಲ್ಲಾಂದ್ರೆ ಗೊತ್ತಾಗೋದಿಲ್ಲ. That tribunal on judicious appreciation of the evidence and record and by supplying sound reasonings held that the claimants have failed to prove that the car in question was being driven by Prasad as alleged, and accident occurred due to his actionable negligence. Whereas the defense of respondent number 2, that deceased himself was the driver of the car and accident occurred due to his own negligence, is probabilized. The tribunal was also justified in holding that PW2 being in the car and the eyewitness was doubtful. There are no grounds to, by no stretch of imagination, the finding of the tribunal that the claimants failed to prove the occurrence of the accident and death of Chandra Mohan due to actionable negligence on the part of one Prasad in driving car number K01MJ0878. Is not proved. That there are no grounds to interfere with the tribunal's order, interfere with the said finding of the tribunal. When the occurrence of the accident as alleged itself is not proved, the question of awarding regarding point number 2, awarding compensation to the claimants does not survive. Therefore,
Sona Vakkun.
For respondents, my lord, senior is appearing online.
Sir.
Not appearing. You are for the respondent.
Respondents.
Appellant illa. ಕಾಣ್ತಾ ಇದ್ದಾರೆ ಅವಾಗಿದ್ರು ಒಪ್ಪಂದವ್ರು. Yes, when will you have it? Some other day?
Another day, Lordship.
As requested, 21st ಆದ್ಮೇಲೆ ಹಾಕೋದು.
Lordships, anytime after 28, your Lordships.
Any time after?
28.
28, as requested. 3.
My lord, in first week of March, my lord.
3.
Very well.
Dismissal, seal number 44. Dismissal. Sheshgiri Rao.
For the appellant in this matter, my lord. Lordship, process pay ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಪೇ ಮಾಡಿದಿರಿ?
ಇವತ್ತು ಫೈಲ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
ಇವತ್ತು ಅಲ್ಲಿ ಹೇಳಿದ್ದು ಅಷ್ಟು ಟೈಮಲ್ಲಿ ಮಾಡಿದ್ರ? This is on 29/1. 1 week time was granted.
Yes, my lord. Sorry, my lordship.
Preemptory order dated 29/1/2025 is not complied. Therefore, appeal already stood dismissed. No further orders.
Lordship, please, my lordship, ಒಂದು ಡೇಟ್ ಫಿಕ್ಸ್ ಆಗಲಿ. ಇದು process ಫೈಲ್ ಮಾಡಿದೀನಿ ಸ್ವಾಮಿ.
ಬರೀ ಅಲ್ಲಿ
ಅಲ್ಲ lordship, please, my lordship.
Have you filed any application for recalling that order?
Before DNP ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಪಾರ್ಟಿಯಿಂದ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇರಲಿಲ್ಲ.
ಕರೆಕ್ಟ್. ಇವತ್ತು ನೀವೇನು ಪ್ರೊಸೆಸ್ ಕೊಟ್ಟು ಅವಾಗ ರಿಕಾಲಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಂದೇ ಒಂದ್ಸತಿ. Lordship, please, my lordship, next date.
For final disposal, seal number 45. Vijay Kumar, Nayak Krishna Venkataraman.
Lordship, ಅದರಲ್ಲಿ ಒಂದು ಸಬ್ಮಿಷನ್ ಇದೆ ಸ್ವಾಮಿ.
No submissions. Your submissions are rejected now. Yes.
For the appellant.
I appear for response.
Serial number ಎಷ್ಟು?
45.
45. Single matter. Withdrawal of the amount. ಏನಿದ್ರಲ್ಲಿ what is the point involved?
My lord, the question of negligence, my lord. 3 vehicles are involved in the accident.
3 vehicles are
3 vehicles are involved in.
ಟೈಮ್ ತಗೊಳ್ತೀರಾ ಇಬ್ರು ಸೇರಿ?
ನಾನು ಒಂದು half an hour ಬೇಕು.
ನಿಮಗೆ ಎಷ್ಟು ಬೇಕು?
ನಂಗೊಂದು 5 ನಿಮಿಷ.
ನಿಮಗೆ ಎಷ್ಟು ಬೇಕು?
ಅವರಿಬ್ಬರು ಡಿಸ್ಪ್ಯೂಟ್ ಇಂಟರ್ಸ್ಟೇಟ್ ಡಿಸ್ಪ್ಯೂಟ್ ಮೇಲೆ
ಇನ್ಶೂರೆನ್ಸ್
ಕಂಪನಿ
ಹೌದು.
ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಂಡ್ ಆಲ್ಸೋ
ಕೊಟ್ಟರು ನಿಮಗೆ
ಅಷ್ಟೇ.
So far as I'm the insurer of the car, so far as our liability is concerned, we have admitted and we have satisfied the award to the extent of 50%.
My lord, tribunal has fixed 50% negligence on the part of the driver of the bus. Actually, my lord, there cannot be any negligence on.
ನೀವು ಯಾವ
The-
ಕೆಲಸ ಎಲ್ಲ ಒಪ್ಕೊಳ್ತೀರಾ?
ಅಲ್ಲ ಸ್ವಲ್ಪ ಫ್ಯಾಕ್ಟ್ ಈಸ್ ಲೈಕ್ ದಟ್.
ರೈಟ್, ಬಟ್ ಇವತ್ತು ಬೇಡ.
Please, my lord.
Tomorrow onwards, 2 days afternoon, we may not be able to take up these final hearing matters
Please.
also, because some administrative work is entrusted to us. ಅದಕ್ಕೆ ಒಂದು ವಾರದಲ್ಲಂತೂ ಇದು ಆಗೋದಿಲ್ಲ.
Please, my lord.
21st. Wednesday, Thursday.
Next Wednesday. 20th.
2022
20?
payment ಆಗಿಲ್ಲ ಅದು.
20th.
20th, okay.
21st ಆದ್ಮೇಲೆ ಹಾಕ್ಬಿಡಿ.
ಇದೆಲ್ಲ ನಾನು ಒಂದು ಅಪ್ಲಿಕೇಶನ್
25th
ಹಾಕಿದ್ದೀನಿ.
ಬೇಡಿ.
ನಮ್ಗೆ ಏನೋ ಸ್ವಲ್ಪ ಬೇರೆ
ಆಯ್ತು.
27th ಆಗ್ಬೋದು, 28th ಆಗ್ಬೋದು.
self and ನನಗಿಂತ ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಆಗ್ಬೋದು.
ಎಲ್ಲ ಕಡೆನೂ ನಾಳೆಯಿಂದ ಬಹುಶಃ ಆಫ್ಟರ್ನೂನ್ ಸಿಟ್ಟಿಂಗ್
Please.
ಆಗ್ಬೋದು.
Malad, after 27th.
27th ಆಗ್ಬೋದಾ?
27th.
Much obliged.
I see one the last matter of fact. Sixth. Number 60.
ಅವ್ರು ಯಾರೋ ಒಂದು ಅರ್ಜೆಂಟ್ ಅಂತಿದ್ರು. ಯು ಆರ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್. ನಿಮ್ದು 2022 ಒಂದು ನಮಗೆ ವಿಲ್ ನಾಟ್ ಬಿ ಏಬಲ್ ಟು ಟೇಕ್ ಅಪ್ ಅಂತ ಹೇಳಿದ್ವಿ, ಬಟ್ ಸ್ಟಿಲ್ ಯುವರ್ ಕ್ಲೈಂಟ್ ಸೆಡ್ ವಾಂಟ್ಸ್ ಟು ಗೆಟ್ ಯು. ಬಟ್ really strong.
And the marriage has irrevocably broken.
ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಇವಾಗ ಆಗೋದಿಲ್ಲ, 21st ವರೆಗೂ ನಮ್ಗೆ ಆಗೋದಿಲ್ಲ.
25th.
25th.
On the last occasion also I argued for 5-10 minutes.
We said we already indicated to the other council, we have some difficulty up to 21st for that.
Serial number 52, it may be, date may be fixed. Serial number 50.
Date fix ಮಾಡಿದ್ದೀವಿ 52. ಏನದು ವಾಟ್ ಇಸ್ 52
list after 2 weeks.
Date may be fixed.
ಇಲ್ಲ ಆಗೋದಿಲ್ಲ, ನಿಮ್ದಾದ್ರೆ 2000
Not so only daughter succumbed to death. Not say her husband also expert. Only single lady is available. She wants to see the light of the case.
ಅಮೌಂಟ್ ತಗೊಂಡಿದ್ದೀರಾ ಇಲ್ವೋ?
ಇಲ್ಲ sir.
ರಿಲೀಸ್ ಆಗೇ ಇಲ್ವಾ?
ಇಲ್ಲ.
ಯಾಕಾಗಿಲ್ಲ?
ತಗೊಂಡಿಲ್ಲ sir.
ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಾ?
ಅಲ್ಲ because
ರಿಲೀಸ್ ಬೈ KSRTC.
please your honor.
ಆದ್ರೆ ರೇಣುಕಾ ಹಾಗೆ ಇದು ಮಾಡ್ತಿರೋದು.
Date may be fixed.
ನೀವೇನಾದ್ರೂ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರಾ ಪೇಮೆಂಟ್ಗೆ?
ಇಲ್ಲ sir.
ಮತ್ತೆ 2018ರಿಂದ ನೀವು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೊಂಡಿದ್ದೀರಾ, ಇದೆಲ್ಲ ಇದೆ ಅಂತ ಹೇಳ್ತೀರಾ?
Date may be fixed your honor.
2 weeks ಆದ್ಮೇಲೆ ಒಂದು ಯಾವ್ದಾದ್ರು ಡೇಟ್ ರಿಕ್ವೆಸ್ಟ್.
Please your honor.
5-3.
Date for the.
ಮೇಡಮ್ ಏನು ಎದ್ದೋಗ್ಬಿಟ್ರ? ಹೌದು ಮೇಡಮ್ 55 ಡೇಟ್ ಯಾವಾಗ ಕೊಡ್ತೀರ? 55. ಏನು ಇವತ್ತು ಎದ್ದೋಗಿದ್ದಾರೆ? ಬಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ? ಮೇಡಮ್ ಎಲ್ಲ ಕ್ಲೋಸ್ ಮಾಡ್ಬಿಟ್ರು ಅಂತ ಕಾಣುತ್ತೆ.
ಯಾವ್ದಾದ್ರು ಸೀರಿಯಲ್ ನಂಬರ್ ನಾನು ಹೇಳಿದ್ದು ಒಂದು ಸ್ಟಾರ್ಟಿಂಗ್ ಅವಾಗ ಹೇಳಿರ್ತೀನಿ, ಅವಾಗ ಎಲ್ಲದಕ್ಕೂ
ಕೊಡಮ್ ಸರ್.
ಸರ್ ಹೇಳಿ.
ಮೇಡಮ್ 55 55
2 weeks.
55
2 weeks, sir.
2 weeks. 2 weeks ಅಂತೆ.
ಸರ್ 2 weeks.
ಡೇಟ್ ಕೊಡಿ.
ಇಲ್ಲ
ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್.
ಇಲ್ಲ ಸರ್, ಡೇಟ್ ಇವಾಗ ಕೊಡಲ್ಲ.
ಆಮೇಲೆ
ಮೇಡಮ್ 2 ದಿನ 3 ದಿನ ಅವ್ರಿಗೇನೋ ಬೇರೆ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟಿವ್ ವರ್ಕ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಸೊ ಮಧ್ಯಾಹ್ನದ ಹೊತ್ತಿರಲ್ಲ ಸಿಟ್ಟಿಂಗು.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಮೇಡಮ್.
49 2 weeks ಸರ್.
2 weeks.
Yes sir.